Parliament may by law prescribe a. The circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under a law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4. B. The maximum period for which a person may, in a class or classes of cases, be detained under a law providing for preventive detention, and C. The procedure to be followed by an advisory board in an inquiry under subclause A of clause 4, article 22, 7, A, B, C. 3. Right against exploitation. 1. Traffic in human beings and beggary and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law, article 23, 1. 2. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service the state shall not make any discrimination on grounds of religion, race, caste, or class, or any of them. Article 23, 2. 3. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Article 24. 4. Right to freedom of religion. 1. Subject to public order, morality, and health and other provisions of this part, all persons are equally entitled to freedom of conscience and the right to profess, practice, and propagate religion. Article 25, 1. 2. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. A. Regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. B. Providing for social welfare and reform or the throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. Article 25, 2a, b. Subject to public order, morality, and health, every religious denomination or section thereof shall have the right a. To establish and maintain institutions for religious and charitable purposes. B. To manage its own affairs in matters of religion. C. To own and acquire movable and immovable property, and D. To administer such property in accordance with the law. Article 26. No person shall be compelled to pay a tax, the proceeds of which are specifically appropriated for payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Article 27. 1. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. Article 28, 23. 2. Nothing in Clause 1 shall apply to an educational institution which is administered by the state but has been established under an endowment or trust which requires that religious instruction shall be imparted in such an institution. Article 28. 2. 3. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such an institution or in premises attached thereto unless such person, or if such person is a minor, his guardian has given his consent thereto. Article 28, 3. 5. Cultural and educational rights. 1. Any section of citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. Article 29, 1. 2. No citizen shall be denied admission to any educational institution maintained by the state or receiving aid out of state funds on grounds of religion, race, caste, language, or any of them. Article 29, 2. Rights of minorities to establish and administer educational institutions. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Article 30, 1. 2. In making a law providing for the compulsory acquisition of property of an educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under the clause. Article 30, 1a. 3. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Article 32. 6. Right to constitutional remedies. 1. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Article 3. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Article 32, 1. 2. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate, for the enforcement of the rights conferred by this part. Article 32, 1. Writ jurisdiction. The Supreme Court under Article 32 and High Courts under Article 226 have the power to issue writs, though the Parliament can empower any other court to issue writs as well. The writ jurisdiction of the Supreme Court and High Courts differ. Whereas the Supreme Court issues writs for the enforcement of the fundamental rights, the High Courts do it for the enforcement of the fundamental rights as well as for other purposes. 2. The Supreme Court's jurisdiction of writs covers the whole country and that of the High Courts to their respective territorial areas. The types of writs are 3. Habeas corpus, literally from Latin term, it means to have the body of. This writ can be issued against both public authorities and individuals. It is not issued where a. the detention is lawful, b. the proceedings are for contempt of a legislature or a court, c. the detention is by a competent court, and d. the detention is outside the jurisdiction of the court. 4. Mandamus, literally it means we command. This writ is issued a. against a private individual or a body, b. to enforce departmental instruction that does not possess statutory force, c. when the duty is discretionary and not mandatory, d. to enforce a contractual obligation, e. against the President of India or state governors, and f. against the Chief Justice of a High Court acting in judicial capacity. v. Prohibition, literally it means to forbid. This writ can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. 6. Certiorari, literally it means to be certified or to be informed. It is issued by a higher court to a lower court or a tribunal or to an administrative authority since 1991, either to transfer on the ground of excessive jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. 7. Qua warranto, literally it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. B. Fundamental rights analysis. Fundamental rights guaranteed to citizens as incorporated in Part I of the Constitution constitute individual rights common to most people in liberal democracies. They are enforceable in a court of law, i.e., their violations result in punishments. These rights are not absolute, they are exercised within the framework of the provisions of the Constitution. They help us remove or reduce inequalities as witnessed in social practices, especially untouchability. They prohibit discrimination on grounds of religion, race, caste, sex, region, or place of birth. They forbid bonded labor and human trafficking. They protect and promote the interests of the minorities, religious, cultural, and ethnic. They guarantee us freedom as also the right to life and personal liberty. What is more is that they provide remedies, i.e., if they are violated, courts can be approached to protect and safeguard these rights. The fundamental rights are both natural as well as legal, natural in the sense that they are necessary for the promotion of our personality, legal in the sense that they are binding upon every government central, provincial, district, and local. The fundamental rights are both claim rights as well as liberty rights, claim rights in the sense that every citizen must be in a position to claim them. Rights are our claims on others' liberty rights in the sense that they assure us of certain liberties of thought, expression, assembly, association, movement, and vocation, and the like. The fundamental rights are both negative as well as positive. Negative in the sense that they enforce limitations on authorities, positive in the sense that they provide facilities and amenities to promote our interests. The fundamental rights are both individual as well as group rights. Individual rights because some rights relate to individuals such as equality, liberty, freedom of religion. Group rights because some of them relate to groups like religious, cultural, and ethnic minorities, these groups through which the people are able to protect and promote their interests. A general glance at Part I of the Constitution reveals a couple of salient features in our scheme of fundamental rights. Firstly, the fundamental rights have been projected as some kind of limitation on the powers of the legislature and the executive insofar as Article 13 forbids the state to make any law contrary to the provisions of Part I, and if it does so, such a law would be void. The article implicitly states that it would be for the courts to declare such a law void. Incidentally, the Supreme Court has been able to state its position clearly in cases like the Kesavananda Bharati and Minerva Mills. Secondly, the right to property, which was a fundamental right till the enactment of the 44th Amendment, 1978, has been converted into a legal right. Thirdly, the scope of operation of fundamental rights has been made limited by Article 31A, except laws providing for acquisition of estates, etc., Article 31B. Validation of certain acts and regulations included in the 9th Schedule, and Article 31C, except laws giving effect to certain directive principles. Fourthly, with the inclusion of fundamental duties, Part IVA has, in a way, minimized the emphasis which was laid on the fundamental rights. Indeed, the fundamental duties are not enforceable by the court, nor is their violation punishable. Yet a court can refuse to enforce a fundamental right of an individual who has patently violated the duties. Fifthly, the fundamental rights in the Indian Constitution have been, indeed, exhaustively stated. Each right has been enumerated in what it means as clearly as possible. Sixthly, the amendability of fundamental rights has been a contentious issue for a long time. The right of Parliament to amend the Constitution has been upheld by the judiciary, but the fundamental rights have also been made a part of the basic structure. Seventhly, the chapter on fundamental rights makes a distinction between citizens and persons. Though all citizens are persons, all persons are not citizens. For example, e.g., aliens are persons but they are not citizens. Article 14 uses the word person, equality before the law or equal protection of the law, but Article 15 uses the word citizen. The state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, or any of them. Eighthly, right to education has been made a part of fundamental rights under Article 21A. Ninthly, fundamental rights, except those in Articles 19, 20, and 21, can be suspended during the operation of national emergency. Tenthly, Article 35 states that a few rights, as in Clause 3 of Article 16, Clause 3 of Article 32, Articles 33 and 34, are enforceable by the law of Parliament and not of state legislatures. LL.C. Amendability of fundamental rights. Fundamental rights are enforceable. The courts have special responsibility to protect fundamental rights, which they perform by issuing writs. Though the fundamental rights, or some parts of them, can be suspended during periods of emergency under Articles 352 and 356, they can be amended by the Parliament. In the Shankari Prasad v. Union of India. 1951, the constitutional validity of the First Amendment, 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of Parliament to amend the Constitution under Article 368 also included the power to amend the fundamental rights. In the Goloknath v. State of Punjab, 1967, the Supreme Court held that the fundamental rights are immutable and hence the Parliament cannot abridge or take away any of the fundamental rights. Reacting to the 1967 case, the Parliament enacted the 24th Amendment, 1971, asserting that the Parliament can abridge or take away fundamental rights and that it has the power to amend the Constitution, including the fundamental rights. In the Kesavananda Bharati v. State of Kerala 1971 case, the Supreme Court upheld the validity of the 24th Amendment, saying that the Parliament can abridge or take away the fundamental rights by amending the Constitution. But the Apex Court ruled that the amending power of the Parliament does not enable it to alter the basic structure of the Constitution. The 4294 Amendment 1976 authorized the Parliament to amend any part of the Constitution and that no amendment could be questioned in any court. The Supreme Court in the Minerva Mills v. Union of India 1980 and the Vaman Rao 1981 cases adhere to the doctrine of basic structure as something out of the domain of Parliament, though the Parliament does possess the power of amending the Constitution. IL.D. The Court and Fundamental Rights. The courts, especially the Supreme Court and High Courts, have played significant role in protecting the fundamental rights of the people in India. Major cases decided by the Supreme Court and associated with fundamental rights are indeed important. As protector and guarantor of the fundamental rights of the people, the Supreme Court, as per a decision in Romesh Thaper v. State of Bombay, cannot refuse to entertain applications seeking protection against the infringement of such rights. Though the Parliament had reversed the Supreme Court's decision through 25th and 26th Amendments, 1971, the Apex Court had earlier invalidated the government's stand on bank nationalization and privy purses in Rustam Kavasji v. Union of India 1970 and Madhvarao Shivjirao Syendia v. Union of India 1971 cases declaring the government's actions against Articles 14, 19, 1, F, 19, 1, G, 31, 2, and 32. While in the Gopalan case 1950, the Supreme Court had held that the freedoms under Articles 19, 21, 22, and 31 are exclusive, it overturned its own stand in R.C. Cooper 1971 case, saying that the fundamental rights conferred by Part I are not distinct and mutually exclusive rights. In the Maneka Gandhi v. Union of India 1978 case, the Supreme Court declared that no one shall be deprived of personal liberty and the right to life except according to the procedure prescribed by the law with attributes found in Article 19. In Rudalsa v. State of Bihar 1983, the Supreme Court ruled that compensation for illegal detention should be granted under Article 32 without affecting the petitioner's right to sue for damages. In St. Stephen's College v. University of Delhi 1992 case, the Supreme Court held that the minority-aided educational institutions are entitled under Article 31 to accord preference in favor of or reserve seats for candidates belonging to their community to the maximum of 50% of annual admissions. In the D.K. Basa v. State of West Bengal 1997 case, the Supreme Court set a number of measures to be observed by the police while securing the arrest of a person so as to prevent the abuse of power by police authorities. In another case, Vishaka versus State of Rajasthan, 1997, the apex court set out guidelines for the protection of women from sexual harassment at workplaces. The refusal of the Bombay High Court to permit abortion of a 26-week pregnancy in the Nikita Haresh Mehta case amounts to right to life, though of an unborn child. Evaluation of fundamental rights. The fundamental rights granted in the Indian Constitution have been criticized as inadequate insofar as they do not provide sufficient freedom and opportunity to all citizens. The phrases such as security of state, public order, morality, and the like are not only unclear, but have wide implications. Likewise, words such as reasonable restrictions, the interest of public orders have not been explicitly stated. That is why it is often said that there are more limitations on fundamental rights than the rights conferred on the people. Though exhaustively stated, the chapter on fundamental rights does not contain a single right which can be termed as having social or economic content. Jennings objects to the legalistic language used in the chapter as lawyer's paradise beyond the comprehension of common man. Despite free legal aid, the whole legal procedure is so expensive that the people usually choose to stay away from courts. The freedom of press is slightly more than implicit. The employment of children in hazardous environments continues. Yet, it would be wrong to ignore the importance of fundamental rights. The fundamental rights have been very aptly described as the Magna Carta of liberties of the Indian people. They provide a check on the legislature and the executive. They protect the rights and interests of the people, the minorities in particular, UI. They help establish the rule of law and democratic system in the country, and thanks to judicial activism, the courts sometimes seem mightier than the state. Directive Principles of State Policy. Part 4 of the Constitution from Articles 36 to 51 contains directive principles of state policy. These provisions are, Article 37 says, not enforceable by a court but are regarded as fundamental to the governance of the country, and the state would do well in applying them in making laws. The directive principles as stated in the Constitution are 3. State to secure social order for the promotion of people's welfare. 1. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which social, economic, and political justice shall be an integral part of all institutions of the national life. Article 38, 1. 2. The state shall, in particular, strive to minimize inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among individuals but also among groups of people residing in different areas or engaged in different vocations. Article 38, 2. Certain principles of policy to be followed by the state. The state shall, in particular, direct its policy towards securing 1. That citizens men and women equally have the right to adequate means of livelihood. 2. That the ownership and control of material resources of the community are so distributed as to best subserve the common good. 3. That the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 4. That there is an equal pay for equal work for both men and women. 5. That the health and strength of workers, both men and women, and children of tender age are not abused, and that citizens are not forced by economic necessity to enter vocations not suited to their age or strength. 6. That children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and moral and material abandonment. Article 39. Equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or scheme or in any other way, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Article 39A. Organization of village panchayats. The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. Article 40. Right to work, to education, and to public assistance in certain cases. The state shall, within the limits of its economic capacity and development, make effective provi-science for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. Article 41. Provision for just and humane conditions of work and maternity relief. The state shall make provision for securing just and humane conditions of work and for maternity relief. Article 42. Living wage for workers. The state shall endeavor to secure, by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial, or others work, a living wage, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and, in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. Article 43. Participation of workers in management of industries. The state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishments, or other organizations engaged in any industry. Article 43A. Uniform Civil Code for Citizens. The state shall endeavor to secure for citizens a uniform civil code throughout the territory of India. Article 44. Provision for free and compulsory education for children. The state shall endeavor to provide, within a period of 10 years from the commencement of the Constitution, free and compulsory education for all children until they complete the age of 14 years. Article 45. Through 869 Amendment Act of 2002, the state is required to provide free and compulsory education to all children between the age of 6 and 14. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. The state shall promote with special care the educational and economic interests of the weaker sections of the people and, in particular, of the scheduled castes and the scheduled tribes, and shall protect them from social injustice and all forms of exploitation. Article 46. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties and, in particular, the state shall endeavor to bring about prohibition of the consumption except for medical purposes of intoxicating drinks and drugs which are injurious to health. Article 47. Organization of agriculture and animal husbandry. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draft cattle. Article 48. Protection and improvement of environment and safeguarding of forests and wildlife. The state shall, through 42-D Amendment 1976, endeavor to protect and improve the environment and the state shall, through 42-D Amendment 1976, endeavor to protect and improve the environment and safeguard forests and wildlife of the country. Article 48A. Protection of monuments and places and objects of national importance. It shall be the obligation of the state to protect every monument or place or object of artistic or historical interest declared by a law made by Parliament to be of national importance from spoiling, disfigurement, destruction, removal, disposal, or export or otherwise. Article 49. Separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in public services of the state. Article 50. Promotion of international peace and security. The state shall endeavor to 1. Promote international peace and security. 2. Maintain just and honorable relations between nations. 3. Foster respect for international law and treaty obligations in dealings with other peoples and 4. Encourage settlement of international disputes by arbitration. Article 51. Lil. B. Directive Principles. What the framers of the Constitution had intended. A Fundamental Rights Subcommittee was entrusted to frame fundamental rights as well as directive principles, both to be designated as fundamental rights. The subcommittee had numerous types of rights, social, political, economic, to select from. Having classified them into two categories, the subcommittee marked one category as enforceable in a court of law and the other as non-enforceable. Presumably the committee felt that the first category of right with somewhat political overtones could be legally enforced, while the second category of right could not, until they were realized. The framers of the Constitution did not find the two categories of rights as mutually opposed. In fact, they found them complementary to each other, putting the fundamental rights in the forefront and the directive principles in the waiting, with one to be enforced immediately and the other to be enforced as and when practicable. The intentions of the framers were to enlarge, as Markenden, Fundamental Rights vis-a-vis Directive Principles of State Policy says in the chapter on fundamental rights, by a progressive transfer to it from that part of the Constitution dealing with the directive principles. In fact, they thought of the fundamental rights and directive principles as equally important to the fundamental rights. The fundamental rights are fundamental because they are essential for the development of the individual's personality, but the directive principles are no less fundamental, and they are indeed regarded as so in the governance of the country. It is not that the framers thought of the directive principles as of no significance. Representing the socio-economic ideals and objectives of the people's aspirations, the directive principles were made non-justiciable till the time they could be made justiciable. This means that the courts, indeed, would not force the state to implement the directive principles, but they would not go against them. If they do, it amounts to going against the spirit of the Constitution as well. To this extent, the directive principles do enjoy judicial status as well. It is clear that the framers of the Constitution did not see any conflict between the fundamental rights and the directive principles, nor did they suggest the primacy of fundamental rights over the directive principles. The records of the Constituent Assembly that B.N. Rao suggested that as and when the two parts appear to come into conflict, the directive principles would prevail. Rao's suggestion in the form of an amendment was not accepted, but it certainly demonstrates the mood of that time. The framers of the Constitution thought of the fundamental rights and directive principles complementing each other, the former as the laws for the present and the latter as the laws of the future. Happily, the courts have settled down to the position that the directive principles do constitute relevance to fundamental rights. LOL. Directive principles, features. The idea of directive principles of state policy as part of the Constitution is not very old. The Constitution of the Principality of Liechtenstein, 1921, and that of the Spanish Republic, 1931, had references to some directives issued for the state. The framers of the Indian Constitution were impressed by the provisions relating to directive principles as stated in the Constitution of the Irish Free State, 1937. Dr. B.R. Ambedkar described directive principles as the novel feature of our Constitution, as they are, like the Instruments of Instructions of the Government of India Act, 1935, issued to the Governor-General by the British government. These are directives to the governments of the day to consider them fundamental while formulating the policies with regard to the administration of the country. Some of the features of these principles can be briefly summed up as under. 1. These principles are not justiciable. The government cannot be called to courts for not having implemented them. 2. They serve as guidelines while making laws for the people. They are like policies for the government, the national manifesto, irrespective of political party in power. 3. They are so comprehensive that they seek to build a socialist society. See Articles 38, 39, 39a, 41, 42, 43, 43a, and 47, a Gandhian India. See Articles 40, 43, 46, 47, and 48, and a liberal international state. See Articles 44, 45, 48, 48a, 49, 50, and 51. 4. They are positive as they require the government to do certain things. 5. They are social and economic in nature. The directive principles seek to establish social and economic democracy. 6. They are not enforceable, but they cannot be ignored either. Governments cannot make laws against them, and if they do, they can be declared violative of the Constitution. In this sense, the directive principles are enforceable. 7. They lay the foundation of economic democracy. 8. Ever since the directive principles of state policy were incorporated in the Constitution, certain new directive principles have been added. These are A. To secure opportunities for healthy development of children, Article 39. B. To promote equal justice and to provide free legal aid to the poor, Article 39a. C. To take steps to secure the participation of workers in the management of industries, Article 43a. D. To protect and improve the environment and to safeguard forests and wildlife, Article 48a. E. To minimize inequalities in income, status, facilities, and opportunities added in Article 38, 44th Amendment, 1978. F. To declare elementary education obligatory under Article 21, 86th Amendment, 2002. 9. Directive principles help supplement fundamental rights. They constitute the economic aspect of fundamental rights, its socio-economic aspect. 10. As they stand, fundamental rights and directive principles are distinct from each other. That is why they are often distinguished. The fundamental rights are enforceable by the court, whereas the directive principles are not enforceable in courts. The courts can issue writs so as to help protect the fundamental rights, whereas they cannot issue any writ to force the state to implement the directive principles. The fundamental rights are rights of the people, whereas the directive principles are not the rights but are the fundamental duties of the state to keep them in mind while formulating policies or making laws. The fundamental rights provide restrictions on the state. They are limitations on the powers of the state, whereas the directive principles are obligations the state is supposed to perform. The fundamental rights are, in their nature, both negative, seeking checks on the state, and positive, asking the state to provide certain facilities, while the directive principles are, in their nature, always positive, expecting the state to perform certain tasks. The fundamental rights lay the foundation of political democracy, whereas the directive principles, those of economic and social democracy. The directive principles usually conform to the chapter on fundamental rights. The fundamental rights are, by and large, individual-oriented, whereas the directive principles are, to a great extent, community-oriented. The fundamental rights have a liberal orientation, whereas the directive principles have a communitarian orientation. D. Fundamental rights and directive principles, their relative position. The question of attitudes of the judiciary, legislature, and executive with regard to fundamental rights and the directive principles has been a significant one. In cases such as Om Prakash versus State of Punjab, 1951, State of Madras versus Champakam Durarjan, 1951, and Jagwant Kaur versus State of Bombay, 1952, the courts held the view that the directive principles of state policy have to conform to and, in fact, run subsidiary to fundamental rights. In Fram Nusarwanji Balsara versus State of Bombay, 1951, Ajay Singh versus State of Punjab, 1952, and in Baswambhar versus State of Orissa, 1957, cases The courts held the view that the directive principles have to work within the framework of fundamental rights. In yet another case, M.H. Qureshi versus State of Bihar, 1958, the Supreme Court maintained that although the directive principles should conform to and run subsidiary to the chapter on fundamental rights, it would not reject the directive principles altogether. The constitutional amendments, first in 1951, the fourth in 1955, and the 17th in 1964, authorized the Parliament to amend the Constitution so as to give the directive principles an advantageous position as compared to the fundamental rights. In 1967, the Supreme Court in the Goloknath case declared the fundamental rights as sacrosanct and held that the fundamental rights cannot be amended for the implementation of the directive principles. In reaction to the Goloknath case, the 25th Amendment, 1971, inserted Article 31C, which contained, no law which seeks to implement Article 39B and 39C would be void on the ground that it contravenes the fundamental rights, especially Articles 14, 19, and 31. 2. No law which seeks to give effect to such policy, i.e., Articles 39B and 39C, would be questioned in a court of law. In the Kesavananda Bharati case, the Supreme Court declared Clause 2 of Article 31C as unconstitutional, stating that the judicial review is a part of the basic structure of the Constitution. The 429D Amendment, 1976, accorded primacy to directive principles over fundamental rights, Articles 14, 19, and 31. But in the Minerva Mills case, 1980, the Supreme Court reversed the position, making the directive principles subordinate to fundamental rights. However, the Supreme Court in the Minerva Mills case regarded both the fundamental rights and directive principles as complementary, one no less important than the other and both essential parts of the basic structure. Directive principles, implementation. Implementation of the directive principles, there is much that has been done. The Minimum Wages Act, 1948, the Payment of Wages Act, 1936, the Payment of Bonus Act, 1965, the Contract Labor Regulation and Abolition Act, 1970. The Child Labor Prohibition and Regulation Act, 1986, the Bonded Labor System Abolition Act, 1976, the Trade Unions Act, 1926, the Factories Act, 1948, the Mines Act, 1952, the Industrial Disputes Act, 1948, the Workmen's Compensation Act, 1923 have been enacted to protect the interests of the labor. The Maternity Benefit Act, 1961, and the Equal Remuneration Act, 1976 have been made to protect the interests of women workers. For the promotion of common good, insurance companies were nationalized in 1956 and banks in 1971. The Community Development Project, 1952, Hill Area Development Program, 1960, Drought-Prone Area Program, 1973, Minimum Needs Program, 1974, Integrated Rural Development Program, 1978, Jauhar Rozgar Yojana, 1989, Swarnajayanti Gram Swarozgar Yojana, 1999, and Sampurn Gramin Rozgar Yojana have been launched for raising the standard of living of the people. The Wildlife Protection Act, 1972, and the Forest Conservation Act, 1980 have been enacted to safeguard the wildlife and the forests respectively. The 73 Degrees and 74th Amendments have given the local governments a constitutional status. The Untouchability Offenses Act, 1955, renamed as the Protection of Civil Rights Act in 1976, and the legislations passed for the Scheduled Castes and the Scheduled Tribes in 1989 have helped promote the interests of the weaker sections of the society. Health services are being extended to the remotest possible areas and attempts are being made to eradicate diseases such as leprosy, AIDS, cancer, and the like. Universalization of education, especially elementary education, has been accorded the highest priority so as to provide free education to all children till the age of 14. The 86th Amendment, 2002, creating Article 21A, seeks to provide free and compulsory education to all children between the age of 6 and 14 years. The year 1990-91, declared as the Year of Social Justice in the memory of Dr. B.R. Ambedkar, indicates the facilities given to the people belonging to the scheduled castes and scheduled tribes. In order to protect the scheduled castes and scheduled tribes from discrimination, the government enacted Prevention of Atrocities Act in 1995 prescribing severe punishments for such action. Land reforms legislations have been enacted from time to time. Up to September 2001, more than 20 million acres, 81,000 sq. km of land had been distributed to scheduled castes, scheduled tribes, and the landless poor. A core objective of the banking policy is to improve banking facilities in rural areas. The Minimum Wages Act of 1948 empowers government to fix minimum wages for people working across the economic spectrum. The Consumer Protection Act of 1986 provides for better protection of consumers. The act is intended to provide simple, speedy, and inexpensive redressal of consumer grievances and awarding relief and compensation wherever appropriate to the consumer. A system of elected village councils, known as Panchayati Raj, covers almost all states and territories of India. 1/3 of the total number of seats have been reserved for women in panchayats at every level, and in the case of Bihar, half the seats have been reserved for women. Legal aid at the expense of the state has been made compulsory in all cases pertaining to criminal law if the accused does not have the means to engage a lawyer. India's foreign policy has been influenced by the directive principles. India supported the United Nations in peacekeeping activities, with the Indian Army having participated in 37 UN peacekeeping operations. The implementation of a uniform civil code for all citizens has not been achieved owing to widespread opposition from various religious groups and political parties. The Shah Banu case, 1985-86, provoked a political firestorm in India when the Supreme Court ruled that Shah Banu, a Muslim woman who had been divorced by her husband in 1978, was entitled to alimony from her former husband under the Indian law applicable to all Indian women. This decision evoked outrage in the Muslim community, which sought the application of the Muslim personal law. In response, the parliament passed the Muslim Women Protection of Rights on Divorce Act, 1986. However, the problem persists. Though there is much that has to be achieved with respect to the implementation of numerous directive principles, the task of implementing them is an ongoing process. Speaking about it, Nehru had rightly remarked, "So long as there are tears and sufferings, so long our work will not be over." F. Directive Principles Evaluation. Professor Ware describes the directive principles as a manifesto of our ideals and objectives. It may rightly be called our national manifesto, for every political party which comes to power is supposed to implement them. The directive principles have evoked a mixed opinion. They are, as K.T. Shah has said, a check payable at the convenience of the bank. Some object to the inclusion of directive principles into what constitutes the basic structure of the Constitution. See Pratap Banu Mehta, Inner Conflict of Constitutionalism, stating that determinate fundamental rights cannot be equated with indeterminate directive principles. Srinivasan held the view that these principles combine, rather incongruously, the modern with the old, and provisions suggested by reason and science with provision based purely on sentiments and prejudice. Sir Ivor Jennings says, directive principles do not matter. These principles have been criticized as lacking legal sanction, devoid of constitutional importance. They are vaguely stated and have been illogically arranged. No two principles are linked together. There are principles which would not be implemented in any remote future, and there are principles which any government worth the name must enforce. Yet these principles have utility of their own. B.N. Rao, the advisor to the Constituent Assembly, had said that these principles are moral precepts for the authorities of the state and that they have an educative value. Granville Austin thought of these principles as those which help further the goals of the social revolution. These principles act as signposts indicating what has been achieved and what still has to be achieved. They provide criteria to judge about the performance of the ruler. They help induce the governments to work for the welfare of the people. Justice Supru had said, "In these directive principles will be found the entire philosophy on which the welfare state in any modern community can be founded." These principles serve as the common manifesto. Justice Gajendra Gadkar, the Constitution of India, rightly says, "A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend in its legislative and executive act." 4. Fundamental duties. The Swaran Singh Committee in its recommendations 1976 suggested the inclusion of a separate chapter on fundamental duties in the Constitution. Following it, Part IVA, with Article 51A, was added by the 429D Amendment. In 2002, through the 86T Amendment, a duty was incorporated providing opportunities to children between the ages of 6 and 14 years. The fundamental duties, so described in the Constitution, are: A. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. B. To cherish and follow the noble ideals which inspired our national struggle for freedom. C. To uphold and protect the sovereignty, unity, and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and spirit of common brotherhood among all people of India, transcending religious, linguistic, and regional or sectional diversities. F. To renounce practices derogatory to the dignity of women. G. To value and preserve the rich heritage of our composite culture. H. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. I. To develop scientific temper, humanism, and spirit of inquiry and reform. J. To safeguard public property and to abjure violence. K. To strive towards excellence in all spheres of individual and collective activity. so that the nation constantly rises to higher levels of endeavor and achievement. L. Parents or guardian should provide opportunities for education to their children or wards between the ages of 6 and 14 years, 86th Amendment, 2002. The fundamental duties included in the Constitution are vague and ambiguous, described only as moral precepts. There is no provision for the enforcement of these duties, Ramcharan v. Union of India, 1980, or any sanction to prevent their violation. The Varma Committee on Fundamental Duties, 1999, however, has identified the existence of meritorious provisions for the implementation of fundamental duties, such as the Prevention of Insults to National Honor Act, 1971, the Protection of Civil Rights Act, 1976, and the Wildlife Protection Act, 1972. Practice questions. 1. Locate the roots of fundamental rights in the liberation struggle of India. 250 words. 2. Describe right to equality and right to freedom as mentioned in the Constitution of India. 700 to 800 words. 3. Comment on the increasingly higher focus on directive principles of state policy. 2014, 200 to 250 words. 4. Relate the concept of secularism with the right to freedom of religion as enshrined in the Constitution of India. 700 to 800 words. 5. Substantiate the concept that the Supreme Court of India is the custodian of our fundamental rights. 700 to 800 words. 6. Explain the right which ensures the minorities their culture and interests. 200 to 250 words. 7. Analyze the significance of Article 32, right to constitutional remedies. 2013, 200 to 250 words. 8. Examine the significance of the verdicts of Supreme Court in the Goloknath and Kesavananda Bharati cases for an understanding of Article 368 in regard to fundamental rights. 2014, 700 to 800 words. 9. Examine the relevance of the directive principles of state policy in the age of liberalization and globalization. 2012, 700 to 800 words. The executive in India, the president, the prime minister, and the union cabinet, the governor, the chief minister, and the state cabinet. Democratic Alliance, 2014, had a governing mantra: maximum governance and minimum government. Thai He BJP, Bharatiya Janata Party, dominated national. Minimum government did not mean absence of government or absence of authority. What it did mean is less of rules, less of files, less of red tapeism, less of officialdom, a system which is self-regulating. Self-evolving system that regulates on its own. Minimum government oversees of what is being done. The government neither it controls nor it coordinates, but it only facilitates. By maximum governance is meant more of implementation than mere formulation of theories and policies. Its objective is the happiness of the people, their overall development based on democratic values. The United Nations refers to certain attributes of governance: primacy of the rule of law, a consensus-oriented decision-making process, efficiency and effectiveness, transparency, responsiveness, equitable and accountable and citizen-driven, encouraging participation in the process of governance. Maximum governance and minimum government has most of the civil servants, meant shrinking of leisure, increasing work. Officially there is a 5-day week, but on Saturday most of them along with their assistants down to clerks and peons are at work. There are no gymkhana festivities in the late evening. Officers' meetings finishing at 8 p.m. are followed by completing the office's daily pending work till about 10 p.m. Bureaucrats are caged in Modi's steel frame. Foreign trips are out, and if done, the reports are to be made available within 3 days of coming back from the trip. In a parliamentary democracy as India, the executive both at the union or the state level is nominal I.E. The president at the union and the governor at the state, and the real or de facto power rests with the prime minister and his council of ministers at the union and with the chief minister and his council of ministers in the states. There are, therefore, 2 offices of power in the parliamentary system: the head of the state and the head of the government. The president at the union level and the governor at the state AVE constitute the head of the state, in whose names there are powers but who do not exercise them. On the other hand, the prime minister with his council of ministers at the
On the other hand, the prime minister, with his council of ministers at the union level, and the chief minister, with his council of ministers, at the state level constitute the real executive, in whose names there are no powers but they exercise all powers, which are vested in the nominal executive. The President of India. I.A. Introduction. Part V, Chapter I, Articles 52 to 78, of the Constitution deals with the Union Executive, i.e., the President, the Vice President, the Council of Ministers, and the Prime Minister. Article 52 of the Constitution reads, there shall be a President of India, and Article 53, 1, says that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in the Constitution. Article 53, 2, declares the President as the Supreme Commander of Defense Forces, but stipulates that the exercise of his powers to be regulated by the law. However, the article states that any function can be transferred to the President and permits the Parliament to confer any function on any authority besides the President. This article makes the following things clear. The President can exercise the executive powers of the Union himself. 2. He can exercise these powers through officers subordinate to him. 3. Either he or officers subordinate to him would exercise these powers in accordance with the provisions of the Constitution and the law. 4. His functions can be increased by the Parliament, and also conferred on authorities other than the President. The President is elected indirectly. Article 54 of the Constitution says that the President shall be elected by the electoral. Article 54 of the Constitution says that the President shall be elected by the electoral college consisting of members of both houses of Parliament, and the members of state legislative assemblies.
In this article and Article 55, the word states includes the National Capital Territory of Delhi and the Union Territory of Pondicherry, i.e., the legislative assemblies of both Delhi and Pondicherry. Article 55 explains the manner of the election of the President. Article 55 of the Constitution says, 1. As far as practicable, there shall be uniformity in the scale of representation of different states in the election of the President. 2. For the purpose of securing such uniformity among states inter se as well as parity between the states as a whole and the Union, the number of votes which each elected member of Parliament and the legislative assembly of each state is entitled to cast shall be determined in accordance with the Constitution. 3. The election of the President shall be held in accordance with the system of proportional representation by single transferable vote and the voting by secret ballot. The value of votes of elected members of state legislative assemblies and the Houses of Parliament is determined as per the provisions of Article 55(2) of the Constitution. Presidential elections of India involve proportional representation from respective states. The number of votes assigned to a voter from a legislative assembly decided as follows. Total population of the state, total number of elected members x 1,000. In the 2012 presidential elections, Pranab Mukherjee got 373,116 MPs votes and 340,647 MLAs votes, while P.A. Sangama got the 145,848 MPs and 170,130 MLAs votes. Pranab Mukherjee 713,763. P.A. Sangama 315,978 votes. The term of the President, according to Article 56, is 5 years, with a provision for re-election. Article 57. The President can resign before the expiry of his term, resignation to be addressed to the Vice President, or be removed by impeachment for violation of the Constitution in the manner as enunciated in Article 61. Article 58 prescribes the qualification for election as President. These are: I. The person is a citizen of India. 2. The person has completed the age of 35 years, and 3. She is qualified for election as a member of the House of the People, Lok Sabha. A person who holds an office of profit is considered ineligible for election. He should also not be a member of either House of the Parliament or state legislature, and if he is, his seat in the House would be regarded as vacant on the date on which he enters upon the office as the President. Article 59. Article 60 of the Constitution prescribes the oath, or affirmation by the President before he takes up his job, in which he affirms that he shall preserve, protect, and defend the dignity of the Constitution and the law. Article 61 prescribes the procedure for impeachment of the President. Impeachment proposal can be initiated in either houses of the Parliament. 2. The proposal has to be signed by 1/4 of members of particular House. 3. A 14-day notice has to be given to the President. 4. The House must pass the impeachment proposal by a majority of 2/3 of the total membership of that House. The passed impeachment proposal bill then is sent to the other House, which sits as a court and investigates the charges. 6. The President against whom the investigation is on has the right to appear and be represented in the House. 7. If the other House passes the resolution by a majority of 2/3 of the total membership of that House, the President stands removed on the day the resolution is so passed. No President has been removed by impeachment so far. The President of India powers and duties, executive. 1. All executive actions of the Government of India are expressed to be taken in the name of the President. Article 77, 1. All orders and instruments are to be made and executed in his name. Article 77, 2. The President makes rules for more convenient transaction of business of the government. Article 77, 3, and contracts, etc. Article 299. 2. All officers of the Union are his subordinates. Article 53, 1. 3. The President has the right to be informed of the affairs of the Union. Article 78b. 4. The President has the power to appoint I. The Prime Minister. 2. Other Union Ministers. 3. The Attorney General of India. 4. The Controller and Auditor General of India. 5. 7. 8. She. Zil. 13. XIV. 15. Judges of the Supreme Court, judges of high courts, the governor of a state, the Finance Commission, the Union Public Service Commission or joint commissions for a group of states, the Chief Election Commissioner and other members of the Election Commission, Special Officer for Scheduled Castes and Tribes Commission to report on the admission of scheduled areas, Commission to investigate into the conditions of backward classes, Commission on Official Language, Special Officer for Linguistic Minorities. 5. The President is the Supreme Commander of the Armed Forces. Article 53, 2. 6. The President appoints ambassadors and high commissioners and receives diplomatic representatives. Treaties with other countries are concluded in his name. He represents the country in the external world. Constitutional limitations on President's powers. Executive power to be exercised in accordance with the Constitution. Article 53, 1. All the ministers are to be appointed by the President on the advice of the Prime Minister. Article 75, 1. President's powers are to be exercised in accordance with the aid and advice of the Council of Ministers headed by the Prime Minister. Article 74, 1, 424. Amendment 4. President may seek reconsideration of the advice sought, but he has to act in accordance with the advice tendered after such reconsideration. Article 74, 1, 44(t)(2) Amendment. Table 20.2 The Presidents of India. IC. The President of India. Powers and duties, legislative and financial. 1. The President has power to summon or prorogue the Houses of Parliament and to dissolve the lower house. Article 85. He has the power to summon a joint sitting of both Houses of Parliament in the case of a deadlock between them over an ordinary bill. Article 108. 2. The President can address both Houses of Parliament assembled together at the first session after general elections and the first session each year and informs the Parliament of the cause of the summons. Article 87. 3. The President has the right to address either House or the joint sitting of both Houses at any time and to require the attendance of members for this purpose. Article 86, 1. In addition to the right to address the Parliament, the Indian President has the right to send messages to either the House in regard to pending bill or to other members. The House must then consider the message with all convenient dispatch. Article 86, 2. 4. In the Council of States Rajya Sabha, 12 members having special knowledge or practical experience of literature, science, art, and social service. In the Council of States Rajya Sabha, 12 members having special knowledge or practical experience of literature, science, art, and social service are nominated by the President. Article 81. The President is also empowered to nominate not more than 2 members to the House of the People from the Anglo-Indian community if he is of the opinion that the Anglo-Indian community is not adequately represented in that House. Article 331. 5. It is the duty of the President to lay before the Parliament A. Annual financial statement, budget, and supplementary statement, if any. B. Report of the Auditor General relating to the accounts of the Government of India. C. Recommendations of the Finance Commission, together with explanatory memorandum of action taken thereon. D. Report of the Union Public Service Commission explaining the reasons wherein advice of the Commission has not been accepted. E. Report of the Special Officer for Scheduled Castes and Scheduled Tribes. F. Report of the Commission on Backward Classes. G. Report of the Special Officer for Linguistic Minorities. 6. The Constitution requires a prior sanction or recommendation of the President for introducing legislation on matters such as A. The formation of a new state or the alternation of boundaries, etc. of an existing state. Article 3. B. A bill providing for any matter specified in Article 31A1. C. A money bill. Article 117, 1, 3. D. A bill affecting taxation in which states are interested, etc. Article 274, 1, Chapter 1 of Part 12. E. A state bill imposing restrictions upon the freedom of trade. Article 304. 7. After a bill is passed by the Parliament, the President A. may give his assent to the bill, or B. may withhold his assent to the bill, or C. may, in the case of non-money bill, return the bill for reconsideration of the Houses with or without a message suggesting amendments. A money bill cannot be returned for reconsideration. D. In the case of C, if the bill is passed again by both houses of Parliament with or without amendments and again presented to the President, it would be obligatory upon him to assent to it, Article 111. E. The President has the right to disallow or return for reconsideration a state bill which may have been reserved for his consideration by the Governor, Article 201. 8. The President has the power to legislate by ordinance when it is not possible to have parliamentary enactment, Article 123. 9. Money bills are introduced in the Lok Sabha on the recommendation of the President, Articles 112, 117. 10. The Contingency Fund of India is placed at the disposal of the President of India, Article 267. D. The President of India powers and duties, judicial and miscellaneous. 1. The President has the power to grant pardon, reprieve, respite, or remission of punishment or suspend, remit, or commute sentence of a person convicted of offense, Article 72, 1. 2. He has the power to make rules and regulations relating to various matters of the state, Article 77. 3. He has the power to give instructions to a governor to promulgate an ordinance if a bill containing the same provisions requires a prior sanction of the President under the Constitution, Article 213, 1, Proviso. 4. He has the power to refer a question of public importance to the Supreme Court for opinion. 10 such references have been made since 1950, Article 143, under advisory jurisdiction. 5. He has the power to appoint commissions to report on specific matters such as commissions on the administration of scheduled areas and welfare of scheduled tribes and backward classes, the Finance Commission, the Commission on Official Languages, and the Interstate Council, i.e. emergency provisions. The President can declare 3 types of emergencies: national emergency, Article 32, state emergency, Article 356, and financial emergency, Article 360. National emergency is caused by war, external aggression, or armed rebellion in the whole of India or a part of its territory. Such an emergency was declared in India in 1962, Indochina War, 1965, Indo-Pakistan War, 1975 internal emergency declared by Indira Gandhi on account of internal disturbances. The President can declare such an emergency only on the basis of a written request by the Council of Ministers headed by the Prime Minister. Such a proclamation must be approved by the Parliament within 1 month. Such an emergency can be imposed at one time for 6 months. It can be extended for 6 months again and again by repeated parliamentary approvals. In such an emergency, fundamental rights of the Indian citizens can be suspended. The 6 freedoms under right to freedom are automatically suspended. However, the life and personal liberty cannot be suspended. State emergency is declared due to failure of constitutional machinery in a state. Nearly all states have undergone such an emergency. This emergency is also known as the President's Rule. LF The President is satisfied on the basis of a report by the governor of the concerned state or from other sources that the governance in a state cannot be carried out according to the provisions of the Constitution. He can declare emergency in the state. Such an emergency must be approved by the Parliament within 2 months. It is imposed for 6 months at one time and can last for a maximum of 3 years with repeated parliamentary approvals every 6 months. If the emergency needs to be extended for more than 3 years, this can be achieved by a constitutional amendment as had happened in Punjab and Jammu and Kashmir. During such an emergency, the President can take over the entire work of the executive and the governor administers the state in the name of the President. The legislative assembly of that state may be dissolved or remain in suspended animation. The Parliament makes laws on all 66 subjects of the state list. All money bills have to be referred to the Parliament for approval. If the President is satisfied that there is an economic situation in which the financial stability or the credit of India is threatened, he can proclaim financial emergency as per the Constitution's Article 360. Such an emergency must be approved by the Parliament within 2 months. It has never been declared. A state of financial emergency remains in force until revoked by the President. In case of a financial emergency, the President can reduce salaries of government officials, including judges of the Supreme Court and High Courts. All money bills passed by state legislatures are submitted to the President for his approval. He can direct the states to observe certain principles, economy measures relating to financial matters. 1. F. Role and position of the President of India. If we look at the provisions of the Constitution, there appears to be a situation where the President is both a real as well as a nominal ruler. Article 53, 1, stipulates that the executive powers of the Union government are vested in the President who can exercise them directly or through officials appointed by him. The President, through Article 72, 1, has the power to grant pardons, reprieves, or remissions of punishment or suspend, remit, or commute the sentence of any person convicted of offense. Article 75, 1, authorizes the President to appoint ministers on the advice of the Prime Minister and ministers, and in accordance with the Article 75, 2, they would remain in office during the pleasure of the President. Article 77, 1, says that all the actions of the government are to be expressed in the name of the President made and executed in his/her name. Article 77, 2, and that he is empowered under Article 77, 3, to make rules for the convenient transaction of business. Article 78, b, entitles President to be informed of the affairs of the administration of the Union. Article 103, 1, empowers the President to give final decision with regard to disqualifications of a member of the legislature. Through Article 111, the President has the right to withhold his/her assent to a bill or send back to the originating House with regard to ordinary bill. The President, under Article 263, has the power to establish interstate counsel in the public interest to inquire into or seek advice upon disputes between states, to investigate and discuss subjects of common interest, and to make recommendations leading to coordination of policies. The President, it may be argued, is elected by elected members of the Parliament and state legislative assemblies. These provisions indicate that the framers of the Constitution did not intend to make the President a nominal head. There are, on the other hand, reasonably powerful arguments which help the Indian presidency not to become a really powerful one. The provisions of the parliamentary form of government in India call is for a nominal head and not the real one. The indirect election of the President under Article 54 is meant to give the President an office of honor and not of power. Article 74, 1, wants the President to seek the aid and advice of the Council of Ministers headed by the Prime Minister in the exercise of his/her power, and the advice, in accordance with the 429D Amendment, reconsidered, as per the 44th Amendment, is binding on the President. All this does not make the President a real ruler of the country. Article 75, 3 makes the Council of Ministers headed by the Prime Minister collectively Article 75, 3 makes the Council of Ministers headed by the Prime Minister collectively responsible to the House of the people. Had the President been made a real ruler, this responsibility would have been given to him/her. There is no financial power given to the President. Articles 112, 115, 119, 354, and 360 clearly indicate that the President has no real financial powers with him/her. Even the emergency provisions do not grant any real power to the President. The reading of Article 78 clearly shows that the administrative decisions are to be taken by the Council of Ministers, and the President has only the right to be informed of these decisions. The stipulations of the above articles of the Constitution indicate that the position of the President lies somewhere else. He is, if not a real ruler, is also not a nominal head. The President of India has a definite position in the federal scheme which the Constitution has adopted. If that were not so, why is there a provision that elected members of state legislative assemblies participate in his/her election, Articles 54, 55, or why is there a provision empowering him/her to establish an interstate council, Article 263? The President, under Article 60, is given the task of preserving, protecting, and defending the Constitution. He/she also has to see that the administration carries on according to the provisions of the Constitution. This indicates that the President has a definite role to play in the administration. He/she is the custodian of the democratic process as enshrined in the Constitution. At times, especially when the majority of a political party/parties is not clear, he/she can use his/her discretion as to who should form the government or whether any advice by a prime minister to dissolve the House of the People be accepted or not. This theoretical position evident from the articles of the Constitution apart, let us see what the framers of the Constitution had in mind about the Indian presidency and how, in reality, the presidents have conducted themselves. Dr. B.R. Ambedkar had pointed out in the Constituent Assembly, under the Constitution, the President occupies the same position as the King under the British Constitution. He is head of the state but not the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial head on whose seal the nation's decisions are made known. Dr. Rajendra Prasad had himself stated that the President would become a constitutional president in all matters. But when he became the President of India in 1951, he found himself at odds on the question of his giving assent to a Hindu code bill. In 1960, he said, "There is no provision in the Constitution which in so many words lays down that the President shall be bound to act in accordance with the advice of the Council of Ministers." He had thus raised the dual identity of the President, I, as a voice of the government of the day, and II, as guardian of the constitutional proprietary. President K. R. Narayanan II had raised voice against the then government's proposal to have a presidential system replacing the parliamentary one, which in his opinion constituted a part of the basic structure of the Constitution. President Fakhruddin Ali Ahmed had to sign the Emergency Proclamation Bill in June 1975 under Article 352 as advised by Indira Gandhi without a clearance from the Council of Ministers. The decision of the Council of Ministers to advise the President to issue a proclamation in writing has been made essential under the 44th Amendment. However, the presidents have used the power under Article 111 to send bills back for a reconsideration to the originating House of the Parliament. President Venkatraman used this power in 1987 by sending the postal bill back. President Shankar Dayal Sharma sent 2 bills back on the eve of the 1996 parliamentary elections. The presidents, keeping the dignity of the office, usually act as the constitutional head. With the rise of coalitional governments, the role of the president in government formations has become important after 1989, with presidents attempting to use their discretionary powers. President Venkatraman in 1989 and 1991, President Sharma in 1996, President Narayanan in 1998, and President Abdul Kalam in 2004 faced hung parliaments and used their powers accordingly, some trying to develop certain precedents. It is, thus, clear that the President of India is not just a rubber stamp, nor does he/she sign on the dotted lines. Indeed, he/she does not rule, but he/she does not reign either. He/she asserts when it is necessary. Indeed, the Constitution of India does not vest the President with real powers of the administration, but in certain situations, though not many, he/she uses his/her discretion and own wisdom without the aid and advice of the Council of Ministers. One such situation arises when, after Lok Sabha elections, no political party commands a majority in the House, and another when an incumbent government loses majority in the Lok Sabha and the Council of Ministers recommends the President to dissolve the House. The third situation is when the President either sends the bill back to the originating House or withholds his/her assent. In such situations, the President can act in his/her wisdom and can use his/her discretion, i.e., he/she acts without the aid and advice of the Council of Ministers. The presidents have usually stood away from the politics in the states and have actually acted on the advice of the Council of Ministers. What at the most the president can do is to ask the cabinet to reconsider the advice given. Once the reconsidered advice is given, the president has to act according to the advice. LL. The Vice President of India. Article 63 of the Constitution provides that there shall be a Vice President of India. Articles 64 and 89, 1, provide that the Vice President shall be ex officio Chairman of the Council of States Rajya Sabha and shall not hold any other office of profit. In the constitutional setup, the holder of the office of Vice President is part of the executive, but as the Chairman of the Rajya Sabha, he is a part of Parliament. To be qualified for election as Vice President, Article 66, 3 says that a person should be citizen of India, should have completed the age of 35 years, and should have to be elected as a member of the Rajya Sabha. The Vice President is elected by an electoral college consisting of members of both houses of parliaments by secret ballot in accordance with the system of proportional representation by single transferable vote. All doubts and disputes arising out of or in connection with the election of Vice President can be looked into and decided only by the Supreme Court of India, whose decision is final. The Vice President holds office for 5 years from the date on which he enters upon the office. He may, however, resign from the office by writing a resignation letter addressed to the President of India. He may also be removed from the office by a resolution of the Rajya Sabha passed by a majority of all members of the Rajya Sabha and agreed to by the Lok Sabha. At least a 14-day notice is necessary to move such a resolution. Notwithstanding the term, the Vice President continues in office till a successor assumes office. Article 67. Table 20.3 The Vice Presidents of India. Name tenure Dr. Zakir Hussain, May 13, 1962 to May 12, 1967. Varahagiri Venkatagiri, May 13, 1967 to May 3, 1969. Dr. Gopal Svarup Padak, August 31, 1969 to August 30, 1974. B.D. Jatti. August 31, 1974 to August 30, 1979. Justice Muhammad Hidayatullah. August 31, 1979 to August 30, 1984. R. Venkatraman. August 31, 1984 to July 24, 1987. Dr. Shankar Dayal Sharma. 3 September 1987. July 24, 1992. K. Narayanan. August 21, 1992 to July 24, 1997. Krishan Kant. August 21, 1997 to July 27, 2002. Baran Singh Shekhawat. August 19, 2002 to July 21, 2007. Muhammad Hamid Ansari and August 10, 2007 till re-elected in 2012 date. Before Dr. Zakir Hussain, S. Radhakrishnan had occupied the office of the Vice President. Under Article 65 of the Constitution, the Vice President acts as President in the event of a vacancy occurring due to death, resignation, or removal of the President. The Vice President reverts to his office when a new President is elected and enters upon his office. When the President is unable to act owing to his absence, illness, or any other cause, the Vice President discharges the President's functions for a temporary period until the President resumes his duties. In the event of the death, removal, or resignation of the President, the Vice President acts as President and the election of new President has to be held within 6 months. Article 62. When the vice president acts as or discharges the functions of the president, he has all the powers and immunities of the president and is entitled to the same emoluments as the president, Article 65. However, during this period, he does not perform the duties of the office of the chairman of the Rajya Sabha, Article 64. The deputy chairman of the Rajya Sabha acts as its chairman. As chairman of the Rajya Sabha, the vice president presides over the meetings of the House. As the presiding officer, he is the unchallenged guardian of the prestige and dignity of the House. He is also the principal spokesperson of the House and represents the collective voice of the House to the outside world. He ensures that the proceedings of the House are conducted in accordance with constitutional provisions, rules, practices, and conventions, and decorum is maintained in the House. He is the custodian of the rights and privileges of the House. As vice president, she performs several other functions: goodwill visits to foreign countries, consultation on formulation and implementation of policies, attendance at numerous social, cultural, academic engagements, and by convention, chancellor of some universities. The vice president is usually informed of government decisions. The vice president is the second head of the state, as also the ex officio chairman of the Council of States. As such, his real role is a unique feature of our Constitution. He has much in common with the Vice President of the United States of America. Both preside over the proceedings of the second chamber of their respective legislatures. But there are also great dissimilarities between the two. The election of the two differs. In the case of the Vice President of the United States of America, the Electoral College which elects the President also elects the Vice President. In the election of the Indian Vice President, members of both houses of Parliament constitute the Electoral College. In the case of vacancy of the President in the United States of America due to death, resignation, or removal, the Vice President becomes the President for the remaining period of the outgoing President. But in India, the Vice President performs the duties of the President as acting President for the maximum period of 6 months within which the election of the President must be held. LLL. The Council of Ministers, the Cabinet, and the Prime Minister. Articles 74, 75, and 78 of the Constitution provide for provisions relating to the Council of Ministers, the Cabinet, and the Prime Minister. A brief summary of Articles 74 and 75 is given as follows. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The question whether any, and if so what, advice was tendered by the Council of Ministers to the President shall not be inquired into in any court. Other provisions relating to the Council of Ministers are: Vi. The Prime Minister shall be appointed by the President and other ministers by him on the advice of the Prime Minister. The minister shall hold office during the pleasure of the President. The Council of Ministers shall be collectively responsible to the House of the People. Before a minister enters upon his office, the President shall administer to him the oath of office and of secrecy according to the form set out in the third schedule. A minister who is not a member of either House of the Parliament for 6 consecutive months shall at the expiration of that period cease to be a minister. The salaries and allowances of ministers shall be such as the Parliament may from time to time by law determine and, until Parliament so determines, shall be specified in the second schedule. Article 78 prescribes the duties of the Prime Minister. They shall be: to communicate to the President all decisions of the Council of Ministers relating to the administration of affairs of the Union and proposals for legislation. To furnish such information relating to the administration of affairs of the Union and proposals for legislation as the President may call for. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. The Prime Minister of India. The above provisions require that there has to be a Council of Ministers headed by a Prime Minister to aid and advise the President in the exercise of his powers. As a custodian of the Constitution, the President has to have a Council of Ministers and a Prime Minister. Furthermore, the President has to take the aid and advice and is, in fact, bound by the advice of the Prime Minister in Council. For the Council of Ministers, the President has to appoint the Prime Minister and, on the latter's advice, has to appoint other ministers, i.e., his Council of Ministers. The President is expected to invite such a person to be Prime Minister who has been elected as leader of the parliamentary party that commands an absolute majority in the Lok Sabha. But when no single political party enjoys a majority, the President has some discretion. He may invite the leader of a combination of parties claiming to have majority in the Lok Sabha and appoint him as Prime Minister. The appointee has to be a member of one of the Houses of Parliament or be elected so within 6 months of being appointed as Prime Minister. After the Prime Minister is appointed, he recommends to the President certain members to be appointed as ministers. In his recommendation for appointing ministers, i.e., the members of the Council of Ministers, the Prime Minister is usually free He unmakes his council of ministers and reshuffles the departments of his ministers as he likes. A powerful prime minister does so or can do so. Table 20.4 The Prime Ministers of India. Name: Jawaharlal Nehru, Gulzari Lal Nanda, Lal Bahadur Shastri, Gulzari Lal Nanda, Indira Gandhi, Morarji Desai, Chaudhary Charan Singh, Indira Gandhi, Rajiv Gandhi, Vishwanath Pratap Singh, Chandra Shekhar, Narasimha Rao. Tenure: August 15, 1947 to May 27, 1964. May 27, 1964 to June 9, 1964. June 9, 1964 to January 11, 1966. January 11, 1966 to January 24, 1966. January 24, 1966 to March 24, 1977. March 24, 1977 to July 28, 1979. July 28, 1979 to January 14, 1980. January 14, 1980 to October 31, 1984. October 31, 1984 to December 2, 1989. December 2, 1989 to November 10, 1990. November 10, 1990 to January 21, 1991. January 21, 1991 to May 16, 1996. Atal Bihari Vajpayee May 16, 1996 to June 1, 1996. H.D. Deve Gowda June 1, 1996 to April 21, 1997. Inder Kumar Gujral April 21, 1997 to March 19, 1998. Atal Bihari Vajpayee March 19, 1998 to May 22, 2004. Manmohan Singh Narendra Modi 26 May 2004. Ill date: May 22, 2004 to May 26, 2014. The powers of the Prime Minister are enormous and his position is paramount, especially if the office is occupied by a strong personality. In relation to the President, the Prime Minister acts as his advisor and a link between the Council of Ministers whose decisions he communicates to the President. In relation to the Council of Ministers, the Prime Minister is the person who makes the ministry and the one who supervises its functioning. With his resignation, the whole ministry stands dissolved. No wonder he is considered central to the working of the central government and described as the captain of the ship of the state. In relation to the legislature, the parliament, the prime minister is the leader of the majority party of the parliament or the majority coalition and, as such, the head of the government and its chief spokesman. He leads in defending the government in the parliament, in running the administration and in getting the budget passed in the parliament. In relation to the nation, the prime minister is the leader of the nation by virtue of his being the leader of the parliament. In fact, his office is the office of power, while that of the president is the office of honor and of respect. Of late, the parliamentary or the cabinet, the Westminster model system has become the prime ministerial form of government. To assist the prime minister, there is a prime minister's office, PMO, headed by the principal secretary to the prime minister. The PMO includes an anti-corruption unit and public grievance wing. It handles all important matters including policy and matters related to defense, administration, and appointments. The Union Council of Ministers. The Union Council of Ministers headed by the Prime Minister is the real executive in India. The President exercises all his powers and performs all his functions with the aid and advice of the Council of Ministers with the Prime Minister at its head. However, the President may ask the Council of Ministers to reconsider its advice. But the reconsidered advice of the Council of Ministers has to be acted upon by the President. No court can inquire into the advice tendered to the President by the Council of Ministers. Articles 74(1) and 74(2) of the Constitution. Members of the Council of Ministers are appointed by the President on the recommendations of the Prime Minister. Each minister is allocated a department and works under the supervision of the Prime Minister. In this way, their individual and political responsibility is towards the Prime Minister for no minister can remain in office without the Prime Minister's wish. All ministers as a body are collectively responsible to the House of the People. This responsibility, called the collective responsibility, implies that ministers work as one unit, one team, they swim and sink together. The ministers are either members of one house of the parliament or of the other. Most ministers are from the House of the People, though there are also members of the Rajya Sabha, the Council of States, as ministers. Usually, the Prime Minister is a member of the House of the People, but there is no constitutional requirement for him to be so. The UPA government is headed by Dr. Manmohan Singh, who is a member of the Council of States. Initially, Indira Gandhi was also a member of the Council of States when she took over as the Prime Minister in 1966. For attaining political homogeneity in a parliamentary democracy, the members of the Council of Ministers belong to the majority political party or the majority coalition. The Council of Ministers is a large body of ministers consisting of about 80 to 85 ministers. Among them, the top category, called the Ministers of Cabinet rank, consists of about 20 members or so who hold the charge of important portfolios. Below this, there is a body of ministers called the Ministers of State, some of whom hold independent charge of relatively minor departments while others are attached to cabinet ministers. Still below is the body of ministers called the Deputy Ministers, each attached to ministers of the two categories above. Parliamentary secretaries constitute still another category of ministers who help the top ministers in handling the affairs in the parliament. Cabinet ministers among all the categories of ministers constitute an important group, though even in this group there is an inner group called the kitchen cabinet or the inner cabinet whose members are most important of all ministers. A cabinet meeting is attended only by the ministers of cabinet rank, but ministers of state can also be invited to attend. The salient features of the Council of Ministers are: A. Ministers are members of the parliament or they become members of either house within a period of 6 months. B. They are collectively responsible to the lower house of the parliament. C. They work as a team. D. They belong to the majority party/parties. E. The proceedings of cabinet meetings are kept secret. F. All ministers work under the leadership of the Prime Minister, who presides over cabinet meetings. The Council of Ministers performs very important functions. A. It formulates and determines all policies of the government. B. It conducts the administration of the union government. C. It recommends all major appointments. D. It prepares the national budget. E. It advises the President on all matters of administration. F. It takes the final decisions of the administration. G. It conducts and regulates foreign relations. H. It helps make all government regulation. The Council of Ministers works through its committees. Important committees include Political Affairs Committee, Economic Affairs Committee, Appointments Committee, Parliamentary Affairs Committee. There is a Cabinet Secretariat headed by a civil service official called Cabinet Secretary, usually the senior-most civil servant, who conducts and coordinates the whole administration. C. The working of the parliamentary system, the President, the Prime Minister, the Council of Ministers. The parliamentary system, as adopted in India, has two executives. The President as the head of the state is the constitutional head, while the Prime Minister as the head of the government is the real power head who, as the head of the Council of Ministers, aids and advises the President in the exercise of her functions and whose advice is binding on the President. The President may ask the Council of Ministers to reconsider the advice. However, he is obliged to act in accordance with the advice tendered after the reconsideration. The functions of the Prime Minister as laid in Article 78 of the Constitution are much less than what he really does. He is not merely a communicator, conveying the decisions of the Council of Ministers to the President and the proposals, if any, of the President to the Council of Ministers with regards to affairs of administration and the legislative policies. He is, in fact, the chief advisor of the President and the chief spokesman of the government both in and outside the Parliament. He is not there merely to furnish information relating to the administration and legislation which the President may call for or to submit to the Council of Ministers, a matter which the President may want to be considered but as a link between the constitutional head and the real executive. The Prime Minister is much more than what she is described in Article 78 of the Constitution. Within a parliamentary form of executive that India has, the Prime Minister is the official who makes and unmakes the government, the one who supervises the functioning of all ministries, the one who presides over modernizing the country, its policies, its innovations. The Prime Minister is not merely a leader of the majority party, but is also the leader of the Parliament and, through it, the leader of the nation. The fact is that the personality of the Prime Minister makes a lot of difference in her position vis-a-vis her ministerial colleagues. A powerful Prime Minister may be like a shining moon among less shining stars, primus inter pares, while a weak Prime Minister may be just the first among equals. Nehru was much more than a mere Prime Minister. This is why he was able to build numerous institutions of democracy. Supported by equally powerful personalities who presided over numerous ministries, he was able to democratize the system. Shastri, following Nehru, worked in true spirit of cabinet system and allowed the ministers to work as a team. Indira Gandhi, with her unique style of leadership, led the nation in most, if not all, cases single-handedly. Unlike Nehru, she was possessive. Rajiv Gandhi sought to follow the style of both his grandfather Nehru and mother, Indira Gandhi. All the prime ministers during the periods of coalitional governments had to work and in fact did work under the constraints of their supporting and participating political parties. Relationship between presidents and prime ministers over the years has gone well in the sense that the presidents have realized their position as the constitutional head and hence worked well with their prime ministers who hold their offices as popular leaders. A Rajendra Prasad Nehru controversy over the Hindu Code Bill in the early years of the Republic and the Zail Singh Rajiv Gandhi relationship over Article 78 in 1987 may be exceptions. The Council of Ministers as a body of different types of ministers within the framework of the parliamentary system of India is the real administrator. The President appoints the ministers but on the advice of the Prime Minister. The ministers are in office during the pleasure of the President, which in effect means the confidence of the Parliament, especially of the House of the People. Legally, ministers are responsible to the President and politically to the Prime Minister, but in actual practice to the House of the People. The real task of the Council of Ministers is A. To evolve policies at the ministerial level. B. To formulate policies at the cabinet level. C. To approve policies at the parliament level, and D. To execute policies at the government level. It is because of this task that the Council of Ministers helps make laws through the Parliament, executes laws, conducts administration, makes appointments, prepares budget, and conducts foreign relations. The cabinet system seldom works as the prime ministerial system unless there is a heavyweight prime minister. India has witnessed cabinet system of various levels. Professor MP Singh, the Union Executive, refers to 3 such levels. A. Pluralist parliamentary level, when the Prime Minister worked together with her ministers, seldom dominated them and usually consulted them, as during the times of Nehru and Shastri. B. Neo-patrimonial parliamentary level, when the Prime Minister dominated ministers, lowering the Council of Ministers into the Prime Minister's office, as during the time or Indira Gandhi, especially between 1971-170. C. Federal parliamentary level, when, as during the coalitional era after 1989, prime ministers worked with their ministers, usually imposed upon them, under constraints of supporting and participating political parties. 4. The government of states. 4. A. The governor. Article 153 says that there shall be a governor for a state, and Article 154 vests all executive powers of the state in the governor, who shall exercise them either himself or through officers subordinate to him. However, the governor's functions can be increased, and the parliament or the state legislature can confer by law any function on any authority subordinate to the governor. The governor is appointed by the president, Article 155. There can be one governor for 2 or more states, Article 153. Article 156 says that the term of office of the governor shall be 5 years, and he may continue in office till his successor enters upon the office. The governor holds office during the pleasure of the president, who can also transfer him to any other state. According to Article 157, a person eligible for appointment as governor should be a citizen of India and have completed the age of 35 years. He should not be a member of either House of the Parliament or state legislature, and if he is so, his seat would be regarded as vacant. When he enters upon the office of the governor, he must not hold an office of profit. His oath or affirmation, under Article 159, prescribes that he would preserve, protect, and defend the Constitution and the law. The Constitution vests in the governor all the executive powers of the state government. He or she appoints the chief minister, who enjoys the support of the majority in the Vidhan Sabha. He or she also appoints other members of the Council of Ministers and distributes portfolios to them on the advice of the chief minister. He also makes other major appointments of the state. The Council of Ministers remains in office during the pleasure of the governor. But in the real sense, it means the pleasure of the Vidhan Sabha. As long as the majority in the Vidhan Sabha supports the government, the Council of Ministers cannot be dismissed. The governor also appoints the Advocate General, Article 165, and the chairman and members of the State Public Service Commission, Article 316. He or she is consulted by the President in the appointment of the judges of the high courts, and he or she appoints the judges of the district courts. The governor has certain legislative powers as well. The governor summons the sessions of both houses of the state legislature and prorogues them. He or she can even dissolve the Vidhan Sabha. These powers are formal, and the governor, while using these powers, must act according to the advice of the Council of Ministers headed by the Chief Minister. He or she inaugurates the state legislature by addressing it after assembly elections and at the beginning of the first session every year. His or her address on these occasions is generally meant to outline the policies of the state government. Articles 174, 175, 176. A bill passed by the state legislature can become a law only after the governor gives his assent. He or she can return a bill to the state legislature, if it is not a money bill, for reconsideration, Article 200. However, if the state legislature sends it back to him or her for the second time, he or she has to give his or her assent to it. The governor has the power to reserve certain bills for the president, Article 200. When the state legislature is not in session and the governor considers it necessary to enact a law, he or she can promulgate an ordinance, Article 213. These ordinances are submitted to the state legislature at its next session. They remain valid for no more than 6 weeks from the date the state legislature is reconvened. To grant pardon, or reprieve, or Remit punishment are among the governor's judicial powers. Article 161. A money bill which falls under the governor's financial powers is introduced in the Vidhan Sabha only with his prior permission. Normally, the governor has to act on the aid and advice of the Council of Ministers headed by the Chief Minister. However, there are situations when he or she has to act as per his or her own judgment and take decisions on his or her own. These are called the discretionary powers of the governor. He or she exercises them in the following cases. A. In the appointment of the Chief Minister of a state. Article 164. When no party gets a majority in the Vidhan Sabha, the governor exercises his or her own wisdom and can either ask the leader of a single largest party or the consensus leader of two or more parties, i.e. a coalition, to form the government. He or she then appoints such a leader as chief minister. B. In informing the president about the failure of constitutional machinery in a state. Article 356. The governor can send a report to the president informing him or her that the governance of state cannot be carried on as per the provisions of the Constitution and advises him to impose a president's rule in the state. Such a situation has arisen in all states at one time or another. The governor, then, acts as the agent of the president and rules on his behalf. C. In reserving certain bills for the consideration of the president. Article 200. The governor can reserve a bill even after it being passed by the state legislature for the president's consideration if he or she feels the need to do so. Like the president, it is the governor who preserves, protects, and defends the Constitution and the law in states. In normal circumstances, the governor has to act as a constitutional or nominal head, thanks to the parliamentary tradition. But when emergency is declared, especially under Article 356, the governor rules the state at the dictate of the union government and in the name of the president. Asterisk. Things worked well until the same political party ruled at the center and the state. But with different political parties in power at the two levels, there arose the demand for state autonomy and a review of the role of governor. The results have been center-state tensions and the constitution of different commissions, reviewing the center-state relations. 4. B. The State Council of Ministers, Cabinet, and the Chief Minister. Article 163 of the Constitution says that there shall be a Council of Ministers with the Chief Minister as its head to aid and advise the governor in the exercise of his functions, except those where he exercises his discretion. This article also says that the advice given to the governor by the Council of Ministers would not be questioned in any court of law. This is clear from Article 163 that the governor, in normal circumstances, acts on the advice of the Council of Ministers. Normal circumstances mean the situations where the governor has no discretion. But in situations where he has discretionary powers, the governor acts on his own. Before a Council of Ministers is constituted, the governor has to appoint a chief minister, Article 164, who is usually the person who commands the majority support in the state legislative assembly. After the appointment of the chief minister, the governor appoints other ministers on the recommendations of the chief minister. The State Council of Ministers exercises all executive powers in the name of the governor, formulates policy with regard to the state administration, makes recommendations with regard to all major appointments in the state, carries on the state administration, and helps make legislation in the state. The Council of Ministers is collectively responsible to the state legislative assembly. The chief minister in a state is like the prime minister at the center, the real executive head in the state. He presides over meetings of the state cabinet, allocates departments among state ministers, and supervises their functioning. He is a link between the governor and the State Council of Ministers. Article 167 of the Constitution prescribes the following duties of the chief minister. I. To communicate to the governor all decisions of the State Council of Ministers relating to administration. 2. To furnish such information relating to the administration and proposal for legislation as the governor calls for. 3. To submit, if the governor so requires, for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council of Ministers. The administration national level. In addition to the real executive, i.e. the Council of Ministers, there are numerous committees such as I. The Cabinet Committee with Cabinet Secretariat, 2. Central Secretariat, 3. Prime Minister's Office, which helps the executive administration, thus reducing the burden of the cabinet. I. The Cabinet Secretariat is a staff agency, operating under the direction and leadership of the Prime Minister, one that does the important coordinating role in the process of policymaking. The Secretariat enjoys the position of a Department of Government of India under the Allocation of Business Rule, 1961. It is headed by the Cabinet Secretary, the ex officio chairman of the Civil Services Board. The Secretariat has 3 wings: civil, military, and intelligence. The civil wing aids and advises the Union Cabinet. The military wing assists the Defense Ministers Committee. The intelligence wing deals with the matters relating to the Joint Intelligence Committee. Since the Bharatiya Janata Party's dominance, the National Democratic Alliance, 2014, Narendra Modi has taken over the reins of the government. Since the Bharatiya Janata Party's dominance, the National Democratic Alliance, 2014, Narendra Modi has taken over the reins of the government. The number of cabinet committees have been reduced from 10 to 6. These 6 cabinet committees are Appointment Committee, Committee on Accommodation, Committee on Economic Affairs, Committee on Parliamentary Affairs, Committee on Political Affairs, Committee on Security. Each of these committees is chaired by the Prime Minister, and each committee has 3 to 8 cabinet ministers. The Cabinet Secretary, as head of the Secretariat, performs certain functions which mainly are providing assistance to the Council of Ministers, acting as advisor and conscience keeper of the civil services, handling senior appointments, preparing the agenda of the Cabinet, attending the meetings of the Cabinet, ensuring that the Cabinet decisions are implemented, advising the Prime Minister, providing the elements of continuity and stability. The Central Secretariat. The Central Secretariat is guided by the mantra minimum government and maximum governance, which expects every civil servant to work every inch of his job, a 5-day week, even mostly working on Saturday, seeking outcome/result on every work done. The Central Secretariat is a collection of officers of various ministries' departments, each ministry working with its own secretary. There are senior officials working under its secretary holding charge of divisions, sections, and their respective offices. The functions of the Central Secretariat are providing data about policies to the ministers, assisting the ministers in their legislative and administrative work, carrying out a detailed scrutiny of the problems raised. 3. Working as a link between the government and other concerned agencies/bodies. 4. Making the sectoral planning. The Prime Minister's Office. The PMO provides the secretarial assistance to the Prime Minister and is headed by the Prime Minister and administratively by the Principal Secretary. The PMO plays an important role in the decision-making process while providing crucial advice to the Prime Minister. Over the years, the PMO has emerged as a center of power. The fact of the matter is that the PMO controls the entire administration. It issues directives and instructions to various secretaries. The Prime Minister himself remains in touch with the top officials of the government. The PMO has become the control room of the whole administration, controlling all the powers unto Prime Minister himself. Mostly the ministers are ministers who are usually ready to defend their Prime Minister. However, the PMO is becoming an agent of change, the change scripted by PM Modi. Practice questions. 1. How is the President of India elected? 200 to 250 words. 2. Describe the executive, legislative, judicial, and financial powers of the President of India. 700 to 800 words. 3. Write a note on the emergency provisions as contained in the Constitution of India. 200 to 250 words. 4. What is, in your opinion, the position of the Indian President? What role does he play in the Indian political system? 700. 800 words. 5. Write a brief note on the Vice President of India. 200 to 250 words. 6. How is the Council of Ministers formed in India? What is the role of the Prime Minister in the composition of the Council of Ministers? 2013, 700 to 800 words. 7. Describe the position of the Prime Minister in a coalition regime in the Indian political system. 700 to 800 words. 8. Examine the impact of coalition politics on Indian political system. 2012, 700. 800 words. 9. How is the governor of a state appointed? Describe his role. 700 to 800 words. 10. Write a note on the Chief Minister of a state. 200 to 250 words. The legislature in India, Parliament of India, and legislatures in states make laws. In addition to this, the legislatures control the executive and finances of the state. They represent the people and provide a forum where the grievances of the people are heard and addressed to. In India, the legislature at the union level consists of 2 houses, the Council of States and the House of the People. In states, some states have 2 chambers, the Legislative Assembly and the Legislative Council. Others have only 1 chamber, the Legislative Assembly. 7. The function of legislature in a democratic system is to the Indian Parliament. A. The Council of States. The Indian Parliament, Article 79 says, consists of the President and 2 houses, A. The Council of States or the upper house, and B. The House of the People or the lower house. The total strength of the Council of States can be 250 members, out of which 12, distinguished in the field of literature, science, art, and social service, are nominated by the President, and the remaining 238 are representatives of states and the Union territories, elected in accordance with the provisions prescribed in the 4th Schedule, i.e., elected by their respective state legislative assemblies on the basis of the population of the states. Hence, the larger the state, the more its representatives in the Council of States, and the smaller the state, the less its representatives in the Council of States has. Uttar Pradesh has 31 representatives, Maharashtra 19, Manipur 1, Sikkim 1, for example. At present, there are 233 members in the Council of States, from the states, and 12 nominated by the President, November 2014. Article 83 makes it clear that the Council of States is not to be dissolved, but 1/3 of its members retire every 2 years. In accordance with Article 84, the qualifications for a Council of States Rajya Sabha member are as follows. The candidate should be A citizen of India. B. Not less than 30 years of age. C. Should possess such other qualifications as may be prescribed by Parliament from time to time. B. The House of the People. The House of the People, also called the Lok Sabha, is the lower house of Parliament directly elected by the people. Its total strength is 530 members elected by the people from states, 20 from the Union territories, and 2 nominated by the President if he is satisfied that the Anglo-Indian community has not been properly represented. Here also, the larger the state, the more are its members in the House of the People. Article 80. There were, in November 2014, 542 members. Article 83 prescribes the tenure of the House of the People as 5 years, unless dissolved earlier. During air emergency, its tenure can be extended for a period not exceeding 1 year. Article 84 prescribes qualifications of the members of the House of the People which are similar to those of the Council of States, except that for the candidate of the House of the People, the minimum age has to be 25 years. IEC, disqualification and vacation of seats. A person shall be disqualified for election as a member of Parliament. Article 102. If he holds an office of profit under the Government of India or the government of a state other than an office declared by Parliament by law not to disqualify its holder. 2. If he is of unsound mind and stands so declared by a competent court. 3. If he is an undischarged insolvent. 4. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under acknowledgement of allegiance or adherence to a foreign state. If he is so disqualified by or under a law of Parliament. Through the Representation of People Act, 1951, the Parliament has specified certain other disqualifications. 1 should not be guilty of an election offence. 1 should not have undergone imprisonment for 2 or more years. 1 should not have been dismissed from government service. 1 should not have been guilty of inciting communal feelings and should not have been preaching or practicing untouchability. In addition to the above, disqualification would follow if 1 has violated the defection law 10th schedule, absented himself for a period of 60 days from the meetings of either of the 2 houses without permission. Article 101. The seat of a member of Parliament is considered vacant if 1 has dual membership in Parliament or if 1's election is declared void by a court or if 1 is expelled by the House. Presiding officers of Parliament. The Speaker presides over the meetings of the House of the People, Article 94, and the Vice President, as the ex officio chairman, presides over the meetings of the Council of States, Article 89. The Council of States elects its deputy chairman and the House of the People elects its Speaker and deputy Speaker for conducting the proceedings of the respective houses. The deputy chairman presides over the meetings of the Council of States in the absence of the chairman. Likewise, the deputy Speaker presides over the meetings of the House of the People in the absence of the Speaker. There is a provision for the office of Speaker pro tem who is appointed by the President and who is usually the senior-most member of the House of the People after general elections. After the Speaker is elected, Speaker pro tem vacates the office. This is done at the first sitting of the House of the People after it is constituted following general election. The presiding officers of the Houses of Parliament supervise the legislative proceedings, maintain decorum and discipline in the House, interpret the rules of procedures and parliamentary precedents, adjourn the House in the absence of quorum, and exercise their casting vote. I.e. houses, their working. The 2 chambers of the Parliament function in a manner as prescribed by rules and regulations. They observe traditions and work through their officials. The usual practices in the Parliament can be briefly describable as under. Officials. There is a leader of the House in the House of the People, Lok Sabha, usually the Prime Minister. There is a leader of the House in the Council of States, usually a minister of cabinet rank. Deputy leaders of the houses are also nominated. These leaders help conduct business in the House. In each House, there is a leader of the opposition, usually the leader of the largest opposition party, who provides constructive criticism of the policies of the government. Each political party in each House of the Parliament controls its respective party members through their officials called the party whip. Party whip is charged with the responsibility of ensuring the attendance of his party members in large numbers and securing their support in favor of or against particular issues. He regulates and monitors their behavior in the Parliament. The members are supposed to follow the directives of the whip. Otherwise, disciplinary action is taken. Sessions of Parliament. The summoning of the sessions of Parliament is done by the President, Article 85. He can prorogue either house of the Parliament. He also has the power to dissolve the House of the People, usually on the advice of the Prime Minister, but not of one who has lost a confidence vote in the House. The Constitution says that the duration of gap between meetings of the House should not exceed 6 months. Adjournment means suspension of work. When suspension of the work is done for a specified time, say a few hours, days, or weeks, it is called adjournment, but when it is done without specifying definite time, it is called adjournment sine die. Both types of adjournment are ordered by the presiding officers of the Houses. Prorogation means terminating the sittings for the period of the session. This is done by the President without affecting the fate of bills pending before the House. Dissolution is termination of the House for the period of its regular tenure. It means new elections. This is done by the President only in the case of the House of the People. The Council of States is not dissolved. In case the House of the People is dissolved, the position with respect to the pending bill is given as following. I. A bill pending in the Lok Sabha lapses, whether originating in the Lok Sabha or transmitted to it by the Rajya Sabha. 2. A bill passed by the Lok Sabha but pending in the Rajya Sabha lapses. 3. A bill not passed by the two houses due to disagreement and if the President has notified the holding of a joint sitting before the dissolution of Lok Sabha does not lapse. 4. A bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse. V. A bill passed by both houses but pending assent of the President does not lapse. 6. A bill passed by both houses but returned by the for reconsideration of houses does not lapse. Quorum of each house is 1/10 of its total membership. Devices of parliamentary proceedings. Categories of questions are I. Starred questions. These questions have to be answered orally on the floor of the House. They carry an asterisk mark. 2. Unstarred questions. These questions are answered in a written form. They do not carry the asterisk mark. 3. Short notice questions. These questions pertain to matters of urgent public importance and can be asked with notice of less than 10 days. Question hour. The first hour of sitting in both houses of Parliament is known as question hour. During the question hour, members of Parliament have the right to ask questions on administrative and governmental policies related to national and international matters. Questions asked in the houses are generally addressed to ministers. These questions can be categorized as starred questions, unstarred questions, or short notice questions. A member has to give a notice to the Secretary General of the concerned House that he wants to ask a question. 0 hour. It is the time immediately after the question hour in both houses of Parliament. It starts at 12 noon. It came to be called an hour also because very often it continues for 1 full hour until the House rises for lunch at 1 p.m. However, the duration of the 0 hour has varied over the years. It is not possible to predict what kind of matters might be raised during 0 hour as there is no mention of any 0 hour in the rules of Parliament. It is the press which coined the term 0 hour during the early 1960s when the practice of raising urgent matters of public importance without prior notice developed. Half-an-hour discussion. Half-an-hour discussion can be held on a matter of sufficient public importance which has been the subject of recent questions in the Lok Sabha. Usually, the discussions take place in the last half an hour on Mondays, Wednesdays, and Fridays. In one session, a member is allowed to raise not more than 2 half-an-hour discussions. Motions. A member may introduce a motion in the form of a proposal. It is, thus, a proposal for eliciting or expressing the opinion of the House on a matter of public importance. Every question to be decided by the House must be proposed as motion. The consent of the Speaker or the Chairman is essential to initiate a motion. A motion passes through 4 stages. I. Tabling of the motion. 2. Posing of questions by the Speaker/Chairperson. 3. Debate or discussion on permissibility of the motion. 4. Vote or decision of the House. Government motions generally aim at obtaining approval of the House for some policy or action. Motions moved by private members focus on eliciting opinion of the House on a particular matter. Motions fall into 3 categories: substance, substitute, subsidiary. A substitute motion is moved in lieu of an original motion. It proposes an alternative to the original motion. A subsidiary motion is a follow-up motion on some proceeding in the House. Subsidiary motions have no relevance independent of the original motion. Subsidiary motions are further divided into 3 categories: I. Ancillary motion, 2. Superseding motion, and 3. Amendment. Call attention motion. It is the right of every member with prior consent of the Speaker or the Chairman to call for the attention of a minister on a matter of urgent public importance. This unique Indian concept of calling attention allows members to highlight failure or inadequate action of the government on an important matter of public importance. This procedural device is similar to an adjournment motion without its censure aspect. The minister is allowed to make a brief statement or request a later date for making a statement. Adjournment motions. In parliamentary parlance, adjournment means a break or termination of debate on a motion/resolution/bill in the House. It may also mean a brief break during a sitting of the House. Adjournment sine die means termination of the sitting without any definite date being fixed for the next sitting. No date named motion. If the Speaker admits notice of a motion but no date is fixed for its introduction, then it is called a no day yet named motion. It is placed before the Business Advisory Committee, which allots the time for discussion on the motion. Government motions get precedence over private members' motions as no day yet named motions are discussed at the government's time. No confidence motion. The changing political composition of Parliament has led to a new procedure known as the motion of confidence in the Council of Ministers. This practice has evolved in recent times and takes place whenever no single political party is in a position to command the majority of the House. The procedure followed is as follows: a one-line motion under Rule 184 that this House expresses its confidence in the Council of Ministers is moved by the Prime Minister on the direction of the President. The Council of Ministers remains in office as long as it enjoys the confidence of the Lok Sabha. If the Lok Sabha expresses a lack of confidence in the Council of Ministers, the government is constitutionally bound to resign. In order to ascertain the confidence, the rules provide for moving a motion to this effect, which is called a confidence motion. A motion of no confidence, once admitted, has to be taken up within 10 days of the leave being granted. Rajya Sabha is not empowered to entertain a motion of no confidence. Censure motion. A censure motion is a distinct type of no confidence motion. While a motion of a no confidence need not specify any ground on which it is based, a censure motion must reveal the ground on which it is based. This type of motion is moved specifically for censuring the government's certain policies actions. A censure motion can be moved against the Council of Ministers or a minister for the failure to act or not to act or for a policy and may express regret, indignation, or surprise of the House at the failure of the minister. 1. F. Bills and legislative procedures in Parliament bills. The draft of a legislative proposal is known as DIL. No bill, whether it is introduced by the government or a private member, can become a law or an act of Parliament until it receives the assent of the President. Broadly, there are two types of bills. Government bill. A bill is known as a government bill if it is initiated by the government. 2. Private member's bill. If a bill is sponsored by a member who is not part of the Council of Ministers is referred to as a private member. In either House of Parliament, it is known as a private member's bill. Although most laws are made through government bills, private members' bills serve the purpose of highlighting changes needed in existing laws or the need for a particular legislation. Bills may be further classified on the basis of their content. The classification is as follows. A. Ordinary bill. Any bill which is not a Constitution Amendment bill or a money bill is classified as an ordinary bill. The following are the different types of ordinary bills. I. Original bills embodying new proposals, ideas, or policies. 2. Amending bills to modify, amend, or revise existing acts. 3. Consolidating bills to consolidate existing law on a particular subject. 4. Expiring laws, continuance bills to continue an expiring act, and V. Bills to replace ordinances issued by the President. B. Money and financial bills. Money and financial bills are treated separately from other bills because of their special features. C. The Constitution Amendment bills. These refer to bills that seek to amend the Constitution. Different types of bills. Ordinary bill. An ordinary bill has to pass through different stages before it becomes a law. In both the houses, the bill goes through first reading. During the first reading, the bill is introduced by the minister in charge of the concerned department after the Speaker grants permission to do so. The bill is then published in the Gazette of India. If the bill has already been published in the Gazette with the Speaker's assent, the stage of introducing the bill in the House can be bypassed. Second reading. The second reading is the most vital stage for the bill because it is scrutinized thoroughly during this period. This reading is divided in two stages. The first stage. At this stage, only the proposals of the bill are discussed. There is no in-depth discussion about the details of the bill. The bill may be referred to a select committee of the Lok Sabha or a joint committee of the Houses with the concurrence of Rajya Sabha and/or may be circulated for eliciting opinion. The committees are appointed on a temporary basis in order to consider bill referred to them. At this time, either of the two houses might refer the bill to departmentally related joint standing committee of both houses. This committee considers the bill clause by clause and its members can move amendments to various clauses. The committee can also take evidence of experts, associations, or public bodies who are interested in the subject. After each clause and schedule has been considered and adopted by the committee, the Lok Sabha Secretariat prepares a report. This report is presented to the House for its consideration. Eliciting opinion. If a motion is passed in Parliament requiring a bill to be circulated to elicit the opinions of local bodies, associations, individuals, or institutions, The Secretariat of the House circulates letters to all state governments and union territories asking them to publish the bill in their respective local gazettes. The period for eliciting opinion is generally mentioned in the motion. If no motion is made, the state governments have to send the opinions within 3 months of the motion adopted. The opinions are then tabled in Parliament. The bill again goes through the committee stage. At this point, the House can debate on the bill as reported by the committee. The debate is confined to the bill as reported by the committee. The second stage. After the House decides to debate the bill as reported by the committee, the members discuss each clause of the bill separately. They can also amend the clauses. This is a long process where each clause and amendment is discussed, adopted or rejected by the House. If an amendment is accepted, it becomes a part of the bill. Third reading. At this stage, the bill is discussed solely to determine whether to approve or reject it. Only certain verbal, formal consequential amendments are allowed to be moved at this stage. In order to pass an ordinary bill, simple majority of members present and voting is required. Once the bill has been approved by the originating House, it is sent to the other House. It goes through all the 3 stages again. In case a bill is passed by the originating House but rejected by the other House, the President has the power to call a joint sitting of the 2 houses. The decision to accept or reject a bill is taken by the majority of the total number of members of both houses present and voting. After both houses of Parliament pass a bill, it is presented to the President for his assent. If the President does not agree to sign the bill, he can send it to the originating House with his suggestions. If the 2 houses of the Parliament pass the bill again with or without incorporating the suggestions of the President, he has to give his assent. However, the President generally acts on the advice of the Council of Ministers, so he generally does not withhold his assent. He has the right to seek information and clarification about the bill. If the President gives his assent, the bill becomes an act. Money bill. According to the Constitution of India, Article 110, a bill is considered to be a money bill if it contains provisions dealing with all or any of the following matters. A. The imposition, abolition, remission, alteration, or regulation of any tax. B. The regulation of money borrowed by the Government of India or a guarantee given by the Government of India. The bill can also consider amendment of the law with respect to financial obligations undertaken or to be undertaken by the Government of India. C. The custody of the Consolidated Fund or the Contingency Fund of India, the payment of monies into or the withdrawal of monies from any such fund. D. The appropriation of monies out of the Consolidated Fund of India. E. The declaring of a new item to be expenditure charged on the Consolidated Fund of India. Also, if there is any increase in the amount of any such expenditure. F. The receipt of money on account of the Consolidated Fund of India or the public account of India or the custody or the issue of such money or the audit of the accounts of the Union or of a state or G. Any matter incidental to any of the matters specified in subclauses A to F. A money bill can only be introduced in the Lok Sabha on the recommendation of the President. However, the Speaker of the House has the final authority to decide whether a bill is a money bill or not. A money bill cannot be introduced in Rajya Sabha, nor can it be referred to a joint committee of houses or be considered at a joint sitting of the 2 committees. Once a money bill is passed in the Lok Sabha, it is sent to the Rajya Sabha. The Rajya Sabha may not amend a money bill but can recommend amendments. A money bill should be returned to the Lok Sabha within 14 days or the bill is deemed to have been passed by both houses in the form it was originally passed by the Lok Sabha. The Lok Sabha has the discretion to accept or reject the amendment recommended by the Rajya Sabha. The President does not have the power to return a money bill for reconsideration. He has to give his assent to the money bill as passed by the Parliament. Financial bill. A bill relating to revenue or expenditure is a financial bill. Those bills which make provisions for any of the matters specified in the money bills but do not contain solely those matters are known as financial bills. For example, a bill contains taxation clause but does not deal solely with taxation. Financial bill also includes matters involving expenditure from the Consolidated Fund of India. The difference between a money bill and a financial bill is merely technical. All financial bills are not money bills. A. Financial bill is considered to be a money bill solely when it contains matters specified in the Constitution for a money bill. Only those financial bills would be considered as money bills which are certified by the Speaker. A financial bill which contains any matter specified for a money bill but does not deal exclusively with such matters has 2 features in common with a money bill. I. It cannot be introduced in the Rajya Sabha. 2. It cannot be introduced only with the recommendations of the President. But if the bill is not classified as a money bill, the Rajya Sabha has full powers to reject or amend it as it does in the case of an ordinary bill. In the case of disagreement over a bill between the houses, the President can call for a joint sitting to resolve the deadlock. A financial bill which involves expenditure from the Consolidated Fund of India is treated in the same manner as an ordinary bill. Hence, it can be introduced in both houses and the Rajya Sabha has full power to reject or amend it. It also does not require the recommendation of the President for its introduction. However, the president's recommendation is necessary before the bill can be passed by both the houses. As the name suggests, an appropriation bill seeks to give legal authority to the government to appropriate expenditure from the Consolidated Fund of India. The Constitution says that no money can be withdrawn from the Consolidated Fund without the enactment of a law by the Parliament. A bill that incorporates demands for grants voted by the Lok Sabha as well as expenditures charged on the Consolidated Fund is introduced in the Lok Sabha. This bill is known as the Appropriation Bill. It is passed in the same manner as any other bill. But no amendments can be proposed to the bill. After the bill is passed by the Lok Sabha, the Speaker certifies it as a money bill. The Rajya Sabha can make recommendations over the bill, but it does not have the power to amend or reject the bill. Therefore, the bill is presented to the President for his assent. Finance Bill. A finance bill incorporates financial proposals of the government for the following year. It is ordinarily introduced in the Lok Sabha every year, immediately after the budget is presented. Discussions on the bill are restricted to matters relating to general administration and local grievances within the sphere of responsibility of the Union government. No discussion is permitted on the details of particular estimates. This bill has to be considered and passed by the Parliament and assented to by the President within 75 days after its introduction. This bill is certified as a money bill. Thus, Rajya Sabha can only make recommendations to the bill. It is up to the Lok Sabha to accept or reject such recommendations. I.g. Budget. A budget is an annual financial statement or an estimate of receipts and expenditure of the Government of India. It is presented for the ensuing financial year, which at present begins on the 1st of April every year. The budget includes an estimated inflows and outflow of the government for 3 years. It gives the actual expenditure for the preceding year, the revised estimates for the current year, and the budget estimates for the next year. The pre-budget economic survey is prepared by the Finance Ministry. The survey studies the overall economic development in the country. It mainly focuses on areas like banking, capital markets, prices, industry, agriculture, and infrastructure. Other topics include trends in gross domestic product, GDP, demand and supply factors, fiscal developments, to name a few. The overall responsibility of preparing the budget rests with the Budget Division within the Finance Ministry. The division takes cognizance of the availability of funds as well as proposals from numerous departments and ministries. It also consults the Comptroller and Auditor General. The budget needs the approval of the Prime Minister before it can be presented in the Lok Sabha. The President decides on which day the budget is to be presented. By convention, it is presented on the last day of February. The budget is presented in 2 parts. I. Railway budget pertaining to the railway finance. 2. General budget, which gives an overall picture of the financial position of the Government of India, excluding the railways. The railway budget and the general budget are presented in the Lok Sabha by the Minister of Railways and the Minister of Finance, respectively. The speech announcing the general budget is divided into 2 parts. Part A, dealing with the general economic survey of the country, and Part B, containing the taxation proposals for the ensuing financial year. Following the budget presentation, the annual financial statement relating to the Government of India, duly authenticated by the Finance Minister, is laid on the table. Also, the Finance Bill is introduced at this time. The procedure of the approval of the general budget involves numerous steps. These are: A. Presentation of budget. The Finance Minister introduces the budget in the Lok Sabha in February with a speech giving an overview of the budget. A copy of the budget is laid on the table of the Rajya Sabha at the conclusion of the Finance Minister's speech in the Lok Sabha. There is no discussion of the budget on the day on which it is presented. B. Discussion on budget. The Parliament allots the time for a discussion after the presentation. The budget is discussed in 2 stages, a general discussion followed by a detailed discussion and voting on the demands for grants. Besides, there are other opportunities for further discussions on financial proposals during the consideration and passing of the Appropriation Bill and Finance Bill. The Rajya Sabha is restricted to discussing the budget in general terms. C. Voting on demands. After the prescribed period of debate is over, the Speaker uses his power to stop all discussions and puts all outstanding demands for grants to a vote. This power is known as guillotine. A voting on demands is the exclusive power of the Lok Sabha. The demands for grants are subjected to cut motions by members of the Lok Sabha. D. Appropriation Bill. This bill is introduced after all demands for grants are passed by the Lok Sabha. The bill paves the way for the enactment of an Appropriation Act and is certified as a money bill. It allows the government to withdraw money from the Consolidated Fund of India. E. Finance Bill. This bill includes all taxation proposals including amendments and paves the way for enacting the Finance Act. A brief description of vote on account, demands for grants, and types of cut motions is given below. Vote on account. If the budget is not approved by the 1st of April or the current financial year, the Indian Constitution allows the Lok Sabha to grant a vote on account. Generally, the passage of budget crosses the beginning of the financial year and it becomes necessary for the government to have enough funds to run the administration of the country. So, the government uses the special provision of vote on account which empowers the Lok Sabha to make a grant in advance for a part of the financial year, pending the completion of the budgetary process. Normally, the vote on account is granted for 2 months for a sum equivalent to 1/6 of the estimated expenditure for the entire year under various demands for grants. During an election year, the vote on account may exceed that period. This provision is invoked once a general discussion on the budget is over and before the discussion on demands for grants is taken up. In the case of the railway budget, which is passed before 31st of March, no vote on account is needed except during an election year. Demands for grants can be defined as requests by the executive to the Lok Sabha for authority to spend the amount asked for. Thus, they are related to the expenditure part of the budget. The demands have to be made in the form of a motion. Members may disapprove of a policy pursued by ministry or suggest measures for economy in the administration or focus attention of the ministry to specific local grievances. Members can do so by moving subsidiary motions called cut motions. 3. Types of cut motions. There are 3 types of cut motions. Disapproval of policy cut. This is the most drastic of them all because it says that the amount of demand be reduced to Re1. A member of parliament has to give precise reasons for such a cut. Economy cut. This motion means that a member would like to reduce expenditure by making a specific cut in the grant demanded. The form of this motion is that the amount of demand be reduced to Rs. Token cut. This motion is widely used by members. Its objective is to voice a grievance for which the government of India is responsible. The motion says that the amount of the demand be reduced to 100 rupees. Hence, cut motions are tools to initiate a discussion on demands for grants. Once the discussions are over, the cut motions are disposed of. Thereafter, the demands for grants are put to a vote of the House. NH powers. Legislative powers and functions of the Parliament extend to making laws on subjects contained in the Union List, Concurrent List, and residuary subjects. In certain cases, the Parliament can make laws on subjects in the State List. The 2 houses have equal legislative powers. An ordinary bill can originate in any of the houses, but to become a law, it must be passed by both houses. In the event of a disagreement between the 2 houses on an ordinary bill, the President, under Article 108, may convene joint meeting of the 2 houses to be presided over by the Speaker of the House of the People, and decision may be taken by a majority of the total members of both houses present and voting. So far, 3 such joint meetings have been held. The Council of States has the exclusive power under Articles 249 and 312 to authorize the Parliament to make laws, A. on a subject in the state list, B. to create a new All India service. Executive powers and functions of the Parliament include control over the ministers by asking questions, supplementary questions, and passing adjournment motions. During the period of the 14th Lok Sabha 2004 to 2009, as many as 85,448 questions were asked. 64 members of the Lok Sabha had never asked any question. Among them were members such as L.K. Advani, Atal Bihari Vajpayee, Mamta Banerjee, H.D. Deve Gowda, Ajit Singh, and actors Govinda and Dharmendra. See Hindustan Times, dated February 26, 2009. It is the House of the People which can force the Council of Ministers to resign by passing a vote of no confidence. The financial powers of the House of the People are more than those of the Council of States. A money bill originates in the House of the People, and after it is passed there, it goes to the Council of States, which has 14 days to consider the bill. The House of the People may accept or reject the recommendations, and its decision effectively means the passing of the money bill from both houses. Article 109. The electoral powers and functions of the houses are, by and large, equal. Both participate in the elections of the President and the Vice President. And amending the Constitution, the 2 houses possess equal powers as they do in approving the emergency provisions. By way of conclusion, it may be stated that the House of the People, by being a popularly elected house, has an edge over the Council of States, though the latter has exclusive powers with respect to Articles 249 and 312. Though the Lok Sabha, as a popularly elected house, enjoys more powers than the Rajya Sabha, it would be injudicious to regard the Rajya Sabha as an insignificant chamber. The Rajya Sabha is important insofar as it acts as the second chamber, helps reconsider hasty and rashly discussed bills, delays when it is necessary, deliberates matters of national importance, represents the federation units in contributing its rule to the development of the nation, relieves the burden on the first chamber by initiating and discussing relatively less important bills. The Parliament, as the legislative organ of the country, has, as Granville Austin, working of a democratic constitution, a history of the Indian experience, points out, united Indians into one mass electorate having universal adult franchise by providing for the direct representation of the voters in genuinely popular assemblies. The parliament represents the mass of Indians, uniting them all on one platform irrespective of their diversities. It is one forum where all speak as Indians. As a legislative body which makes laws on subjects contained in the Union list and, on residuary powers on subjects in the concurrent list if it finds necessary and on subjects in the state list during abnormal times. However, our parliament is not as supreme a legislative body as the British Parliament, thanks to the constraints of a quasi-federal polity which we have adopted. The Indian Parliament is not a sovereign legislative body because its laws can be declared void if they are contrary to the Constitution. The framers of the Indian Constitution did not intend making the Parliament a supreme legislative body, but they did make the Constitution as the supreme law of the land. The Parliament's authority to amend the Constitution has, of late, been admitted by the Supreme Court, and yet it has been barred from interfering with the basic structure of the Constitution. The power of judicial review, too, restricts the power and position of the Parliament. The compulsions of politics have made the executive organ of the government dominant over the legislative organ. The ever-enhancing powers of the executive have hijacked the powers of the legislature. The more organized and disciplined a majority political party is, the more are its chances of making the legislature its annex. The power of delegated legislation has served to strengthen the position of the executive at the cost of the legislature. The legislature's powers are, by and large, on the decline, relegating to the stature of either debating society or a platform ventilating the grievances of the people. Relationship between the executive and the legislature, in any form of polity, whether parliamentary, presidential, or semi-parliamentary, is always important in governance. The Indian president as the constitutional head is part of the parliament. See Article 79. As such, he/she convenes the sessions of the parliament, prorogues it, and dissolves the Lok Sabha. Article 85. She has the right to address and send messages to parliament. Article 86. He/she assents bills to make them laws. Article 111. He/she promulgates ordinances during the recess of Parliament. Article 123. But the President does not participate in the proceedings of Parliament, nor can he/she stop a bill from becoming a law. At best, he/she can send the bill back for reconsideration of the Parliament, but he/she has to sign the bill when it is presented again for his/her assent. The President cannot refuse to give assent to a money bill, though his/her prior permission is necessary for the introduction of the money bill in the House of the People, Lok Sabha. The President does have real powers relating to Parliament and legislation, but theoretically all powers are vested in him/her as the head of the state, i.e., as the constitutional head. Relationship between the real executive, the Council of Ministers headed by the Prime Minister, as in India, in the parliamentary system of government on the one hand and the Parliament on the other, is more important. In our country, the President appoints the Prime Minister who commands or can command the majority support of the Parliament, especially the House of the People, though the Prime Minister may not be the member of the Lok Sabha as Dr. Manmohan Singh is not. The President also appoints other members of the Council of Ministers on the advice of the Prime Minister. As members of the Council of Ministers headed by the Prime Minister is collectively responsible to the House of the People, the ministers are taken from the Parliament. Those who are not members of Parliament must seek membership of either House of the Parliament within 6 months of assuming office, and are responsible as a team to the Lok Sabha and individually to the Prime Minister. The Parliament controls ministers by asking questions, supplementary questions, and moving and passing adjournment motions. A censure motion, cut or motion, a vote of no confidence by the House of the People leads to resignation of the Council of Ministers. Thus, the real executive, i.e., the Council of Ministers in India, is not only a part of the Parliament but is also accountable to it. As part of the Parliament, the Council of Ministers with the leadership of the Prime Minister gets legislations and budgets passed by the Parliament with the majority support and ultimately makes the Parliament work in the way it wants. Instead of controlling the Council of Ministers, the Parliament is controlled by the Council of Ministers. The working of Parliament in India has witnessed, broadly speaking, 3 different phases. A. Parliament under one-party majority governments. B. Parliament under minority governments, and C. Parliament under coalitional governments. The first phase, under Nehru and Indira Gandhi as prime ministers, had a parliament which worked at the dictates of the Congress Party. Parliament was Congress and the Congress was Parliament, with the executive controlling the proceedings of the Parliament. The second phase, under Charan Singh, Chandra Shekhar, Narasimha Rao, Deve Gowda, and I.K. Gujral as prime ministers, found the executive relatively weak and the Parliament active, if not assertive. The third phase, under Atal Bihari Vajpayee and Dr. Manmohan Singh as prime ministers, found the executive working under constraints of the supporting political parties, sometimes conciliative. I. Committees of Parliament. The 2 houses of the Parliament work through committees. There are committees in each house and there are joint committees of the 2 houses. Ad hoc and standing committees. Parliamentary committees are of 2 kinds, ad hoc committees and standing committees. Ad hoc committees are appointed for a specific purpose and they cease to exist when they finish the task assigned to them and submit a report. Principal ad hoc committees are select and joint committees on bills. Others like the Railway Convention Committee, the Committee on Draft 5-Year Plans, and the Hindi Equivalence Committee were appointed for specific purposes. Apart the ad hoc committees, each House of Parliament has standing committees like the Business Advisory Committee, the Committee on Petitions, the Committee of Privileges, and the Rules Committee. Select and joint committees. When a bill comes up before a House for general discussion, it is open to that committee to refer it to a select committee of the House or a joint committee of the two houses. A motion has to be moved and adopted to this effect in the House in which the bill is tabled for consideration. In case the motion adopted is for a reference of the bill to a joint committee, the decision is conveyed to the other House requesting it to nominate members of the other House to serve on the committee. The select or joint committee considers the bill clause by clause just as the two houses do. Amendments can be moved to various clauses by members of the committee. The committee can also take evidence of associations, public bodies, or experts who are interested in the bill. After the bill has, thus, been considered, the committee submits its report to the House. Members who do not agree with the majority report may append their minutes of dissent to the report. Committee on Estimates. This committee consists of 30 members who are elected by the Lok Sabha every year from among its members. A minister is not eligible for election to this committee. The term of the committee is 1 year. The main function of the Committee on Estimates is to report what economies, improvements in organization, efficiency, or administrative reform consistent with the policy underlying the estimates may be effected and to suggest alternative policies to bring about efficiency and economy in the administration. From time to time, the committee selects such estimates pertaining to a ministry or a group of ministries or the statutory and other government bodies as it may deem fit. The committee also examines matters of special interest which may arise or come to light in the course of its work or which are specifically referred to it by the House or the Speaker. Committee on Public Undertakings. The Committee on Public Undertakings consists of 15 members elected by the Lok Sabha and 7 members of the Rajya Sabha. A minister is not eligible for election to this committee. The term of the committee is 1 year and its functions are A. To examine reports and documents of public undertakings. B. To examine reports, if any, of the Comptroller and Auditor General on public undertakings. C. To examine in the context of the autonomy and efficiency of public undertakings whether the affairs of the public undertakings are being managed in accordance with sound business principles and prudent commercial practices, and D. Such other functions vested in the Committee on Public Accounts and the Committee on Estimates in relation to the public undertakings as are not covered by clauses A, B, and C above, and as may be allotted to committee by the Speaker from time to time. The committee does not, however, examine matters of major government policy and matters of day-to-day administration of the undertakings. Committee on Public Accounts. This committee consists of 15 members elected by the Lok Sabha and 7 members of the Rajya Sabha are associated with it. A minister is not eligible for election to this committee. The term of the committee is 1 year. The main duty of the committee is to ascertain whether the money granted by Parliament has been spent by the government within the scope of the demand. The appropriation accounts of the Government of India and the audit reports of the Comptroller and Auditor General mainly form the basis for the committee's examination. Cases involving losses, nugatory expenditure, and financial irregularities come in for severe criticism by the committee. The committee is not concerned with questions of policy. It is concerned only with the execution of the policy laid down by the Parliament and its results. Business Advisory Committee, Lok Sabha. The Business Advisory Committee of the Lok Sabha consists of 15 members including the Speaker who is ex officio chairman. Members are nominated by the Speaker. Almost all sections of the House are represented on the committee as per the respective strength of parties in the House. The function of the committee is to recommend the time that should be allotted for discussion of such government legislative and other business as the Speaker, in consultation with the Leader of the House, may direct to be referred to the committee. The committee, on its own initiative, may also recommend to the government to bring forward particular subjects for discussion in the House and recommend allocation of time for such discussions. The decisions reached by the committee are unanimous in character and representative of the collective view of the House. The committee generally meets at the beginning of each session and thereafter as and when necessary. Committee on Private Members' Bills and Resolutions, Lok Sabha. This committee consists of 15 members and the Deputy Speaker is its chairman when nominated as a member of the committee. The committee is nominated by the Speaker. The functions of the committee are to allot time to private members' bills and resolutions, to examine private members' bills seeking to amend the Constitution before their introduction to the Lok Sabha, to examine all private members' bills after they are introduced and before they are taken up for consideration in the House, and to classify them according to their nature, urgency, and importance into 2 categories, namely, Category A and Category B, and also to examine such private members' bills where the legislative competence of the House is. Committee on Petitions, Lok Sabha. It consists of 15 members nominated by the Speaker. A minister is not nominated to this committee. The function of the committee is to consider and report on petitions presented to the House. Besides, it also considers representations from individuals and associations on subjects which are not covered by rules relating to petitions and gives directions for their disposal. VII. Committee on Subordinate Legislation, Lok Sabha. The committee consists of 15 members nominated by the Speaker. A minister is not nominated to this. Challenged. The committee thus performs the same function in relation to private members' bills and resolutions as the Business Advisory Committee does in regard to government business. The committee holds office for a term not exceeding 1 year. Rules Committee, Lok Sabha. The Rules Committee consists of 15 members including the Speaker, who is ex officio chairman. Members are nominated by the Speaker. The committee considers matters of procedure and conduct of business in the House and recommends amendments or additions to the rules of procedure and conduct of business in the Lok Sabha that are necessary. Committee on Privileges, Lok Sabha. This committee consists of 15 members nominated by the Speaker. Its function is to examine every question involving a breach of the privilege of the House or of members of any committee thereof referred to it by the House or by the Speaker. It determines the reference to the facts of each case whether a breach of privilege is involved and makes suitable recommendations in its report. 8. Committee on Government Assurances, Lok Sabha. This committee consists of 15 members nominated by the Speaker. A minister is not nominated to this committee. While replying to questions in the House or during discussions on bills, resolutions, or motions, etc., ministers at times give assurances or undertakings either to consider a matter or to take action or to furnish the House further information later. The functions of this committee are to scrutinize the assurances, promises, and undertakings given by ministers from time to time and to report to the Lok Sabha on the extent to which such assurances have been implemented and to see whether such implementation has taken place within the minimum time necessary for the purpose. Committee. The committee scrutinizes and reports to the House whether the powers to make regulations, rules, subrules, and bylaws conferred by the House or delegated by the Parliament are being properly exercised by the executive within the scope of the delegation. Joint Committee on Offices of Profit. This committee consists of 15 members. 10 members are elected from the Lok Sabha and 5 from the Rajya Sabha. The committee is constituted for the duration of the Lok Sabha. The main functions of the committee are to examine the composition and character of committees and bodies appointed by the central and state governments and to recommend what offices should disqualify and what offices should not disqualify a person for being chosen as and for being a member of either House of Parliament under Article 102 of the Constitution. X. Committee on Welfare of the Scheduled Castes and Scheduled Tribes. The Committee on Welfare of the Scheduled Castes and Scheduled Tribes consists of 20 members elected by the Lok Sabha and 10 members elected by the Rajya Sabha are associated with it. The term of the committee is 1 year. A minister is not eligible for election to this committee. The main functions of the committee are to consider all matters concerning the welfare of the scheduled castes and scheduled tribes failing within the purview of the Union government and the Union territories, to consider reports submitted by the National Commission for Scheduled Castes and Scheduled Tribes and to examine the measure taken by the Union government to secure due representation of the scheduled castes and scheduled tribes in services and posts under its control. She. Railways Convention Committee. The Railways Convention Committee is an ad hoc committee. It consists of 18 members. Out of these, 12 members are from the Lok Sabha nominated by the Speaker and 6 members are from the Rajya Sabha nominated by the Chairman. By convention, the Minister of Finance and the Minister of Railways are members of the committee. Besides, ministers of state in the Ministries of Finance and Railways are its members. The main function of the committee is to review the rate of dividend payable by the railways undertaking to general revenues as well as other ancillary matters in connection with the railway finance vis-a-vis general finance and make recommendations thereon. ZIL. Committee on Empowerment of Women. This committee came into being on April 29, 1997, as a consequence of identical resolutions adopted by both the Houses of Parliament on the occasion of International Women's Day on March 8, 1996. The committee consists of 30 members, 20 nominated by the Speaker from among members of the Lok Sabha and 10 nominated by the Chairman, Rajya Sabha, from among members of the Rajya Sabha. The term of the committee is 1 year. The committee has been primarily mandated with the task of reviewing and monitoring the measures taken by the Union government in the direction of securing women equality, status, and dignity in all matters. 13. Departmentally related standing committees. A full-fledged system of 24 departmentally related standing committees came into being in April 1993. These committees cover under their jurisdiction all ministries/departments of the Government of India. These committees include committees on commerce, home affairs, industry, and energy. Each of these standing committees consists of not more than 45 members, 30 nominated by the Speaker from among members of the Lok Sabha and 15 nominated by the Chairman, Rajya Sabha, from among members of the Rajya Sabha. A minister is not eligible to be nominated to these committees. Each committee has a term of 1 year. With reference to the ministries/departments under their purview, the functions of these committees are A. Consideration of demands for grants, B. Examination of bills referred to by presiding officers of the two houses. LL. State legislatures in India. In every state in India, there is a provision for a legislature, Article 168, which consists of the governor and a legislative assembly or legislative council or both. In the states of Andhra Pradesh, Bihar, Maharashtra, Karnataka, Telangana, Uttar Pradesh and Jammu and Kashmir, there are two houses, the Legislative Assembly and Legislative Council, and in all other states, there is the one house, the Legislative Assembly. Article 169 provides for the abolition or creation of a legislative council in a state by a parliament resolution passed by a simple majority in each house on a representation by the concerned state to the president. Article 3. There is proposal to have a legislative council in the state of Punjab. Article 170 says that the maximum strength of a state legislative assembly can be 500 and the minimum 60. It is this house which is directly elected by the people whose tenure, Article 172, is 5 years. Unless dissolved earlier, the tenure can be extended for a maximum period of 1 year during emergency. Qualification, privilege, and disqualifications measures of members of the Legislative Assembly are by and large the same as those of the members of the Lok Sabha. Article 171 says that the maximum strength of a legislative council shall be 1/3 of the strength of the Legislative Assembly of the state and the minimum 40. The Jammu and Kashmir Legislative Council has 36 members, while Andhra Pradesh, Bihar, Karnataka, Maharashtra, Telangana and Uttar Pradesh have 50, 75, 63, 78, 50 and 108 members respectively. The Legislative Council is constituted as follows. 1/3 of members are elected by the members of local bodies in the state, by municipalities, district boards, etc. 2. 1/12 are elected by graduates of 3 years, standing and residing within the state. 3. 1/12 are elected by teachers of 3 years standing in the state, not lower in standard than secondary school. 4. 1/3 are elected by members of the Legislative Assembly of the state from among persons who are not members of the Assembly, and the remainder are nominated by the governor from among persons who have a special knowledge or a practical experience of literature, science, art, cooperative movement, and social service. Article 171. Article 172 says that the Legislative Council is a permanent house and is not dissolved. Its members are elected for a period of 6 years, 1/3 retire every 2 years. The qualifications, privileges, and the disqualifications measures of the members of the Legislative Council are, by and large, the same as are of the members of the Rajya Sabha. The powers and functions of the state legislature extend to making laws on subjects enumerated in the state list and the current list. In case there is a law passed on a subject of the concurrent list by both the Parliament and the state legislature, the union law prevails and the state law becomes void to the extent it goes contrary to the union law. A bill has to be passed by the state legislature before it is presented to the governor, who either gives assent or withholds the bill or sends it back to the originating house or sends it to the president for his consideration. The bill can be sent to the president for his consideration for a second time. Article 201. The Legislative Assembly has more financial powers. A money bill is presented first in the Assembly. The Council has a 14-day period to consider it. The executive powers of the Assembly are more than those of the Council. The Assembly can force the State Council of Ministers to resign by passing a vote of no confidence. The Legislative Assembly also has special powers as follows. A motion of no confidence against the government in the state can only be introduced in the Vidhan Sabha Legislative Assembly. If it is passed by a majority vote, then the Chief Minister and his Council of Ministers must collectively resign. 2. A money bill can only be introduced in Vidhan Sabha. After it is passed in the Vidhan Sabha, it is sent to the Vidhan Parishad Legislative Council, where it can be kept for a maximum time of 14 days. Unless the Vidhan Parishad rejects it or 14 days lapse or suggestions made by the Vidhan Parishad are not accepted by the Vidhan Sabha, the bill is considered passed. The budget of the state is presented in the Vidhan Sabha by the finance minister of the state in the name of the governor of that state. 3. If a bill is passed by the Assembly for a C and time and sent back to the Council, and if the Council does not pass it within 1 month or the Assembly does not accept its recommendations for the second time, it is considered passed by both houses. There is a mechanism of joint meeting of the two houses to resolve the deadlock only on those bills originating in the Assembly and the Council not agreeing to them, but not for those bills originating in the Council, the Assembly rejecting them. The state legislature works through its committees in the same manner as the Parliament does. There are almost the same sort of officials in state legislature as in the Parliament. There is some kind of similarity between the powers of the Parliament and state legislature. When a deadlock between the two houses of Parliament takes place when the Council of States rejects the bill or its proposed amendments are not acceptable to the House of the People or the latter does not pass the bill within 6 months, the bill is considered passed. In the case of state legislatures, the time period is 3 months. The provision for a joint sitting of the two houses of parliament does not relate to the fact as to where the bill originated first, but in the case of state legislature, the provision for a joint sitting relates to the fact that the bill has originated in the assembly. Practice questions. 1. How is the Council of States organized? Who presides over its meetings? 250 words. 2. Account for the changes in the socio-economic profile of legislatures during the last 1 decade in India. 2014, 700 to 800 words. 3. How does an ordinary bill become a law? What are the stages through which it passes? 700 to 800 words. 4. What is a money bill? How is budget passed in the parliament? 700 to 800 words. 5. Compare the powers of the Council of States with those of the House of the People. 700 to 800 words. 6. Describe the powers and functions of the parliament. What is the role of the parliament in the Indian political system? 700 to 800 words. 7. Explain the role of the Council of States. 200 to 250 words. 8. Write a note on the Public Accounts Committee or the Estimate Committee. 200 to 250 words. 9. Explain the powers and functions of the state legislatures in India. 200 to 250 words. 10. Write a short note on the decline of Indian Parliament. 2013, 200 to 350 words. The judiciary in India, the Supreme Court, the High Courts, etc. And thereafter itself. Unbridled government is a threat both to the individual as well as to the society. Controlling itself amounts to keeping its organs in balance with one another. Montesquieu's theory of separation of powers had a point: when the 3 organs are separately managed, they are then well handled. Give any of the 2 powers to one person or assembly of persons, the system not only slides into tyranny but also endangers the people's liberties. The separation of judiciary from legislature and the executive ensures justice on the one hand and the balance of power on the other. 7. Government's first great job is to control the people. A balanced polity is one where the 3 organs of the state, legislature, executive, and equals judiciary plus equals function independently and in so doing ensure the balance between them. Legislature acts in such a manner that it keeps the executive in check. The executive functions in such a way that it keeps a balance with the legislature. Judiciary operates in such a fashion that it keeps both the executive and the legislature in their mandated role. Of the 3 organs, the role of judiciary is important. The test of a democratic polity depends, Bryce had once remarked, on the functioning of the judiciary. Speaking on the occasion of Golden Jubilee celebrations of the Supreme Court of India on January 28, 2000, the President of India said, "The judiciary in India has become the last refuge for the people, and the future of the country will depend upon the fulfillment of the high expectations reposed by the people in it." The Supreme Court of India. Introduction. Chapter 4 of Part 5, Articles 124 to 147 of the Constitution deals with the Union Judiciary, which largely relates to the Supreme Court of India. Article 124 of the Constitution says that there shall be a Supreme Court of India consisting of the Chief Justice and other judges whose number is prescribed by the Parliament through law passed from time to time. In 1950, the Supreme Court of India consisted of a Chief Justice and 7 judges. This number increased to 11 in 1956, 14 in 1960, 18 in 1978, and 26 in 1986. The Supreme Court at present consists of 1 Chief Justice and 30 judges. Each judge, including the Chief Justice, has a tenure until he attains the age of 65 years. He can resign or can be removed as per Clause 4A of Article 124, which reads, "A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity." Clause 3 of this article prescribes qualification for the appointment of a judge. A. He shall be a citizen of India. B. Has been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or C. Has been for at least 10 years an advocate of a high court or of 2. C. Has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession. Or D. Is, in the opinion of the President, a distinguished jurist. A judge who has served in the Supreme Court is barred to plead in any court within the territory of India after retirement. Judges of the Supreme Court are paid salaries and are entitled to such privileges as determined by Parliament by law passed from time to time, Article 125. The Supreme Court came into being on January 28, 1950, and its inauguration took place in the Chamber of Princes in the Parliament. The judges of the Supreme Court, as also of high courts, are appointed as per the 99th Amendment Act, 2014 by the National Commission on Appointment of Judges of Higher Judiciary, consisting of 6 members, Chief Justice of India, 2 senior-most judges, next to the Chief Justice of the Supreme Court, Union Law and Justice Minister, and 2 other eminent members for a 3-year term, one of them belonging to the SC, ST, OBC, minorities and women. The transfer of the judges of higher courts is conducted by the Judicial Commission. The Supreme Court has declared the 99th Amendment as invalid in 2015. The judges of the higher judiciary and their transfer are done as earlier, which follows as under. The Judges' Inquiry Act, 1965, regulates the procedure relating to the removal of a judge of the Supreme Court, and the procedure is 1. A removal motion signed by 100 members of the Lok Sabha or 50 members of the Rajya Sabha is to be given to the Speaker/Chairman. 2. The Speaker/Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker/Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of the Chief Justice or a judge of the Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. 5. If the committee finds the judge guilty of misbehavior or suffering from incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of the Parliament by special majority, an address is presented to the President for removal of the judge. Special majority means 2/3 of the members present and voting, and which must have a simple majority of the total membership of each House. 7. Finally, the President passes an order removing the judge. No Supreme Court judge has been impeached so far. The first and the only case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991-93. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress Party abstained from voting. B. Jurisdiction of the Supreme Court. The Supreme Court has original, appellate, and advisory jurisdiction. Original jurisdiction. The Supreme Court has an exclusive original jurisdiction under Article 131 over any dispute between the Government of India and one or more states, or between the Government of India and any state or states on one side and one or more states on the other, or between 2 or more states, if and insofar as the dispute involves question, whether of law or of fact, on which dependes the existence of extent of a legal right. In addition, Article 32 of the Constitution grants an extensive original jurisdiction to the Supreme Court in regard to enforcement of the fundamental rights. It is empowered to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, to enforce them. Appellate jurisdiction. The appellate jurisdiction of the Supreme Court can be invoked by a certificate granted by High Court under Articles 132, 1, 133, 1, or 134 of the Constitution in respect of a judgment, decree, or final order passive by it in civil or criminal cases, involving substantial questions of law as to the interpretation of the Constitution. The Supreme Court can also grant special leave to appeal against judgment or order of a non-military court. The Parliament has the power to enlarge the appellate jurisdiction of the Supreme Court and has exercised this power in case of criminal appeals by enacting the Supreme Court Enlargement of Criminal Appellate Jurisdiction, Act, 1970. Appeal can also be filed to the Supreme Court in civil matters if the High Court concerned certifies that the case involve a substantial question of law of general importance, and that, in the opinion of the High Court, the said question needed to be decided by the Supreme Court. In criminal cases, an appeal can be filed to the Supreme Court if the High Court has a. On appeal reversed an order of acquittal of an accused person and sentenced him to death or to imprisonment for life or for a period of not less than 10 years, or b. withdrawn for trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused and sentenced him to death or imprisonment for life or for a period of not less than 10 years, or c. certified that the case is fit for appeal to the Supreme Court. Parliament is authorized to confer on the Supreme Court any further powers to entertain and hear appeals from judgment, final order, or sentence in criminal proceeding of a High Court. Advisory jurisdiction. The Supreme Court has a special advisory jurisdiction in matters which may specifically be referred to it by the President of India under Article 143 of the Constitution. However, the President is not bound to accept the advice. Some of the cases where the advice of the Supreme Court was sought included Delhi Laws Act, 1954, Kerala Education Bill, 1958, Barabar Union, 1960, Customs Act, 1963, Special Courts Bill, 1978, Jammu and Kashmir Resettlement Act, 1982, Kaveri Water Dispute Tribunal, 1992, Ram Jama Bhumi Case, 1994. 2. The Supreme Court has the power to grant special leave to appeal against any judgment by any court. Article 136. 3. The Supreme Court is empowered to review its own judgment. Article 137. Under Articles 129 and 142 of the Constitution, the Supreme Court has been vested with power to punish anyone for contempt of any law court in India. The Supreme Court performed an unprecedented action when it directed a sitting minister of the state of Maharashtra to be jailed for 1 month on a charge of contempt of court on May 12, 2006. This was the first time that a serving minister was ever jailed. Judicial review. Judicial review is a process through which the judiciary examines the constitutionality of a legislative act and/or executive order. If on examination it is found that there has been a violation of the Constitution, the judiciary declares it to be unconstitutional and invalid. Though the word judicial review has nowhere been used in the Constitution, numerous provisions, such as Articles 13, 32, 131, 132, 133, 134, 226, 246, etc., explicitly confer the power of the judicial review on the Supreme Court. The Supreme Court has used the power of judicial review in various cases, such as the Goloknath case, 1967, the bank nationalization case, 1970, the Privy Purse's abolition case, 1971, and the Kesavananda Bharti case, 1973, and the Minerva Mills case, 1980. When the judicial review power is exercised, the following 3 grounds are referred to by stating that the law or the order infringes the fundamental rights, Part 3, B is outside the competence of the authority which has framed it, and C is repugnant to the constitutional provisions. The Constitution seeks to ensure the independence of Supreme Court judges in various ways. Judges are generally appointed on the basis of seniority and not on political preferences. A judge of the Supreme Court cannot be removed from office except by an order of the President passed after an address in each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of members present and voting, and presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. The salary and allowances of a judge of the Supreme Court cannot be reduced after appointment. A person who has been a judge of the Supreme Court is barred, after retirement, from practicing in any court of law or before any authority in India. The Supreme Court, the role of judiciary. The intention of the Constituent Assembly, insofar as the Supreme Court was concerned, was to make the apex court as the custodian of the federal scheme which the framers had visualized, B, the Constitution they had so fondly formulated, and C, the fundamental rights granted to the people as enshrined in the Constitution. The framers had no intention to put one organ of the government against the other. The idea was to check the arbitrariness of both the legislature and the executive, rather than making it as the battleground for settling scores. They did wish to project it as impartial as possible and had sought to keep the judiciary away from the pressure of the government, legislature including. There was, in fact, no intention to make the judiciary override the wishes of the legislature, either. Happily, the provisions relating to the Supreme Court were so designed that it acted as the guardian of the constitutional and administrative system of the idea of state-independent as well as impartial judiciary was what the framers of the Constitution sought to establish in the country. Aladi Krishnaswamy Iyer had rightly pointed out in the Constituent Assembly, while there can be no two opinions on the need for the maintenance of judicial independence, both for the safeguarding of the individual liberty and the proper working of the Constitution, it is also necessary to keep in view one important principle. The doctrine of independence is not to be raised to the level of a dogma so to enable the judiciary to function as a kind of super-legislature or super-executive. The Supreme Court, over the years, has served its role remarkably well. Though Article 131 restricts the Supreme Court to take up issues relating to treaties prior to the commencement of the Constitution as also matters under Articles 280 and 290, it did decide disputes between the Union government and the governments of states or between states. In the case, State of West Bengal versus Union of India, 1963, the Supreme Court declared the unconstitutionality of the Coal-Bearing Areas Act, 1957. In the State of Bihar versus Union of India case, 1970, the Supreme Court held that disputes of constitutional and legal and not of political nature be taken up. See also State of Rajasthan versus Union of India, 1978. In yet another case, the State of Karnataka versus Union of India, 1978, the government of Karnataka challenged the power of the Union government to appoint an inquiry commission under Article 131, though the Supreme Court had interpreted the said article generously. Another 2 cases, State of Karnataka versus State of Andhra Pradesh, 2001, and the State of Haryana versus State of Punjab, 2002, related to the distribution of river water between the concerned states and thus did not constitute part of the dispute arising under Article 131. The two cases were related to Article 262 and were, hence, not taken up for hearing by the Apex Court. Although the issue in the S.R. Bommai v. Union of India case, 1994, was not one of doubting India's federal scheme as was asserted. The fact that the Supreme Court declared under the scheme of our Constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages of the center. The states have an independent constitutional existence. They are not satellites or agents of the center. Within the sphere allotted to them, the states are supreme. Let it be said that the federation in the Indian Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own process and a recognition of ground realities. The Supreme Court of India has protected the fundamental rights, rather overzealously. The right to life under Article 21 is not merely the right to live. It is the right to live with dignity, to live in a healthy environment, its scope extending to all civil human rights. Endorsing the view taken in the Motaram v. State of Madhya Pradesh case, 1978, the Supreme Court, in the Husainara Khatun case, 1979, sought to include reasonable, fair, and just conditions when acting on the procedure established by law under Article 21. Condemning the practice of using handcuffs and fetters as torture of the prisoners, defiling their dignity, vulgarizing the society, and fouling the soul of the country's culture, the Supreme Court, in the Prem Shankar Shukla v. Delhi administration case, 1980, invoked Articles 14, 19, and 21 declaring the handcuffing as the violation of one's personhood, a decision which was reiterated in the Citizens for Democracy v. State of Assam case, 1995. In Ichu Devi Kararia v. Union of India, 1980, the Supreme Court declared personal liberty, Article 21, as most precious, without which life would be worth nothing. In yet another case, Nilabadi Behera v. State of Orissa, 1993, the Supreme Court declared judiciary as the protector of civil liberties. In Delhi Domestic Working Women's Forum v. Union of India, 1995, the Supreme Court asserted that speedy trial is one of the essential requisites of law, giving a meaning to the guarantee of equal protection of law. Under Article 14, the People's Union for Civil Liberties v. Union of India, 1997, D.K. Basa v. State of West Bengal, 1997, and Vishaka v. State of Rajasthan, 1997, the Supreme Court sought to prohibit arbitrary interference and custodial torture as a naked violation of human dignity and sexual harassment. The Civil Rights of the People, Articles 14, 15, 19. The Supreme Court has done no less in expressing its concern about the impact of pollution on ecology and environment in numerous cases. Some of these cases are MC Mehta v. Union of India, 1988, Indian Council for Enviro-Legal Action v. Union of India, 1996, Vellore Citizens Welfare Forum v. Union of India, 1996, S. Jagannath v. Union of India, 1997, MC Mehta Tosh Trapezium. Matter v. Union of India, 1997, MC Mehta Badgal and Suraj Kundlake's Matter v. Union of India, 1997, Bitasagal v. Union of India, 2001, and MC Mehta v. Union of India, 2002. In the field of education and especially relating to the rights of the minorities, the Supreme Court has given historic decisions contributing immensely to these fields. Some such cases are Kerala Education Bill 1957, 1959, the Ahmedabad St. Xavier Society v. State of Gujarat, 1974, St. Stephen's College v. University of Delhi, 1992, Mohini Jain v. State of Karnataka, 1992, Uni Krishnan v. State of Andhra Pradesh, 1993, Time Pai Foundation v. State of Karnataka, 2002, Islamic Academy of Education v. State of Karnataka, 2003, and P.A. Inamdar v. State of Maharashtra, 2005. The judicial review power of the Supreme Court together with that of high courts has enhanced the position of the Indian judiciary. The Supreme Court of India, being the highest judicial organ, is an important institution in our polity. Over the years, it has proved its merit by being the custodian of the Constitution, protector of our federal system, and the defender of the fundamental rights of our people. Indeed, the Supreme Court has been able to attain and keep its grandeur, although it is not as powerful as the American Supreme Court. The American Supreme Court has empowered itself through what is called due process of law, which has given it wide scope of power, including the power to protect the rights of the people and the Constitution. The Indian Supreme Court works within what has been described as procedure established by law, which has relatively restricted its scope of power. The American Supreme Court goes by the law as well as by its spirit, while the Indian Supreme Court goes more by the law than by its spirit. LL. The High Courts in India. Chapter 5 of Part 6, from Articles 214 to 231, deal with high courts in the states. Article 214 says that there shall be a high court for each state, though some states may have a common high court together. Guwahati High Court, for example, has its jurisdiction over the states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Nagaland, Tripura, Mizoram, and Punjab, and Haryana High Court has its jurisdiction over the states of Punjab and Haryana. Among the Union territories, Delhi has a high court, but other Union territories are attached to their neighboring states. Like the Supreme Court of India, each high court is a court of record, Article 215, and as such has the power to punish for contempt of the court. Each high court, Article 216 says, consists of a chief justice and such other judges as the president may from time to time deem it necessary to appoint. Article 217 prescribes the appointment, tenure, and qualification of judges. It reads thus: 1. Every judge of a high court shall be appointed by the president by warrant under his hand and seal after consultation with the Chief Justice of India and the governor of the state. In the case of appointment of a judge other than the Chief Justice of the High Court shall be consulted. The judges shall hold office in the case of an additional or acting judge as provided in Article 224 and in any other case until he attains the age of 62 years. Provided that a judge may, by an application written in his hand addressed to the President, resign from his office. B. A judge may be removed from his office by the President in the manner provided in Clause 4 of Article 124 for the removal of a judge of the Supreme Court. C. The office of a high court judge shall be vacated by his being appointed by the President to be a judge of the Supreme Court or by his being transferred by the President to any other high court within the territory of India. 2. A person shall not be qualified for appointment as a judge of a high court unless he is a citizen of India and a. has for at least 10 years held a judicial office in the territory of India, or b. has not for at least 10 years been an advocate of a high court or two or more such courts in succession. The Calcutta High Court is the oldest high court in the country, established on July 2, 1862. High courts which handle a large number of cases of a particular region have permanent benches or a branch of the court established there. Benches exist also in states which come under the jurisdiction of a court outside its territorial limits. Smaller states with few cases may have circuit benches. Circuit benches, known as circuit courts in some parts of the world, are temporary courts which hold proceedings for a few months in a year. Thus, cases built up during the interim period are judged when the circuit court is in session. The judges of high courts are paid salaries and are entitled to privileges as are determined by a parliament through law. The jurisdiction of the high court can be summed up as follows. Original: the high court hears all disputes. A. Relating to matters of admiralty, will, marriage, company laws, contempt of court. B. Relating to the elections of parliament and state legislatures. C. Relating to revenue matters. D. Relating to enforcement of the fundamental rights. Writ: the High Court has the power to issue writs such as habeas corpus, mandamus, prohibition, quo warrant, certiorari, Article 226. Appellate: civil appeals against orders and judgments of district courts, additional courts, criminal appeals against sentences of more than 7 years. Death sentences awarded by lower court have to be confirmed by the High Court, where the lower court itself certifies that the appeal against its judgment can be made. Control over subordinate courts: the High Court has the power to superintend over all courts and tribunals with regard to the compliance of rules and procedures and service conditions. Judicial review: the High Court has the power to examine the constitutionality of a law or an executive order and declare the same void if it is against the Constitution. The 42-inch 4D Amendment 1976 restricted this power to state laws within its preview, but the 434 Amendment 1977 restored the jurisdiction of the High Court to include state union laws and orders as well. LLL. Judicial review. Judicial review is the power of the judiciary to declare the laws of the legislature and the orders of the executive unconstitutional if the judiciary finds such laws/orders contrary to the Constitution. Judiciary has this power because it, as compared to the other two organs of the state, the legislature and the executive, is usually and relatively impartial and non-political. It also has this power because it, as compared to the other two organs, is more capable to see through what is being overdone by some organs that is not due to them. Who else should be given the power to judge it except the one whose intentions are never in doubt? A legislature, because of its electoral compulsions, can usurp the power it does not have. An executive, because of the power it can possibly assert, can go beyond its specified limits, but the judiciary, attuned to administer justice and committed to the statute book, would only seek to keep the balance in the system. That is one reason why the judiciary is empowered to uphold the Constitution and keep all laws/orders passed or issued within the parameters of the supreme law of the land, for no judiciary is politically ideologized, at least not at its highest level. The power of judicial review vested in judiciary is based simply on the logic that the Constitution should remain the supreme law of the land and that all other laws and authorities need not venture to go beyond the limitations laid down by the Constitution. The concept of judicial review is the American contribution to the world when the Chief Justice Marshall, while pronouncing the verdict in Marbury v. Maidism, 1803, declared that it was judiciary among the organs of the state, which can decide on the constitutionality of a law or a decree, and if found violating the Constitution can declare it void. The judicial review in India differs from the way it exists in the USA. In the USA, the notion of judicial review is rooted in the doctrine of due process of law, while in India it is derived from a relatively lenient doctrine process established by law. In the state of Madras versus V.G. Roe 1952 case, Justice Patanjali Shastri stated, "Our constitution contains express provision for judicial review of legislation as to its conformity with the Constitution. This is especially true as regards the fundamental rights, to which this court has been assigned the role of sentinel. While the court naturally attaches great weight to the legislative judgment, it cannot desert its own duty to determine finally the constitutionality of an impugned statute. There are specific provisions in our Constitution which provide for judicial review, especially the provisions relating to Articles 13, 32, 131 to 136, 226, 245 and 246. But the Supreme Court had specified certain rules for applying the doctrine of judicial review. H.C. Sirvai Constitutional Law of India refers to such rules. 1. There is a presumption in favor of constitutionality, and a law will not be declared unconstitutional unless the case is free of all doubts, and the onus to prove that it is unconstitutional lies with the petitioner who has challenged it. 2. When the validity of a law is questioned, it should go to protect and promote parliamentary sovereignty. 3. The court will not consider constitutional questions if a case can be decided on other grounds. 4. The court will not decide a larger constitutional question if it is required by the case before it. 5. The court will not hear an objection as to the constitutionality of a law by a person whose rights are not affected by it. 6. A statute cannot be declared unconstitutional merely because it is not consistent with the spirit of the Constitution. 7. In assessing the constitutionality of a statute, the court is not concerned with the motives, bona fides or malifides of the legislature, but the law must be upheld whatever a court may think of it. 8. Courts should not pronounce on the validity of an act or part of an act which has not been brought into force, because till then the question of validity would be merely academic. Numerous laws and amendments have gone through judicial scrutiny from the time of the Constitution's enactment, though Nehru had emphatically stated, "No Supreme Court and no judiciary can stand in judgment over the sovereign will of the Parliament, representing the will of the entire community." The Kamesneshwar Singh v. State of Bihar, 1951, Ramesh Thapar v. State of Madras, 1950, and Motilal v. State of Uttar Pradesh, 1950, were the cases where the Supreme Court, using the power of judicial review, has declared the abolition of zamindari through amendment. The Amendment Act was challenged in Shankari Prasad case, 1951, and the Sujjan Singh case, 1965. In the latter case, the 17th Amendment Act was challenged. In both cases, the Supreme Court held the view that the Parliament was empowered to amend the Constitution, including provisions relating to the fundamental rights. But in the Goloknath case, 1967, which challenged the 17th Amendment on the ground that it had violated the right to property, Article 31A especially, the Supreme Court reviewed its decision and declared that the Parliament cannot amend the Constitution, which is violative of Article 13(2). The court's activism was witnessed in the 1969 bank nationalization and in the 1970 abolition of privy purses ordinances, when both ordinances, using the power of judicial review, were declared unconstitutional. The 24th, 25th, and 26th Amendments, all in 1971, defended the government's action. The apex court waited till 1973 when, through the Kesavananda Bharti case, 1973, it upheld the Parliament's power to amend the Constitution but did not allow the basic structure of the Constitution to be destroyed by the Parliament. The 42nd Amendment, 1976, enhanced the power of the Parliament immensely, but in the Minerva Mills case, 1980, the Supreme Court endorsed the decision made in the Kesavananda Bharti case, with Justice Bhagwati making a point: it is for the judiciary to uphold constitutional values and to enforce constitutional limitations. 4. Judicial activism. There is no statutory definition, nor is there any consensual connotation given to the notion of judicial activism. Is usually described as a proactive role played by the judiciary. Justice J.S. Varma says that judicial activism means the active process of implementation of the rule of law, essential for the preservation of a functional democracy. Being an restrictive term, it is described differently by different persons. While some extol it as judicial creativity and dynamism of judges, which brings revolution in the field of human rights and social welfare through enforcement of public duties. Others criticized it by describing it as judicial extremism, judicial terrorism, transgression into the domains of the other organs of the state, negating the constitutional spirit. The two extreme views appear to have originated due to the role judiciary has played in different cases. Any amount of additional active role may lead to either judicial creativity or judicial extremism. Governance is not merely a lawmaking process. It is also law execution, together with the establishment of justice. The three organs of the state perform three different functions. It is always impossible to put these three different departments separately and then expect a normal functioning. That is why the legislature, while doing its major job of making legislation, performs certain administrative and judicial functions, so do other organs. Fusion, and not separation of functions, is the key to good governance. And if in such a situation, the judiciary does perform relatively a more active role, judicial activism may not be given any more importance than what it deserves. What is important is that judiciary in its role should not abuse either its powers or its position. Governance, being something of a whole, has not to leave any ambiguity anywhere. What wrong is done when the judiciary fills up a vacuum? What wrong is done when any organ other than the judiciary is supported by the judiciary? Judicial activism operates in a situation of some vacuum, when it is required. Judiciary does not begin making laws on its own, nor does it carry out the administration. Justice Varma rightly says, "Judicial activism is that which ensures proper functioning of all organs and the best kind of judicial. Activism is that which brings about results with the least judicial intervention. If everyone else is working, we do not have to step in." Judicial activism is the judiciary acting, i.e., judiciary in action, and not judiciary in intervention. Judicial activism is not one where judiciary takes up an activity, but it is one where it is asked to take action on someone else's stance, public interest litigation including. In S.P. Gupta v. Union of India, 1982, case, the Supreme Court granted accessibility to persons to invite judicial action against the abuse of power or misuse or inaction of the government, both the legislature and the executive. It may be said that the Supreme Court had come to the rescue of workers. People's Union for Democratic Rights v. Union of India, 1982. Bonded Labor, Bandhwa Mukti Morcha v. Union of India, 1984. Prisoners, Sunil Batra v. Delhi Administration, 1978. Pavement Dwellers, Olga Tellis v. Bombay Municipal Corporation, 1985. Under trial détentes, Hussain Ara Khatun v. State of Bihar, 1979. Inmates of protection homes, Upendra Baxi v. State of Uttar Pradesh, 1983. And victims of Bhopal gas disaster, Union Carbide Corporation v. Union of India, 1991. In Rutlam Municipality v. Vertichand, 1980. The Supreme Court sought to activate administrative machinery when it failed to perform its legal obligations. In Common Cause v. Union of India, 1996, the Supreme Court canceled the allotment of petrol pumps made on grounds of nepotism and malified and passed severe strictures against the then Minister of Petroleum and Natural Gas. All these cases indicate that judicial activism has its own importance. A word of caution with regard to judicial activism comes from Dr. A.S. Anand, former Chief Justice of India. He says, "Courts have to function within the established parameters and constitutional bounds. Decisions should have a jurisprudential base with clearly discernible principles. Courts have to be careful to see that they do not overstep their limits, because to them is assigned the sacred duty of guarding the Constitution. Courts cannot create rights where none exists, nor can they go on making orders which are incapable of enforcement or violative of other laws or settled legal principles. With a view to seeing that judicial activism does not become judicial adventurism, the courts must act with caution and proper restraint. They must remember that judicial activism is not an unguided missile. The failure to bear this in mind would lead to chaos. Public adulation must not sway judges, and personal aggrandizement must be eschewed. It is imperative to preserve the sanctity and credibility of the judicial process. It needs to be remembered that courts cannot run the government. The judiciary should act only as an alarm bell. It should ensure that the executive has become alive to perform its duties. B. Subordinate courts. The structure and functions of subordinate courts are more or less uniform throughout the country. Their designations denote their functions. They deal with all disputes of civil or criminal nature as per the powers conferred on them. Their power is derived principally from two important codes prescribing procedures: the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973, and further strengthened by local statutes. As per the direction of the Supreme Court, W.P. Civil 1022/1989 in the All India Judges Association case, a uniform designation has been given to the subordinate judiciary's judicial officers all over the country, viz. District or Additional District Judge, Civil Judge, Senior Division and Civil Judge, Junior Division, on the civil side, and on criminal side, Session Judge, Additional Sessions Judge, Chief Judicial Magistrate and Judicial Magistrate, etc., as laid down in the C.R.P.C. Under Article 235 of the Constitution of India, administrative control over members of the subordinate judicial service rests with the concerned High Court. Further, in exercise of powers conferred under proviso to Article 309 read with Articles 233 and 234 of the Constitution, state government frames rules and regulations in consultation with the High Court in their state to administer subordinate courts. Members of the state judicial services are governed by these rules and regulations. The next set of courts is described as courts of district and sessions judge, which also include courts of additional judge, joint judge, or assistant judge. The court of the district and sessions judge at district level is the principal court of original jurisdiction. In addition, there are courts known as small causes courts. These are set up either under the Provisional Small Causes Act at the district level or under the Presidency Town Small Causes Courts Act in presidency/metropolitan towns. The Family Courts Act, 1984, aims at promoting conciliation and securing speedy settlement of disputes relating to marriage and family affairs and related matters. It envisages that courts shall be set up in a city or town with a population of more than 10 lakh and at such other places as the state government may deem necessary. Family courts have been set up in Andhra Pradesh, 7, Assam 1, Bihar 2, Karnataka 5, Kerala 5, Maharashtra 16, Manipur 1, Orissa 2, Pondicherry 1, Punjab 2, Rajasthan 5, Sikkim 1, Tamil Nadu 6, Uttar Pradesh 16, and West Bengal 1. Besides, necessary notifications extending the jurisdiction of the Family Courts Act have been issued by the Government of India in respect of Haryana, Madhya Pradesh, and the Union Territory of Andaman and Nicobar Islands. 6. Lok Adalat. Lok Adalat, People's Courts, established by the government, settles disputes through conciliation and compromise. The first Lok Adalat was held in Chennai in 1986. Lok Adalats accept cases which could be settled by conciliation and compromise, pending in regular courts within their jurisdiction. The Lok Adalat is presided over by a sitting or retired judicial officer as chairman, with 2 other members, usually a lawyer and a social worker. There is no court fee. If the case is already filed in a regular court, the fee paid is refunded if the dispute is settled at the Lok Adalat. Procedural laws and the Evidence Act are not strictly followed by the Lok Adalats while assessing the merits of claims. Main condition of the Lok Adalat is that both parties in dispute should agree for settlement. The decision of the Lok Adalat is binding on the parties to the dispute and its order is capable of execution through the legal process. No appeal lies against the order of the Lok Adalat. Lok Adalat is very effective in settlement of money claims. Disputes, like partition suits, damages, and matrimonial cases, can also be easily settled in Lok Adalats as chances compromise through give and take approach stand high in such cases. Lok Adalat is a boon to the litigant public where they can get their disputes settled fast and free of cost. Lok Adalats have proved to be an effective mechanism for resolution of disputes through conciliatory methods. Up to 2010, about 25,000 Lok Adalats had been held in different parts of the country where about 160 lakh cases were settled. In about 80 lakh motor vehicles accident claim cases, compensation amounting to over $1 billion was awarded. Under the Legal Services Authorities Act, the Lok Adalat has been given the status of a civil court and every award made by the Lok Adalat is final and binding on all parties and no appeal lies to any court against its award. Benefits which accrue to litigants through Lok Adalats are: there is no court fee, and if the case is already filed in a regular court, the fee paid is refunded if the dispute is settled at the Lok Adalat. There is no strict application of procedural laws and the Evidence Act while assessing the merits of the claim by the Lok Adalat. Parties to the dispute, though represented by their advocate, can interact with the Lok Adalat judge directly and explain their stand in the dispute and the reasons thereof. This is not possible in a regular court of law. The decision of the Lok Adalat is binding on the parties to the dispute and its order is capable of execution through the legal process. No appeal lies against the order of the Lok Adalat, whereas verdicts of regular law courts can be challenged in higher forums on a proas, which causes delay in the settlement of the dispute. Rationale behind the non-appealability or Lok Adalat decisions is that they are based on mutual settlement. Disputes can be brought before the Lok Adalat directly instead of going to a regular court first and then to the Lok Adalat. And hence, no case for appeal shall arise. In every respect, the scheme of Lok Adalat is a boon to the litigant public where they can get their disputes settled fast and free of cost. Vil. Free legal aid and public interest litigation. Article 39A of the Constitution provides for free legal aid to the poor and weaker sections of the society. The Legal Services Authorities Act, 1987, as amended by the Act of 1994, which came into force on November 9, 1995, aims at establishing a nationwide network for providing free and comprehensive legal services to the weaker sections. A National Legal Services Authority, NALSA, has been set up for implementing and monitoring legal aid programs in the country, and a Supreme Court Legal Services Committee constituted under the Act. In high courts also, High Court Legal Services Committees are being established to provide free legal aid to eligible persons in matters coming before the high courts. The Legal Services Authorities Act also provides for constitution of state legal services committees, high court legal services committees, district legal services committees, and taluk legal services committees. Under the Legal Services Authorities Act, every citizen whose annual income does not exceed 9,000 rupees is eligible free legal aid in cases before subordinate courts and high courts. In cases before the Supreme Court, the limit is 12,000 rupees. This limit can be increased by state governments. Limitation as to the income does not apply in the case of persons belonging to the scheduled castes, scheduled tribes, women, children, and handicapped. Legal aid programs adopted by NALSA include promoting legal literacy, setting up of legal aid clinics in universities and law colleges, training of paralegal personnel, and holding legal aid camps and lock adalats. The government had sanctioned 4 rupees crore as grant and aid for NALSA in 1998-99 to implement its programmer at various levels. The NALSA also monitors and evaluates the implementation of the legal aid programs in the country. Up to March 2009, about 97 lakh persons benefited through court-oriented legal aid programs provided by state legal aid and advice boards / state legal services authorities. Of them, 25.1 persons belong to the scheduled castes, more than 2 lakhs to the scheduled tribes, 24.6 were women, and 1.6 lakh children. In 1981, Justice P. N. Bhagwati in S. B. Gupta v. Union of India, 1981, articulated the concept of public interest litigation, PL, as follows. Where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position unable to approach the court for relief, any member of public can maintain an application for an appropriate direction, order, or writ in the High Court under Article 226, and in case any breach of fundamental rights of such persons or determinate class of persons. In this court under Article 32. Seeking judicial redress for the legal wrong or legal injury caused to such person or determinate class of persons. The rule of /aucus standi has been relaxed, and a person acting bona fide and having sufficient interest in the proceeding of public interest litigation will have a locus standi and can approach the court to challenge the violation of fundamental rights and genuine infraction of statutory provisions, but not for personal gain or private profit or political motive or any oblique consideration. Ashok Kumar Pandey v. State of West Bengal, 2004. In Guruvayur Devaswam Managing Committee v. C.K. Rajan, 2003, the Apex Court held the courts exercising their power of judicial review found to their dismay that the poorest of the poor, the depraved, the illiterate, the urban and rural unorganized labor, women, children handicapped by ignorance, indigence, and illiteracy, and other downtrodden have either no access to justice or had been denied justice. A new branch of proceedings known as social interest litigation or public interest litigation was evolved with a view to rendering complete justice to the aforementioned classes of persons. It expanded its wings in course of time. The courts in pro bono publico granted relief to inmates of the prisons, provided legal aid, directed speedy trial, maintained human dignity, and covered several other areas. Representative actions. Pro bono publico and test litigations were entertained in keeping with the current accent on justice to the common man and a necessary disincentive to those who wish to bypass real issues on the merits by reliance on peripheral procedural shortcomings. Pro bono publico constituted a significant page in the present-day judicial system. Public interest litigation in Indian law means litigation for the protection of public interest. It is litigation introduced in a court of law not by the aggrieved party but by the court itself or by a private party. It is not necessary for the exercise of the court's jurisdiction that the person who is the victim of the violation of his or her right should personally approach the court. Such cases may occur when the victim does not have the necessary resources to commence litigation or his freedom to move court has been suppressed or encroached upon. The court can itself take cognizance of the matter and proceed sua motu, or cases can commence on the petition of any public-spirited individual. Numerous aspects of public interest litigation, PL, may be stated as 1. The nature of public interest litigation is remedial, as that the traditional jocus standi rules are not followed in such cases. 2. A third party not concerned with the case can file a petition on the ground that the injured party cannot approach the court. 3. PL makes the court change its position from protector to the guardian of the rule of law. 4. PL makes the case one of collaborative nature where all concerned, the claimant, the court, the government, seek human rights as meaningfully as possible. 5. PL makes the litigation investigative as it works on reports of registrar, district magistrate, and comments of experts and the like. 6. An attempt is made to wipe tears from some eyes in PL cases when PL cells are open to help the needy. This is called the epistolary jurisdiction. PL is working as an important instrument of social change. It is working for the welfare of every section of the society. It's a sword that can be used by everyone for securing justice. The innovation of this legitimate instrument citizen has proved beneficial for a developing country like India. PL has been used as a strategy to combat atrocities in the society. It's an institutional initiative for the welfare of the needy in the society. In Bandha Mukti Morcha versus Union of India, the Supreme Court ordered the release of bonded laborers. In Murli S. Dogra versus Union of India, the court banned smoking in public places. In a landmark judgment of High Domestic Working Women's Forum versus Union of India, 1995, the Supreme Court issued guidelines for rehabilitation and compensation for raped working women. In Vishaka versus State of Rajasthan, the Supreme Court laid down exhaustive guidelines for preventing sexual harassment of working women in their place of work. We may, thus, conclude by quoting Cunningham, Indian PL might rather be a phoenix, a whole new creature arising out of the ashes of the old order. It is, indeed, something like the American PIL, public interest law, or rather better in the sense that it does not touch the spirit of social change. PIL in India is related to environmental cases. MC meta cases are such examples. Judicial reforms. There are, at present, over 14,000 courts throughout the country handling about 4 crores of cases. With the working strength of about 12,500 each judge handles nearly 4,000 cases. Is it not a sufficient ground for initiating judicial reforms in the country? Working on the judicial management system, our National Judicial Academy is doing its job seriously. Though there are large a number of cases before courts, the fact is that only about 40% of the cases are 1 year old, while 90% of the delayed cases are those pending in subordinate courts. An array of long-term and short-term reforms may be suggested. With regard to the long-term reforms, we need to have legislative reforms to remove the bottlenecks which adversely affect the adjudication. To strengthen the bar. To strengthen legal education, legislative reforms to expend the power of judges to control judicial pressures to ensure just and efficient outcomes in line with international reforms, and a satisfactory framework for judicial accountability. With regard to short-term reforms, the following can be suggested. If certain administrative reforms are made, a large number of cases pending in courts can be reduced. In most cases, the government is a party in the case, either defendant or appellant. If the decision-making authorities take firm, independent, and impartial steps in time, citizens would not be driven to litigations. A weak and inefficient revenue administration is another reason for a large number of civil cases. If the revenue administration is streamlined and everyone is given proper title deeds with computerized diagrams, a large number of land disputes could be avoided. In states where the revenue administration is poor, there are large numbers of civil cases, and these disputes relate either to title or boundaries of their properties. These cases could be avoided if proper resurvey operations are done and proper revenue records are maintained by. 6. Most criminal cases get delayed intentionally. Inept. The authorities. There are a large number of financial institutions which are trying to recover money through criminal proceedings by making use of the provisions of the Negotiable Instruments Act. The courts have become collecting agents for these financial institutions. Most of them are privately owned by people who engage in the practice of giving usurious loans. Because of these types of cases, the trial of ordinary criminal cases is seriously hampered. Why does not the government build its own infrastructure and in the process reduce the number of cases in the courts? A large number of motor accident claims are pending in various tribunals. In some states, it takes more than 4 or 5 years to settle a claim despite the fact that large number of cases are settled through lock adalats. The insurance companies should have proper settlement method whereby they must acknowledge their liability and disburse the amount to the claimant even before she comes to the courts. Such a streamlined procedure is not available in our system. When the claimants are before the courts, insurance companies are not in a position to settle the claims even in cases where they admit their liability. The situation is not different in respect of land acquisition cases. In many cases, amount awarded by land acquisition officers are not reasonable or proper, driving parties to resort to litigation were. If there were district-level high-power committees to fix compensations at reasonable amount, most claimants might possibly accept them, leaving only a few to move to courts for enhancement. Policing and weak prosecution are largely responsible for the slow pace of trials in many courts. There is always a planned approach to delay the criminal cases. In conclusion, we may say that there is a need for national minimum court performance standards in the country so that disposal of the cases is increased, Courts do not delay the adjudication unnecessarily, and cases should have their serial numbers together with the starting dates. Practice questions. 1. How is the Supreme Court organized in India? 200 to 250 words. 2. How is a judge of the Supreme Court of India removed? 200 to 250 words. 3. Explain the jurisdiction of the Supreme Court of India. 700 to 800 words. 4. Examine the role of Supreme Court as the final interpreter of the Indian Constitution, 2013. 700 to 800 words. 5. Write a brief note on the High Court of a state. 200 to 250 words. 6. Write a detailed essay on judicial review in India. 700 to 800 words. 7. Comment on judicial activism and social change. 2012. Write brief notes on the following. A. Subordinate courts. B. Lock Adalat. C. Free legal aid. D. Public interest litigation. 200 to 250 words each. 9. What reforms would you suggest in the Indian judicial system? 700 to 800 words. 10. Examine the debate on the appointment procedure of judges to the higher judiciary in India. 200 to 250 words. Grassroots democracy, urban and rural government, municipal administration and Panchayati Raj. Democratic polity. The more a political system is decentralized down to the local level, the greater are the chances of grassroots democracy flourishing. Responsiveness and educative values are the added advantages of a decentralized system. A local government is always good, as it relieves the higher administration of its burden, but a local self-government is still better, as it awakens and involves the local people and gives them their experience of administration at their doorsteps. Decentralization of the power is a salient feature of a. Decentralization can be in operation both at the urban as well as rural levels. In a country like India, rural governance assumes importance because the people still live in villages, though there have developed urban administrative institutions such as municipal corporations for bigger towns, municipalities for smaller populations, notified area committees for especially specified areas, town area committees for small towns, and cantonment boards managed by military officials. Rural areas have institutions, such as Gram Panchayats, Panchayat Samitis, and the Zilla Parishads. With the passage of time, names and functions of these local institutions, both urban and rural, have undergone changes. The 73th and 74th Amendments, 1993, were the latest enactments with regard to Nagar and village institutions. Urban local administration in India. The history of urban bodies, both cities and towns, is fairly old in India and can be traced to the Indus Valley civilization, where emphasis was laid on planned roads, houses, and town meetings. Kautilya, in his work, Arthasastra, has given a graphic description of the city of Patliputra. The Mauryas, the Guptas, the Turks, and the Mughals helped city administrations to flourish, laying emphasis on sanitation, roads, inns, water supply, marketplaces, public utility works. Sher Shah Suri built the Grand Trunk Road connecting the far western town of Peshawar with the far eastern town of what is known as Kolkata today. During the British colonial rule, towns and cities developed. The first municipal corporation was established in Madras in 1688. Calcutta and Bombay followed in 1772 and 1793, respectively. The number of corporations in India rose rapidly in independent India. In 1975, there were 34 municipal corporations. It rose to 170 in 2014. 2,100 municipalities and over 2,100 Nagarpalika, 2014. So has the number of other local urban institutions in the country. The total number of towns in the country are around 5,000, while the percentage of villages in India is around 80% of the total population, i.e. more than 600,000, 2005 to 2006. Corporations, municipalities, notified area committees, town area committees, and cantonment boards are other urban local institutions in India. The organization of each such institution varies from state to state, so do their functions as well. Usually, a municipal corporation is headed by an elected mayor, while the administration of the city is carried out by an elected council. The power of the municipal corporation is usually exercised by a general council, a standing committee, and the municipal chief executive officer. Councillors are elected by the people for a specified period. Along with councillors, there are certain aldermen elected by councillors. The council, consisting of councillors and aldermen, elects the mayor and deputy mayor. The mayor, and in his absence, the deputy mayor, presides over meetings of the council. The mayor is the ceremonial head of the council and hence the first citizen of the city. The general council makes laws, bylaws, passes budget, appoints committees, and supervises the functioning of various departments of the corporation. There are various standing committees in the corporation elected by the council to carry out most of the administrative activities, including taxation, finance, health and sanitation, and water and electricity supply. The municipal commissioner, as the chief executive officer of the corporation who is appointed by the state government, usually supervises the administrative work. The business of the corporation relates to functions such as public health, education, construction, and the maintenance of waterworks, sewerage, streets and bridges, parks, recreation grounds, markets, and shopping centers. For doing these things, corporations can raise taxes such as property tax, tax on buildings, education cess, tax on profession, and the like. Municipalities are established in smaller towns through the acts of the state. Their organization varies from state to state. Municipalities differ from corporations because they are set up for smaller areas and smaller populations, and they have lesser sources of revenues. Like corporations, municipalities have three authorities: the council and its committees, chairman/president of the council, and chief executive officer or chief municipal officer. The strength of the municipal councils differs from state to state depending upon their population. Members of the council are elected by voters on the basis of universal adult franchise for a period which ranges from 3 to 5 years. The council decides such issues as policy matters, prepares budgets, imposes taxes, makes rules and regulations, laws and bylaws. Most of the functions of municipal councils are carried out by committees. The chairman or the president of the council is the ceremonial head and performs the function of the presiding officer, though in some states he does the executive and administrative tasks as well. The function of the municipal officer relates to the conduct and supervision of the administration in the concerned area. Municipalities have to do almost the same function as corporations, i.e., civic functions, some compulsory or obligatory and some optional, but almost all dealing with tasks such as public health and public sanitation, education, especially of primary level, public utility works, water and electricity supply, maintenance of street, roads, parks, sewerage system. Most of their expenditure is met by levying taxes and receiving grants from the state and central governments. Small urban areas such as notified areas, town areas, and cantonment boards are bodies where administration is done through appointed officials with government supervision and control. They do the local level functions as do the municipalities and corporation. Urban administration and the 74th Amendment, municipal bodies. With the passage of the 74th Amendment, 1993, the entire local urban administration has acquired a new structure with a new orientation relating to their organization, functions, and finances. The amendment has added 12th schedule to the Constitution. Part 9A, dealing with articles from 243p to 243za, deal with municipal bodies. Articles 243p defines municipalities, committees, etc. Committee means a committee constituted as under Article 243s. Metropolitan area means an area having a population of 1 million or more, comprised in one or more districts and consisting of 2 or more municipalities or panchayats. Municipal area means the territorial area of municipalities. Municipalities mean institutions of self-government. Nagar Panchayat means a transitional area, an area in transition from a rural area to an urban area. Municipal council for a smaller urban area and corporation for a larger urban area. Other articles dealing with municipal bodies as enumerated in the Constitution are as follows. 243 Quetzales. Constitution of municipalities, there shall be constituted in every state. A Nagar Panchayat, by whatever name called, for a transitional area, i.e., an area in transition from a rural area to an urban area. B. A municipal council for a smaller urban area, and C. A municipal corporation for a larger urban area in accordance with the provisions of this part. 243R. Composition of municipalities. 1. Same as provided in Clause 2, all seats in a municipality shall be filled by persons chosen by direct election from territorial constituencies in the municipal area, and for this purpose each municipal area shall be divided into territorial constituencies to be known as wards. 2. The legislature of a state may, by law, provide a. For the representation in a municipality of I. Persons having special knowledge or experience in municipal administration. 2. Members of the House of the People and members of the Legislative Assembly of the state representing constituencies which comprise wholly or partly the municipal area. 3. Member of the Council of States and members of the Legislative Council of the state registered as electors within the municipal area. 4. Chairpersons of committees constituted under Clause 5 of Article 243s, provided that persons referred to in paragraph shall not have the right to vote in the meetings of the municipality. B. The manner of election of the chairperson of a municipality. 243s. Constitution and composition of ward committees, etc. 1. There shall be constituted ward committees consisting of 1 or more wards within the territorial area of a municipality having a population of 300,000 or more. 2. The legislature of a state may, by law, make provision with respect to A. The composition and the territorial area of a ward committee. B. The manner in which the seats in a ward committee shall be filled. 3. A member of a municipality representing a ward within the territorial area of the ward committee shall be a member of that committee. 4. Where a ward committee consists of A. One ward, the member representing that ward in the municipality, or B. Two or more wards, one of the members representing such wards in the municipality elected by the members of the ward committee shall be chairperson of that committee. 243t. Reservation of seats I. 1. Seats shall be reserved for the scheduled castes and the scheduled tribes in every municipality, and the number of seats so reserved shall bear, as nearly as may be, the same proportion to the total number of seats to be filled by direct election in that municipality as the population of the scheduled castes in the municipal area or of the scheduled tribes in the municipal area bears to the total population of that area, and such seats may be allotted by rotation to different constituencies in a municipality. 2. Not less than 1/3 of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. 3. Not less than 1/3, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every municipality shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a municipality. 4. The office of the chairperson in municipalities shall be reserved for the scheduled castes, the scheduled tribes, and women in such manner as the legislature of a state may, by law, provide. 5. The reservation of seats under Clause 1 and 2 and the reservation of offices of chairpersons other than the reservation for women under Clause 4 shall cease to have effect on the expiration of the period specified in Article 334. 6. Nothing in this part shall prevent the legislature of a state from making any provision for reservation of seats in a municipality or the office of chairperson in municipalities in favor of the backward class of citizens. 243u. Term of municipalities, etc. Every municipality, unless dissolved sooner than its term under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer than that, provided that a municipality shall be given a reasonable opportunity of being heard before its dissolution. No amendment of any law for the time being in force shall have the effect of causing the dissolution of a municipality at any level, which is functioning immediately before such amendment, till the expiration of its term specified in Clause 1. 1. An election to constitute a municipality shall be completed. The expiry of its term specified in Clause 1. B. Before the expiration of a period of 6 months from the date of its dissolution, provided that where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, it shall not be necessary to hold any election under this clause for constituting the municipality for such period. 2. A municipality constituted upon the dissolution of a municipality before the expiration of its term shall continue only for the remainder of the period for which the dissolved municipality would have continued under Clause 1, had it not been so dissolved. 243v. Disqualification for membership. 243w. Powers, authority, and responsibilities of municipalities. Subject to the provisions of this Constitution, the legislature of a state may, by law, endow municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government, and such law may contain provisions for the devolution of powers and responsibilities upon municipalities, subject to such conditions as may be specified therein, with respect to I. The preparation of plans for economic development and social justice. 2. The performance of functions and the implementation of schemes as may be entrusted to them, including those in relation to the matters listed in the 12th Schedule. B. Committees with such powers and authority as may be necessary to enable them to carry out responsibilities conferred upon them, including those in relation to matters listed in the 12th Schedule. 243x. Power to impose taxes and functions of municipalities. The legislature of a state may, by law, authorize a municipality to levy, collect, and appropriate taxes, duties, tolls, and fees in accordance with procedure and limits laid down the legislature, or assign to a municipality certain taxes, duties, tolls, and fees levied and collected by the state government subject to conditions and limits laid down by the government. A. Provide for making such grants in aid to municipalities from the consolidated fund of the state, and B. Provide for constitution of such funds for crediting all monies received, respectively, by or on behalf of municipalities, and also for withdrawal of such monies therefrom, as may be specified in the law. 243y. Finance Commission. 1. A Finance Commission constituted under Article 2431 shall review the financial position of municipalities and make recommendations to the governor as to principles which should govern I. The distribution between the state and the municipalities, the net proceeds of taxes, duties, tolls, and fees leviable by the state, which may be divided between them under this part, and allocation between the municipalities at all levels of their respective shares of such proceeds. 2. The determination of taxes, duties, tolls, and fees which may be assigned to or appropriated by municipalities. 3. The grants in aid to municipalities from the consolidated funds of the state. B. Measures needed to improve the financial position of municipalities. C. Grants in aid by the governor in the interests of sound finances of municipalities. 2. The governor shall cause every recommendation made by the commission under this article, together with an explanatory memorandum as to the action taken thereon, to be laid before the legislature of the state. 243Z. Audit of accounts of municipalities. 243ZA. Elections to municipalities. 1. The superintendence, direction, and control of the preparation of electoral rolls for, and the conduct of, all elections to municipalities shall be vested in the State Election Commission referred to in Article 243K. 2. Subject to the provisions of the Constitution, the legislature of a state may, by law, make provision with respect to matters relating to, or in connection with, elections to municipalities. From the above description of the articles, one can describe the organization, functions, and other details of the municipal bodies as follows. The Constitution, as amended, provides for the establishment of Nagar Panchayats for transitional areas, that is to say, an area in transition from a rural area to an urban area, municipal councils for smaller urban areas, and municipal corporations for larger urban areas. However, no municipality can be constituted in areas that come under the jurisdiction of an industrial establishment that provides or proposes to provide municipal services therein. All seats in municipal bodies are filled by persons chosen by direct election from the territorial constituencies in the municipal area. However, the legislature of a state may, by law, provide for the representation in a municipal body of persons having special knowledge or experience of municipal administration, members of the Rajya Sabha, Lok Sabha, Legislative Council, and Legislative Assembly of the state, representing constituencies which comprise wholly or partly the municipal area, and chairpersons of ward committees. There are wards committees, consisting of one or more wards, within the territorial area of a municipal body having a population of 300,000 or more. The legislature of a state may, by law, make provisions with respect to the composition and the territorial area of a ward committee and the manner in which seats in a ward committee may be filled. The legislature of a state can also make provisions for the constitution of other committees in addition to ward committees. Seats are reserved for the scheduled castes and the scheduled tribes in every municipal body in proportion to their population. Out of these reserved seats, for scheduled castes and scheduled tribes, 1/3 are reserved for women belonging to these communities. Similarly, not less than 1/3 of the total number of seats to be filled by direct election in every municipal body are reserved for women, including their reservation in the quota of scheduled castes and scheduled tribes. Similarly, the offices of chairpersons in municipal bodies are reserved for the scheduled castes, the scheduled tribes, and women in such a manner as the legislature of a state may, by law, provide. The legislature of a state may also make provisions for the reservation of seats in municipal bodies or offices of chairpersons for other backward classes. A person who has attained the age of 21 years is eligible to be elected as a member of a municipal body. The superintendence, direction, and control of the preparation of electoral rolls for and the conduct of elections to municipal bodies is vested in the State Election Commission, constituted with reference to elections for Panchayati Raj institutions. The term of a municipal body is 5 years. Municipalities can, however, be dissolved earlier after giving them reasonable opportunity of being heard. Election of a new municipal body is to be held before the expiry of its term or within 6 months of its dissolution, as the case may be. The legislature of a state may extend the powers and authority of municipal bodies, if necessary, to enable them to function as institutions of self-government. It may authorize a municipal body to levy, collect, and appropriate such taxes, duties, tolls, and fees as it thinks fit. It may also assign a share in those taxes, duties, tolls, and fees that are levied and collected by the state government itself. It may also make provisions for making grants in aid to municipal bodies from the consolidated fund of the state. It may also provide for constitution of such funds for crediting all money received by municipal bodies and their withdrawal. The Finance Commission, constituted with reference to Panchayati Raj institutions, is charged with the responsibility of reviewing the financial position of municipal bodies and make recommendations to the governor as to the principles which would govern the distribution between the state and the municipal bodies of the net proceeds of the taxes. The structure envisaged by the 74th Amendment is elaborate. For a total of 101 city corporations, 1,430 municipalities, and 2,091 nagarpalikas in the country, 2007, so far elections have been held 2 to 3 times. The number of elected representatives for all urban local bodies is about 70,000. Of the 3,640 chairpersons of these bodies, at least one-third are women. The All India Council of Mayors is also presently headed by a woman. These are all visible signs of a significant arithmetical change in the representative structure of the nagarpalikas. But the question remains whether this amounts to the functioning of an effective democracy. Available evidence indicates several deficits. Decentralization deficit is one such deficit. Indeed, Schedule 12 identifies as many as 18 functions for nagarpalikas, such as urban planning, regulation of land use, construction of buildings, planning for economic and social development, roads and bridges, water supply, public health, sanitation, fire services, urban forestry, slum improvement, urban poverty alleviation, urban amenities, aesthetics aspects, burials and burial grounds, cattle ponds, and prevention of cruelty to animals, public amenities such as lighting, bus stops, and public conveniences, and regulation of slaughterhouses. However, these are not mandatory but common with the work area of state government between, for example, water supply and urban planning, sometimes generating conflict between the state and urban municipal administration. Another serious deficit may be the state government's control over urban institutions. The government control is always pervasive. States' finances, which flow as routine, sometimes stop as willed by the state government. The accountability factor in urban institutions is always weak, though the structure of the institution is elaborate. Provisions with regard to the decentralization in cities and towns are always vague. Ward committees have not been effective, nor do they participate in their zonal committees effectively. There is a lack of proximity between the elected representatives and the people who elect them. Power sharing between the union government and state governments has not been a happy exercise in India. The same has been the case between the state governments and local bodies, more or less. LLL. Panchayati Raj Historical Overview. The Panchayati Raj system in India has existed from the time as far back as we can imagine. Evidences from the time of the Rig Veda suggest the existence of self-governing bodies in villages. With the passage of time, these bodies became panchayats, council of 5 persons. Panchayats constituted functional institutions of grassroots governance in villages. They used to distribute land among farmers and collect revenue in kind earlier and in cash later, especially during the British rule. Thus, with the passage of time, and particularly during the British colonial rule, the village self-sufficiency gave way to feudalism and the zamindari system, leading to the exploitation of farmers, rural poverty, unemployment, and backwardness. The British commercialization of agriculture destroyed all that was good in the villages of India. Gandhi's village Gram Swaraj was an attempt to give back to village panchayats what was lost during the British rule, though during the period of national movement much was not resolved by the leadership in this regard. Gandhi favored the village Swaraj and Dr. B.R. Ambedkar opposed the idea. During the drafting of the Constitution, the Directive Principles of State Policy (DPSP) under Article 40 provided for the state effort to organize village panchayats as units of self-governance, though the complete Part 4 dealing with Directive Principles of State Policy was made non-justiciable. Panchayati Raj as an institution has gone through numerous stages. The first 5-year plan failed to bring about active participation of the people in the plan process. The second 5-year plan sought to cover the entire countryside with national extensive service blocks through officials and locally elected people, but this too failed to attain the desired results relating to grassroots democracy. The Balwantrai Meta Committee, 1957, studied the community development projects and the National Extension Service. The committee held the view that community development would come up if the community, especially the village one, was involved in the planning, decision-making, and implementation. The suggestions given by the Balwantrai Meta Committee were: 1. An early establishment of elected local bodies and devolution to them of necessary resources, power, and authority. 2. That the basic unit of democratic decentralization was at the block/samity level, since the area of jurisdiction of the local body should neither be too large nor too small. The block was large enough for efficiency and economy of administration and small enough for sustaining a sense of involvement of citizens. 3. Such a body must not be constrained by too much control by the government or government agencies. 4. The body must be constituted for 5 years by indirect elections from village panchayats. Its functions should cover the development of agriculture in all its aspects, the promotion of local industries and services such as drinking water, road building, etc. and 5. The higher-level body, Zilla Parishad, should play an advisory role. The structure of Panchayati Raj institutions (PRIs), which developed subsequently, did not yield requisite democratic momentum. Hence, the expected rural development did not occur. Political and bureaucratic interferences by the state, lack of adequate financial resources, pathetic awakening at the rural level, domination by the rural elite, and the like were major factors responsible for the dismal result. A prime reason for the non-realization of the results of the rural development was fiscal. In 1963, the K. Sanham Committee was appointed to study the PRI finances. The committee recommended the following. A. Panchayats should have special powers to levy special tax on land revenues and home taxes, etc. B. People should not be burdened with too many demands taxes. C. All grants and subventions at the state level should be mobilized and sent in a consolidated form to various PRIs. D. A Panchayati Raj Finance Corporation should be set up to look into the financial resource of PRIs at all levels, provide loans and financial assistance to these grassroots level governments, and also provide non-financial requirements of villages. These issues have been debated over the last 3 decades and have been taken up by the state finance commissions, which are required to select taxes for assignment and sharing, identifying the principles for such sharing and assignment, determine the level of grants, and recommend the final distribution of states' transfers to local authorities. The Janata Party rule at the center 1977 found numerous weaknesses in the functioning of the Panchayati Raj. The government decided to appoint a high-level committee under the chairmanship of Ashok Mehta 1978 to examine measures to strengthen PRIs. The recommendations of the Ashok Mehta Committee were: I. The district is a viable administrative unit for which planning, coordination, and resource allocation are feasible and technical expertise available. 2. PRIs is a 2-tier system with Mandal Panchayat at the base and Zilla Parishad at the top. 3. The PRLs are capable of planning for themselves with resources available to them. 4. District planning should take care of the urban-rural continuum. V. Representation of SCs and STs in the election to PRIs on the basis of their population. 6. 4-year term of PRIs. 7. Participation of political parties in elections. 8. Any financial devolution should be committed to accepting that much of the developmental functions at the district level would be played by the panchayats. The states of Karnataka, Andhra Pradesh, and West Bengal passed new legislations based on this report. However, politics at the state level did not allow these institutions to develop their own political dynamics. The Jeev K. Rao Committee was appointed in 1985 to look at various aspects of PRIs once again. The committee was of the opinion that a total view of rural development must be taken, in which PRIs must play a central role in handling people's problems. It recommended the following. A. PRIs have to be activated and provided with all required support to become effective organizations. B. PRIs at the district level and below should be assigned the work of planning, implementation, and monitoring of rural development programs, and C. The Block Development Office should be the spinal cord of the rural development process. The LM Singhavi Committee studied the Panchayati Raj system in 1986. The Gram Sabha was considered as the base of a decentralized democracy, and PRIs were viewed as institutions of self-governance which would actually facilitate the participation of the people in the process of planning and development. It recommended A. Local self-government should be constitutionally recognized, protected, and preserved by the inclusion of a new chapter in the Constitution. B. Non-involvement of political parties in panchayat elections. The suggestion of giving panchayats the constitutional status was opposed by the Sarkaria Commission, but the idea gained momentum in the late 1980s when the late Prime Minister Rajiv Gandhi introduced the 64th Constitutional Amendment Bill in 1989. The 64th Constitutional Amendment Bill was prepared and introduced in the lower house of Parliament, but it got defeated in the Rajya Sabha as non-convincing. He lost the general elections. In 1989, the National Front government introduced the 74th Constitutional Amendment Bill, which could not become an act because of the dissolution of the 9th Lok Sabha. All these various suggestions and recommendations and means of strengthening PRIs were considered again while formulating the new Constitutional Amendment Act. 4. Rural Administration and the 73rd Amendment, Panchayati Raj Institutions. Part 9, from Articles 243 to 2430, deals with institutions of the Panchayati Raj. Article 243 defines panchayats to include Gram Sabha, Gram Panchayat, a panchayat at the intermediate level as also one at the district level. The constitutional provisions relating to panchayats can be stated as follows. 243a. Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of a state may, by law, provide. 243b. Constitution of Panchayats. 1. There shall be constituted in every state a panchayat at the village, intermediate, and district level in accordance with the provisions of this part. 2. Notwithstanding anything in Clause 1, panchayats at the intermediate level may not be constituted in a state having a population not exceeding 2 million. 243c. Composition of panchayats. 1. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayats, provided that the ratio between the population of the territorial area of a panchayat at any level and the number of seats in such panchayat to be filled by election shall, so far as practicable, be the same throughout the state. 2. All seats in a panchayat shall be filled by persons chosen by direct election from territorial constituencies in the panchayat area, and, for this purpose, each panchayat area shall be divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the panchayat area. 3. The legislature of a state may, by law, provide for the representation a. of chairpersons of panchayats at the village level, panchayats at the intermediate level, or, in the case of a state not having panchayats at the intermediate level, panchayats at the district level. B. Of chairpersons of panchayats at the intermediate level and the district level. C. Of members of the House of the People and the Legislative Assembly of the state representing constituencies which comprise wholly or partly a panchayat area at a level other than the village level in such panchayats. D. Of members of the Council of States and the members of the Legislative Council of the state, where they are registered as electors within a panchayat area at the intermediate level and at the district level. 4. The chairperson of a panchayat and other members of a panchayat, whether or not chosen by direct election from territorial constituencies in the panchayat area, shall have the right to vote in the meetings of the panchayats. 5. The chairperson of a panchayat at the village level shall be elected in such manner as the legislature of a state may, by law, provide, and b. A panchayat at the intermediate level or district level shall be elected by and from amongst the elected members thereof. 243d. Reservation of seats. 1. Seats shall be reserved for a. the scheduled castes and b. the scheduled tribes. 2. Not less than 1/3 of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. 3. Not less than 1/3, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every panchayat shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a panchayat. 243e. The term of panchayats has to be 5 years unless dissolved earlier than that, the election for a new panchayat to be completed within 6 months before the expiration of its normal term. No election for a new panchayat if there remains 6 months of its normal term. 243f. Deals with disqualifications for membership to be stated by law. 243g. Powers, authority, and responsibilities of panchayats. Subject to provisions of the Constitution, the legislature of a state may, by law, confer on panchayats such powers and authority as may be necessary to enable them to function as an institution of self-government, and such law may contain provisions for the devolution of powers and responsibilities to panchayats at the appropriate level, subject to such conditions as may be specified therein with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th schedule. 243h. Powers to impose taxes and funds for panchayats. The legislature of a state may, by law, a. authorize a panchayat to levy, collect, and appropriate such taxes, duties, tolls, and fees in accordance with procedures and limits laid down by the state legislature. b. Assign to a panchayat such taxes, duties, tolls, and fees levied and collected by the state government for such purposes, subject to conditions and limits specified. c. Provide for making grants in aid to panchayats from the consolidated fund of the state, and d. Provide for constitution of such funds for crediting monies received by or on behalf of panchayats, and also for the withdrawal of such monies therefrom as may be specified in the law. 243/ Constitution of Finance Commission to review financial position. 1. The governor of a state shall, as soon as possible, maybe within 1 year from the commencement of the Constitution 734 Amendment, Act, 1992, and thereafter at the expiration of every 5th year, constitute a finance commission to review the financial position of panchayat and to make recommendations to the governor as to a. Principles which should govern I. The distribution between the state and panchayats of the net proceeds of the taxes, duties, tolls, and fees leviable by the state, which may be divided between them under this part, and the allocation between the panchayats at all levels of their respective shares of such proceeds. 2. The determination of the taxes, duties, tolls, and fees which may be assigned to or appropriated by panchayats. 3. The grants in aid to panchayats from the consolidated fund of the state. B. Measures needed to improve the financial position of panchayats. C. Any other matter referred to the Finance Commission by the governor in the interests of sound finance of panchayats. 2. The legislature of a state may, by law, provide for the composition of the commission, the qualifications which shall be requisite for appointment as members thereof, and the manner in which they shall be selected. 3. The commission shall determine its procedure and shall have such powers in the performance of their functions as the legislature of the state may, by law, confer on them. 4. The governor shall cause every recommendation made by the commission under this article together with an explanatory memorandum as to be action taken thereon to be laid before the legislature of the state. 243J. Audit of accounts of panchayats. 243K. Elections to panchayats. 1. The superintendence, direction, and control of the preparation of electoral rolls for and the conduct of all elections to panchayats shall be vested in a state election commission consisting of a state election commissioner to be appointed by the governor. 2. Subject to the provisions of law made by the legislature of a state, the conditions of service and tenure of office of the state election commissioner shall be such as the governor may by rule determine, provided that the state election commissioner shall not be removed from his office except in the manner and on ground provided for a judge of a high court, and the conditions of service of the state election commissioner shall not be varied to his disadvantage after his appointment. 3. The governor of a state shall, when so requested by the state election commission, make available to the state election commission such staff as may be necessary for the discharge of the functions conferred on the state election commission by clause 1. 4. Subject to the provisions of the Constitution, the legislature of a state may, by law, make provisions with respect to matters relating to or in connection with elections to panchayats. 243 Elemento. Details regarding panchayats, largely not important for our purposes. From the above, certain features relating to Panchayati Raj institutions are: 1. The Gram Sabha or village assembly as a deliberative body to decentralize the governance has been envisaged as the foundation of the Panchayati Raj system, having a population of over 2 million. 2. A uniform three-tier structure of panchayats at village, Gram Panchayat, GP, Intermediate Panchayat Samiti PS, and District Zilla Parishad ZP levels. It applies to all states. 3. All seats in a panchayat at every level are to be filled by elections from respective territorial constituencies. 4. Not less than 1/3 of the total seats for membership as well as the office of chair. Not less than 1/3 of the total seats for membership as well as the office of chairpersons of each tier has to be reserved for women. For the scheduled castes and tribes, SCs and STs have to be provided at all levels in proportion to their population in the panchayat. 6. To supervise, direct, and control regular and smooth elections to panchayats, a state election commission has to be constituted in every state and the union territory, UT. 7. The Act has ensured the constitution of a state finance commission in every state/UT for every 5 years to suggest measures to strengthen the finances of PRIs. To promote bottom-up planning, a district planning committee, DPC, in every district has been accorded a constitutional status. 9. An indicative list of 29 items has been given in the 11th schedule of the Constitution. Panchayats are expected to play an effective role in planning and implementation of works related to 29 items, which include, among others, agriculture, land improvement, animal husbandry, fisheries, a rural social forestry, khadi and village industries, rural housing, drinking water, fuel and fodder, bridges, ferries, waterways, rural electrification, poverty alleviation, and public distribution system. At present, there were in 2014 about 3 lakh elected representatives at all levels of the Panchayati system, 1/3 of which are women. These members represent more than 237 for 26 gram panchayats, 6,326 intermediate level tiers, and 593 district panchayats. Spread over the length and breadth of the country, the panchayats cover about 96% of India's more than 5.8 lakh villages and nearly 99.6% of the rural population. This is the largest experiment in the decentralization of governance in the history of humanity. The scheduled castes number 521,522 and the scheduled tribes 317,479 at all levels. A lack of funds, apathy at the rural level, unclear division of power resulting in duplication and sometimes triplication of responsibility, and frequent state interference in one form or another slows down the work of PRIs and renders them inefficient. Other drawbacks of PRIs are: 1. The uniformity of the system undermines each state's unique history, traditions, and consequent structures of local government. 2. Representation of members of parliament and state legislatures are often counterproductive. There are clashes of interests between legislators and PR representatives, particularly for getting votes. 3. The Act does not define the role of political parties clearly. It doesn't mention that political parties can enter the election arena in their formal capacity. 4. The Act is silent about the relationship between PRIs and local bureaucracy. 5. The Act doesn't spell out specific grounds for a dissolution of PRIs by states. This gives scope for states to dissolve PRIs on political considerations. Though the PRI system has so many positive features, the elite control over the system, the apprehensions of state-level leaders of challenge to their power and the lukewarm attitude of the bureaucracy have not allowed the PRIs to function as a real democratic institution with the people's participation. Studies from different states in India clearly prove that even though some states have shown political activism to implement PRIs, the unequal social structure and rigid caste system prevalent in Indian villages coupled with power-hungry local bureaucracy kill the spirit of the system. District and metropolitan planning. The 73-inch and the 74th Amendments bestow planning tasks on local, rural, and urban bodies. The Constitution makes elaborate provisions. 243 ZB. Committee for District Planning. 1. There shall be constituted in every state at the district level a district planning committee to coordinate plans prepared by panchayats and municipalities in the district and to prepare a draft development plan for the district as a whole. 2. The legislature of a state may, by law, make provisions with respect to a. The composition of the district planning committee. B. The manner in which the seats in such a committee shall be filled up, provided that not less than 4/5 of the total number of members of such a committee shall be elected by and from amongst the elected members of the panchayat at the district level and of municipalities in the district in proportion to the ratio between the population of rural areas and of urban areas in the district. C. The functions relating to district planning which may be assigned to such committees. D. The manner in which the chairpersons of such committees shall be chosen. 3. Every district planning committee shall, in preparing the draft development plan, a. have regard to matters of common interest between the panchayats and municipalities. 2. Matters of common interest between the municipalities and panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 3. The overall objectives and priorities set by the Government of India and the Government of the state. 4. The extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and the Government of the state and other available resources whether financial or otherwise. B. Consult such institutions and organizations as the Governor may, by order, specify. 4. The chairperson of every metropolitan planning committee shall forward the development plan as recommended by the committee to the Government of the state. The above articles can be summed up in simple words as thus. Committees for district planning are to be constituted in every state at the district level to coordinate the plans prepared by panchayats and municipal bodies in the district and to prepare a draft development plan for the district as a whole. The committee needs to, in preparing the draft development plan, have regard for matters of common interest between panchayats and municipal bodies. The chairperson of every district planning committee has to forward the development plan to the Government of the state. An area having a population of 1 million or more, comprised in 1 or more districts and consisting of 2 or more municipal bodies or panchayats may be declared by the Governor of the state as a metropolitan area. Every metropolitan area has a metropolitan planning committee to prepare a draft development plan for the metropolitan area as a whole. The legislature of a state may, by law, make provisions with respect to the composition of the metropolitan committees and the manner in which seats in such committees are to be filled, the representation in such committees of the union and state governments, and the manner in which the chairpersons of such committees should be chosen. However, not less than 2/3 of the members of such committees are elected by and from amongst the elected members of municipal bodies and the chairpersons of panchayats in the metropolitan area in proportion to ratio between population of municipal bodies and panchayats in that area. Every metropolitan planning committee has to, in preparing the draft development plan, have regard for the plans prepared by municipal bodies and panchayats in the metropolitan area and also to matters of common interest between municipal bodies and panchayats. The chairperson of every metropolitan planning committee shall forward the development plan to the Government of the state. Practice questions. 1. Trace the history of urban local government in India. 700 to 800 words. 2. Write a detailed note on the 74th Amendment of the Constitution. 700. 800 words. 3. What are the major drawbacks of the Nagarpalika system with reference to 74th Amendment? 200 to 250 words. 8. Explain how has the participation of women impacted the functioning of rural local bodies in India. 2014, 700 to 800 words. 4. Trace the history of the Panchayati Raj system in India. 700 to 800 words. 5. Write a detailed note on the 73-inch amendment of the Constitution. 700. 800 words. 6. What are the major drawbacks of the Panchayati Raj system with reference to the 73D Amendment? 200 to 250 words. 7. Write an essay on district and metropolitan planning. 200 to 250 words. 9. Examine the changing structure of Panchayati Raj institutions with special reference to the 73rd Constitutional Amendment Act. 2013, 700 to 800 words. The statutory institutions/commissions. The Constitution and some through the laws of Parliament. Each such commission or institution exists for some purpose. Discussed below are these commissions. 7. Here are numerous commissions, some provided in. The Election Commission. The Election Commission of India is an autonomous, quasi-judicial and a constitutional body established for the Election Commission of India is an autonomous, quasi-judicial and a constitutional body established for the purpose of conducting fair and free elections to representative institutions as they exist in the country. Set up on January 25, 1950, under Article 324 of the Constitution, the Election Commission may rightly be described as one of the pillars of our polity. The Election Commission, until 1989, was a one-person institution called the Chief Election Commissioner. In 1989, 2 additional members called Election Commissioners were appointed, making the Election Commission a 3-official body. But the 2 were removed in January 1990. Now, under a law of the Parliament of 1991, the Election Commission consists of the Chief Election Commissioner and such other members as the President may fix. At present there are 2 election commissioners, besides the Chief Election Commissioner. The President of India appoints the Chief Election Commissioner and other election commissioners. All of them enjoy a term of 6 years or up to the age of 65 for the Chief Election Commissioner and 62 years for election commissioners, whichever is earlier. The Election Commissioner status is equivalent to that of a judge of the Supreme Court. The Chief Election Commissioner can be removed on grounds as those of a judge of the Supreme Court, and other election commissioners may be removed on the recommendations of the Chief Election Commissioner. The powers and functions of the Chief Election Commission relate mainly to the conduct of elections in the country. Its functions can be summed up as under 1. Conduct of elections to Parliament. 2. Conduct of elections to the state legislatures including the Union territories. 3. Conduct of elections to offices of the President and Vice President. It also does the work connected with the following functions like A. The preparation of electoral rolls. B. Fixing the dates of elections. C. Supervising the elections. D. Arranging for the counting of votes and declaring the results, and E. Advising the President in regard to disputes like whether a member of Parliament or a state legislature has become subject to any disqualification or not. 4. Demarcation of constituencies. 5. Recognition of political parties and allotment of election symbols. 6. Scrutiny of election expenses of candidates. Thus, the responsibility of conducting the elections is that of the Election Commission. During the elections, the entire central and state government machinery, including paramilitary forces and the police, is deemed to be on deputation to the Election Commission, which takes effective control of personnel, movable and immovable government properties it deems necessary for successful completion of the electoral process. The Election Commission is independent of government control so as to allow it to act impartially. The Commission's independence is ensured by provisions as given below. A. The appointment of an election commissioner is not based on the pleasure of any body. It is an appointment for a term of 6 years or till the person attains the age of 65 years, whichever is earlier. B. An election commissioner may be removed on the same grounds and by the same method as applicable to a judge of the Supreme Court. C. Conditions of service of a commissioner shall not be varied to his disadvantage after his appointment. D. An election commissioner shall not be removed from office except on the recommendation of the Chief Election Commissioner. E. The Union and the state governments are under obligation to make available to the Commission such staff as may be necessary for the discharge of its functions. The Election Commission is autonomous and independent in the sense that it separates itself from every kind of executive interference. It is quasi-judicial in matters relating to electoral disputes. It may be stated here that its recommendations and opinions are usually binding on the governments. The Commission gives its annual report to the President. The fact that the Election Commission has performed its task in the most efficient and honest manner is a testimony of our successful experiment with democracy. The difference between a genuine and pseudo-democracy depends mainly on the independent functioning of the Election Commission. Notwithstanding political controversies surrounding the office and composition of the Election Commission in India, our election machinery working under the Election Commission has done its job remarkably well. The Comptroller and Auditor General of India. Article 148(1) of the Constitution says that there shall be a Comptroller and Auditor General of India, who is to be appointed by the president for a period of 6 years, or till he attains the age of 65 years, whichever is earlier. He can be removed from office in the same manner and on the same grounds as a judge of the Supreme Court. The Parliament determines his salary and other conditions of service, and until it does so, he is to be governed by conditions as specified in the second schedule. His oath or affirmation is prescribed in the third schedule of the Constitution. As an important pillar of the state, the Comptroller and Auditor General of India has a dual role. I. To ensure that the executive complies with laws passed by the legislature in letter and spirit. He does so on behalf of the Parliament. 2. On behalf of the executive, i.e., government. He ensures compliance by subordinate authorities with rules and orders issued by the executive. The Comptroller and Auditor General is neither a part of the Parliament nor that of the Council of Ministers executive. But his office is so important that he has to see the diverse authorities act in regard to all financial matters in accordance with the Constitution and the laws framed under it. Under the Comptroller and Auditor General Act, 1971, his duties and powers can be summed up as under 1. To make rules for carrying out the provisions relating to the maintenance of accounts. 2. To make regulations for carrying out the provisions relating to the scope and extent of audit, including laying down for the guidance of government departments general principles of government accounting and broad principles in regard to the audit of receipts and expenditure. 3. To requisition of all records of the audit departments/organizations. 4. To access computer systems of the auditees and to download and use electronic data if necessary. 5. To review the development of computer systems of auditees and suggest/enforce controls. 6. To approve the appointment of external auditors engaged by auditees for meeting any statutory requirements, but only with reference to government companies. 7. To supervise and regulate external auditors' work under the Indian Companies Act. 8. To dispense with, when circumstances so warrant, any part of the detailed audit of any account or class of transactions and to apply such limited check in relation to such accounts or transactions as he may determine. As per the Act of 1971, the jurisdiction of the Comptroller and Auditor General of India extends to a. All the union and state government departments, including departmental commercial undertakings such as the Indian Railways and Posts and Telecommunications. b. Public commercial enterprises controlled by the union and state governments, i.e. government companies and corporations. c. Non-commercial autonomous bodies and authorities owned or controlled by the union or states. d. Authorities and bodies substantially financed from union or state revenues. e. Companies where the equity participation by government is 51% or more. f. Any authority or body, not being a foreign state or international organization, which gets grant or loan for any specific purpose from the Consolidated Fund of India or of a state or union territory having a legislative assembly. g. Audit of all receipts which are payable into the Consolidated Fund of India or state or union territory having a legislative assembly. h. Audit of regulatory bodies such as Telecom Regulatory Authority of India, TRAI, Central Electricity Regulatory Commission, CERC, State Electricity Regulatory Commissions, CERCs, and Insurance Regulatory Authority and Development Authority. However, the role of audit of regulatory authorities is at present confined only to the extent of certifications of their accounts, as audit scrutiny over regulatory functions is still somewhat nebulous. The Comptroller and Auditor General of India follows audit procedures and performs his functions accordingly. He has to follow specific standards, practices, and guidelines in conducting the audit and reporting. He can engage consultants and/or obtain professional services in conducting the audit. He can also consult and collaborate with other countries/SALs and international organizations on matters relating to audit. Apart from certificates of appropriation and finance accounts of the Union and states and submission of separate audit reports on statutory corporations and other autonomous bodies for which he is the sole auditor, the Comptroller and Auditor General of India brings out a large number of reports relating to the Union government and the state governments. These reports incorporate important audit findings and performance reviews of systems, projects, and programs and comprehensive appraisals of public enterprises and other bodies and authorities. He also reports on acts that infringe upon the state economic interest like embezzlement of state assets, serious losses, and wastes. These reports are laid before the Parliament and state legislatures concerned every year. He can share his audit reports with public and media only after laying them in the Parliament and the state legislatures. Some of these reports are selected by the Public Accounts Committee of Parliament and state legislatures for detailed discussions and recommendations. The Comptroller and Auditor General of India assists the Public Accounts Committee by vetting the action taken, notes on selected reports. Though India is a federal type of polity, the Constitution provides for a unitary audit by the Comptroller and Auditor General of India who conducts the audit of the accounts of both the Union and state governments. For ensuring his independent functioning, the Constitution provides particularly the following. I. He is appointed by the President of India by warrant under his hand and seal, and his oath of office requires him to uphold the Constitution of India and laws made thereunder. 2. He shall hold office for a term of 6 years from the date on which he assumes office, provided that where he attains the age of 65 years before the expiry of the said term of 6 years, he shall vacate such office on the date on which he attains the said age, and that he may, at any time, by writing under his hand addressed to the President, resign from his office. 3. He can be removed from office only on grounds of proven misbehavior or incapacity after an address by both Houses of Parliament supported by a 2/3 majority. 4. His salary and conditions of service cannot be varied to his disadvantage after appointment. V. He shall not be eligible for further office under the Government of India or of any state after retirement. 6. His administrative powers and the conditions of service of persons serving in Indian Audit and Accounts Department shall be prescribed by rules made by the President only after consulting him. 7. The administrative expenses of his office are charged upon the Consolidated Fund of India and are not subject to being voted by Parliament. LLL. Finance Commission. The Constitution of India provides for, under Article 280, the establishment of a finance commission for the purpose of allocation of certain resources of revenue between the union and state governments. Qualifications, powers, and procedures of the Commission are regulated by the Commission itself under Finance Commission, Miscellaneous Provisions Act, 1951. Such commissions are deemed to be civil courts for the purpose of the Code of Criminal Procedure, 1898. Finance Commission is appointed every 5th year. The President appoints the chairman of the commission and 4 other members whose qualifications are determined by the Parliament. Under Article 280 of the Constitution, the Finance Commission is required to make recommendations to the President in respect of the following. 1. The distribution of net proceeds of taxes to be shared between the center and states, and the allocation between states the respective share of such proceeds. 2. Principles to govern the grants and aid by the center to states out of the Consolidated Fund of India. 3. Measures needed to augment the Consolidated Fund of a state to supplement the resources of panchayats and municipalities in the state on the basis of the recommendations made by the State Finance Commission. 4. Any other matter referred to it by the President in the interests of sound finance. The major recommendations of the 14th Finance Commission appointed for 2015 to 2020 as reported by Professor Y.U. Reddy are: 1. The share of states in the net proceeds of the shareable central taxes should be 42%. This is 10% higher than the recommendation of 13th Finance Commission. 2. Revenue deficit to be progressively reduced and eliminated. 3. Fiscal deficit to be reduced to 3% of the GDP by 2017. 18. 4. A target of 62% of GDP for the combined debt of center and states. 5. The Medium-Term Fiscal Plan, MTFB, should be reformed and made the statement of commitment rather than a statement of intent. 6. FRBM Act need to be amended to mention the nature of shocks which shall require targets relaxation. 7. Both center and states should conclude grand bargain to implement the Model Goods and Services Act, GST. 8. Initiatives to reduce the number of central sponsored schemes, CSS, and to restore the predominance of formula-based plan grants. 9. States need to address the problem of losses in the power sector in time-bound manner. 10. Sector-specific grants be stopped. 4. Union Public Service Commission. The Constitution, under Article 315, provides for a Public Service Commission for the Union and a Public Service Commission for each state. There is a provision stipulating that, if the legislatures of 2 or more states request so, a Joint Public Service Commission, JPSC, can be set up for 2 or more states. The Union Public Service Commission, UPSC, with the approval of the President, can serve the needs of any state if required by the concerned governor. The President appoints the chairman and other members of the UPSC and JPSC, while the chairman and other members of the Public Service Commission of a state are appointed by the governor of the state. In each commission, half the members have to be persons who would have served the Government of India or the government of the state, as the case may be, for at least 10 years. The term of each member of any commission is 6 years unless he has attained the age of 65 years in the case of a UPSC member and 62 years in the case of a State of Joint Public Service Commission member, Article 316. A member may resign from his office or may be removed from office by the President if he is adjudged an insolvent or engages in any paid employment outside the duties of his office or is in the opinion of the President infirm in mind or body. He cannot be removed from office on any other ground except if the Supreme Court finds him guilty of a proven misbehavior on a reference made to it by the President. The word misbehavior has been explained in the Constitution. A member shall be deemed to be guilty of misbehavior if I. He is interested or concerned in any contract or agreement made on behalf of the Government of India or of a state, or 2. if he participates in any way in the profit of such contract or agreement in tandem with other members of an incorporated company. The powers and functions of the Union Public Service Commission (UPSC) can be classified as 1. Regulatory, 2. Executive, and 3. Quasi-judicial. These functions may be explained as follows. 1. Regulatory. Among the regulatory functions, the UPSC advises the government in matters relating to I. Methods of recruitment, and the second, principles to be followed in making appointments, promotions and transfers from one service to another. The UPSC's jurisdiction is purely advisory. Article 323 of the Constitution merely states that it is the duty of the Commission to advise the government on all matters relating to methods of recruitment to civil services, promotions, and transfers. 2. Executive. The Commission has a specific constitutional duty of conducting examinations for appointments to the services of the Union. Under this provision, the UPSC conducts written examinations for different categories of posts annually besides holding interviews for selection of candidates for specialized and other categories of positions. It may be noted that the Commission's jurisdiction is narrowly restricted to gazetted officers who constitute an insignificant portion of the total number of government employees. This means that the executive jurisdiction of the Commission extends to only 1.9% of the total employees of the central government. Another executive function of the UPSC is to present annually to the President a report of the work done by the Commission during the preceding year. The President is obliged to place the report before both Houses of Parliament with a memorandum explaining the cases, if any, where the advice of the Commission was not accepted and reasons for such non-acceptance. 3. Quasi-judicial. The quasi-judicial jurisdiction of the UPSC is limited both in scope and extent. In fact, it has no true appellate jurisdiction. It can only advise on disciplinary actions taken against employees. According to the Constitution, the government should consult the Commission on the following matters. All disciplinary actions affecting a government employee like censure, withholding of increments or promotion, demotion to a lower grade, compulsory retirement, removal or dismissal from service, etc. 2. Claims for reimbursement of costs incurred by an employee in legal proceedings instituted against him in respect of acts done in the execution of his duty. 3. Claims for the award of pension in respect of injuries sustained by an employee and any question as to the amount of any such award. Constitution of India, Article 323. 3c. The UPSC derives its functions, apart from the Constitution of India as discussed above, from other sources like a. the laws made by the Parliament, b. rules, regulations, and orders of the executive, and c. conventions. Under Article 321 of the Constitution, the Parliament through legislations can confer additional functions on the UPSC pertaining to the services of the Union or states. If necessary, the Parliament can place the personnel system of any local authority, corporate body, or public institution within the jurisdiction of the Commission. According to Articles 318 and 320 of the Constitution, the central government through certain regulations and orders entrusts certain functions to the Commission. Also, the President may define from time to time through regulations matters in which the Commission need not be consulted. The Commission also discharges certain functions, such as conducting written tests for the selection of scientists and technicians for the pool of highly qualified scientists and technologists, who are deputed to the central government, scientific institutions, national laboratories, universities, etc. These functions are being discharged by the UPSC on the basis of conventions only. The independence of the UPSC has been ensured by the Constitution. The method of removal of a member of the UPSC is not easy. Lest any member is taken to corrupt practices, the Constitution provides for prohibitions after a member ceases to be a member on the Commission. The chairman of the UPSC becomes ineligible for further employment under the Government of India or the Government of a state. The chairman of a state public service commission becomes ineligible for appointment in the same commission. The member of the UPSC can become eligible to be the chairman of the UPSC but ineligible for any other appointment. Under the Government of India, the member of any state public service commission is eligible to be the chairman of the same public service commission or a member of the UPSC or the chairman of any other public service commission, but ineligible for the same position in the same public service commission. The UPSC has performed its role fairly well over the years. The executive's interference is limiting the scope of certain vacancies, or the number of vacancies make the UPSC rather ineffective or neglected. In certain other cases, the government interferes in delaying or deferring appointments or putting the recommendations of the Commission in abeyance. The UPSC is charged with observing too much secrecy in its functioning. V. National Commission for Scheduled Castes. The 89th Amendment Act, 2003, bifurcated the erstwhile National Commission for Scheduled Castes and Scheduled Tribes into two separate and independent commissions. Article 338 provides for a National Commission for the Scheduled Castes. The article reads, 1. There shall be a commission for the scheduled castes to be known as the National Commission for Scheduled Castes. 2. Subject to provisions of law made in this behalf by Parliament, the commission shall consist of a chairperson, vice-chairperson, and 3 members. Conditions of service and tenure of office of the chairperson, vice-chairperson, and members shall be such as the President may by rule determine. 3. The chairperson, vice-chairperson, and members of the commission shall be appointed by the President by warrant under his hand and seal. 4. The commission shall have the power to regulate its own procedure. 5. It shall be the duty of the commission A. To investigate and monitor all matters relating to the safeguards provided for the scheduled castes under the Constitution or under any order of the government and to evaluate the working of such safeguards. B. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes. C. To participate and advise on the planning process of socio-economic development of the scheduled castes, and to evaluate the progress of their development in the Union and states. D. To present to the President, annually and at such other times as the Commission may deem fit, reports upon the working of those safeguards. E. To make in such reports recommendations as to measures that should be taken by the Union or a state for the effective implementation of those safeguards and other measures for the protection, welfare, and socio-economic development of the scheduled castes. And F. To discharge such other functions in relation to protection, welfare, and development and advancement of the scheduled castes as the President may, subject to the provisions of law made by Parliament, by rule specify. 6. The President shall cause all such reports to be laid before each House of Parliament along with a memorandum explaining the action taken or proposed to be taken on recommendations relating to the Union and reasons for the non-acceptance, if any, of any such recommendation. 7. Where any such report or any part thereof relates to a matter with which a state government is concerned, a copy of such report shall be forwarded to the governor of the state who shall cause it to be laid before the legislature of the state along with a memorandum explaining the action taken or proposed to be taken on recommendations relating to the state and reasons for the non-acceptance, if any of any such recommendation. The Commission shall, while investigating any matter referred to in subclause A, or inquiring into any complaint referred to in subclause B of clause 5, have all powers of a civil court trying a suit, particularly in respect of as summoning and enforcing the attendance of any person from any part of India and examining him on oath. B. Requiring the discovery and production of any document. C. Receiving evidence on affidavits. D. Requisitioning any public record or copy thereof from any court or office. E. Issuing summons for the examination of witnesses and documents. F. Any other matter which the President may, by rule, determine. 9. The Union and every state government shall consult the Commission on all major policy matters affecting scheduled castes. The National Commission for the Scheduled Castes, NCSC, investigates and monitors the implementation of safeguards to the scheduled castes, covering activities such as the implementation of laws, provisions relating to reservations in recruitments, promotions, and admissions relating to educational institutions and economic development. The first report of NCSC was placed before the Parliament, i.e., report of 2004 to 2005 only in 2008. In addition to NCSC, the Stand ING Committee of Parliament on Social Justice and Empowerment also helps the welfare of the scheduled castes. The National Commission for the Scheduled Castes is doing its job remarkably well, especially in investigating the complaints of the violations of reserved quotas, though the participation of the scheduled castes themselves in fields relating to them is relatively low. Consequently, atrocities on the weaker sections and their low-level participation in educational institutions keep mounting. 6. National Commission for Scheduled Tribes. Article 338A was inserted as a result of the 89th Amendment Act, 2003, through which the National Commission for the Scheduled Tribes, NCST, after the bifurcation of the earlier National Commission for Scheduled Castes and Tribes, was to be constituted. The National Commission for the Scheduled Tribes consists of a chairperson, vice-chairperson, and 3 members. The President appoints these officials and determines their conditions of service and tenure of office. The duties of the NCST includes I. Investigation and monitoring of all matters relating to the safeguards provided for the scheduled tribes. 2. Inquiry into specific complaints with respect to the deprivation of rights and safeguards of the scheduled tribes. 3. Participating and advising on the planning process of socio-economic development of the scheduled tribes and evaluating the progress achieved. 4. Submitting reports to the President with regard to the working of the safeguards relating to the scheduled tribes. V. Making recommendations for the making recommendations for the improvement of the scheduled tribes, and 6. Discharging such other functions which may help protect, develop, and promote the welfare of the scheduled tribes. The Commission, while investigating any matter relating to the safeguards provided to the scheduled tribes, has all powers of a civil court and can act accordingly. The report of NCST, when submitted to the President, is placed before the Parliament by the President. The scheduled tribes in India constitute about 8.2% of the population and 15% of the country's areas. Their literacy rate is 47.1%, with the female literacy at 34.76%, and in numerous ecological and geoclimatic conditions ranging from plains to forests. These groups are on different stages of social, economic, and educational development. About 75% of them are characterized by pre-agricultural level of technology, a stagnant or declining population, extremely low literacy, and subsistence level of economy. About 500 such tribes have been notified under Article 342 of the Constitution. The government has to accord top priority to promote their all-round development, much more than what has been done for the scheduled tribes in the country. The constitutional provisions for the safeguards of the scheduled tribes have to be operationalized and laws enacted to promote their welfare. Happily, efforts are already on to improve the lot of the people belonging to the scheduled tribes. VIL. National Commission for Women. Women in India do not constitute a minority. They are not regarded as backward. In a patriarchal society as India is, women have always suffered numerous social disabilities. Indeed, certain steps are necessary to help improve the conditions of women in the traditionally male-dominated Indian society. The Constitution does not make specific provisions in favor of women, though Article 15, 3, 21, and 14 refer to some general provisions so as to provide for specific considerations for women. The Supreme Court, through interpretive processes, has tried to extend some safeguards to women. Through judgments in cases such as Bodhisattva Gautam vs. Subra Chakraborty, 1996, and the Chairman RLY Board vs. Chandrama Das, 2000 case where rape was declared a heinous crime, and a landmark judgment in Visakha vs. State of Rajasthan, 1997, courts have tried to improve the social conditions of Indian women. But these have hardly sufficed to improve the position of women in India. Thus, in the light of these conditions, the Committee on the Status of Women, India, as well as a number of NGOs, social workers, and experts who were consulted by the government in 1990 recommended the establishment of an apex body for women. The National Commission for Women Act, 1990, Act No. 20 of 1990 of Parliament, constituted the National Commission for Women as a statutory body. The first commission was constituted on January 31, 1992, with Mrs. Jayanti Patnaik as chairperson. The Act of 1990 under Section 3 provides for the constitution of the Commission. This section lays down that the Commission will consist of a chairperson who is committed to the cause of women, 5 members from various fields, and a member secretary who shall be an expert in the fields of management, organizational structure, sociological movement, or a member of the civil service of the Union. All the members of the Commission are nominated by the central government. Each person holds office for a period of 5 years or till he or she attains the age of 70. At least one member each of the Commission must belong to a scheduled caste or scheduled tribes each. In addition to the above-mentioned members of the Commission has power to set up committees with members from outside the Commission. Section 10(1) of the Act of 1990 provides for a 14-point mandate, i.e. functions for the National Commission for Women, NCW. The functions are: 1. Investigate and examine all matters relating to safeguards provided for women under the Constitution and other laws. 2. Present to the central government annually and at such other times as the Commission may deem fit reports upon the working of those safeguards. 3. Make in such reports recommendations for the effective implementation of those safeguards for improving the conditions of women by the Union or states. 4. Review from time to time the existing provisions of the Constitution and other laws affecting women and recommend amendments thereto so as to suggest remedial legislative measures to meet any lacunae, inadequacy, or shortcoming in such legislations. 5. Take up cases of violation of provisions of the Constitution and of other laws relating to women with the appropriate authorities. 6. Look into complaints and take sua moto notice of matters relating to a. Deprivation of women's rights, b. Non-implementation of laws enacted to provide protection to women and also to achieve the objectives of equality and development, c. Non-compliance of policy decisions, guidelines, or instructions aimed at mitigating hardships and ensuring welfare and providing relief to women, and take up the issues arising out of such matters with appropriate authorities. 7. Call for special studies or investigations into specific problems or situations arising out of discrimination and atrocities against women and identify the constraints so as to recommend strategies for their removal. 8. Undertake promotional and educational research so as to suggest ways of ensuring due representation of women in all spheres and identify factors responsible for impeding their advancement, such as lack of access to housing and basic services, inadequate support services, and technologies for reducing drudgery and occupational health hazards and for increasing their productivity. 9. Participate and advise on the planning process of socioeconomic development of women. 10. Evaluate the progress of the development of women activities under the Union and states. 11. Inspect or cause to be inspected a jail, remand home, women's institution, or other place of custody where women are kept as prisoners or otherwise, and take up with the concerned authorities for remedial action if found necessary. 12. Fund litigation involving issues affecting a large body of women. 13. Make periodical reports to the government on any matter pertaining to women and in particular various difficulties under which women toil, and 14. Any other matter which may be referred to it by central government. The Union government consults NCW on all policy matters affecting women. During the period between April 2003 and March 2004, NCW processed 5,462 complaints through its Complaints and Investigation Cell. Workshops and seminars are organized by NCW to discuss and suggest steps for improving the conditions of women. NCW's achievements over the years have been commendable. Some of these achievements can be mentioned. Due to efforts of NCW, Rupali Jain was reinstated as a teacher. SMT. Savitri had approached the NCW regarding the exploitation of her deaf and dumb daughter who, along with her child, had been deserted by her husband and in-laws allegedly due to her disabilities. The commission took up the matter and the husband was located and counseled. He agreed to rehabilitate with his wife and daughter. The commission was also successful in securing the release of Mrs. Siddhabala, name changed, who was allegedly gang-raped by BSF personnel in 2002. The victim, along with her young daughter, was wrongly detained in Presidency Jail in Kolkata after the alleged rape. The matter was taken up by the commission, which resulted in the release of the rape victim and safe custody with her brother. Besides these achievements, the commission has proposed amendments to a number of acts such as the Hindu Marriage Act, 1955, Medical Termination of Pregnancy Act, 1971, and the Indian Penal Code, 1960. The Commission has also proposed bills such as the Marriage Bill of 1994, the Domestic Violence to Women Prevention Bill of 1994, and the Prevention of Barbarous and Beastly Cruelty Against Women Bill, 1995, amongst others. Some of these bills, such as the Domestic Violence to Women Prevention Bill, have recently been passed. The Commission has also intervened in a number of court cases which have been mentioned in a chapter dealing with functions of the Commission. Despite these achievements, it may be noted that NCW does not possess any concrete legislative powers. It does not select its own members, they are appointed by the Union government. For its financial functioning, NCW depends on grants from the Union government. There is a need to make NCW more effective than what it is now. VIL. National Human Rights Commission. The National Human Rights Commission, NHRC, of India is an autonomous body established on October 12, 1993 under the provision of the Protection of Human Rights Act, 1993. The Commission is in conformity with the Paris Principles, October 1991. The NHRC consists of a chairperson and 4 members. Chairperson of the National Commission for Minorities and National Commission for Women are its ex officio members. The chairperson and members of the NHRC are appointed by the President on the recommendations of a committee consisting of the Prime Minister, the Speaker of the House of the People, the Home Minister, the Leader of the Opposition in the Council of States, and the Deputy Chairman of the Council of States. The functions of NHRC are 1. Proactively or reactively inquire into violations of human rights or negligence in the prevention of such violation by a public servant. 2. Intervene in any proceeding involving allegation of violation of human rights pending before a court. 3. Visit any jail or other institution under the control of a state government, where persons are detained or lodged for purposes of treatment, reformation, or protection, for the study of the living conditions of the inmates and make recommendations. 4. Review safeguards provided by or under the Constitution or any law for the time being in force for the protection of human rights and recommend measures for their effective implementation. 5. Review factors, including acts of terrorism, that inhibit the enjoyment of human rights and recommend appropriate remedial measures. 6. Study treaties and other international instruments on human rights and make recommendations for their effective implementation. 7. Undertake and promote research in the field of human rights. 8. Spread literacy among various sections of the society and promote awareness of safeguards available for the protection of these rights through publications, the media, seminars, and other available means. 9. Encourage efforts of NGOs, and institutions working in the field of human rights. The NHRC is not only an investigation body, it is also a body that holds inquiry into complaints. For this purpose, the Commission broadly divides cases in these categories. I. Custodial deaths. 2. Police excesses, torture, illegal detention/unlawful arrest, false implication, etc. 3. Fake encounters. 4. Cases related to women and children. V. Atrocities on Dalits/members of the minority community/disabled. 6. Bonded labor. 7. Armed forces/paramilitary forces. And 8. Other important cases. Since its establishment in October 1993, the Commission has directed compensation of Rs.9, 76, 68, 634 in 559 cases. In the year 2002 to 2003, the Commission recommended compensation amounting to Rs.31, 40, 000 in 39 cases. The Commission during the period beginning from April 1, 2002 to March 31, 2003 registered 68,779 cases. Out of 68,779 cases registered in the year 2002 to 2003, 67,354 complaints were of human rights violations, 1,340 related to custodial deaths, 2 concerned custodial rapes, and 83 related to police encounters. As on March 31, 2003, the total number of cases before the Commission was 43,010, which included 9,763 cases awaiting preliminary consideration and 33,247 cases in respect of which reports were either awaited from the authorities concerned or the reports had been received and are pending further consideration within the Commission. It is worthwhile to illustrate National Human Rights Commission versus State of Arunachal Pradesh case, 1996, in which the Supreme Court directed the government of Arunachal Pradesh to ensure the life and personal liberty of each and every Chakma residing within the state. The significance of this judgment also lies in clearing the doubts regarding the applicability of fundamental rights to refugees. This decision rules that foreigners are entitled to enjoy the protection of the right to life and liberty under Article 21 of the Indian Constitution. There is yet another illustration. 2 writ petitions, Paramjit Kaur versus State of Punjab and Committee for Information on Punjab versus State of Punjab, were filed in the Supreme Court in 1995 containing serious charges. The Apex Court observed that 585 dead bodies were fully identified, 274 partially identified, and 1,238 unidentified, and that there was flagrant violation of human rights on a large scale. On December 12, 1996, the Supreme Court requested the HR Commission to have the matter examined in accordance with law and determine all issues related with the case. During the year of its inception, 199394, the NHRC received 496 complexity, which figures reach now 74,444 in 2005 to 2006. According to the Commission, Delhi, Uttar Pradesh, and Haryana topped the human rights violation in 2011. Delhi's figures were 5,228 in 2009 to 10, which jumped in 5,929 in 2010, 7,865 in 2011 to 12. 9. National Commission for Minorities. The Government of India has set up a commission to protect the rights of the minorities. It consists of a chairperson, a vice-chairperson, and 4 members, all appointed by the President. Functions of the National Commission of Minorities, NCM, are a. To evaluate the progress of the development of the minorities under the Union and in states. B. To monitor the working of safeguards provided in the Constitution and in the laws enacted by Parliament and state legislatures. C. To make recommendations for the effective implementation of safeguards for the protection of the interests of the minorities by the central government or state governments. D. To look into specific complaints regarding the deprivation of rights and safeguards of the minorities, and take up such matters with the appropriate authorities. E. To cause studies to be undertaken into problems arising out of discrimination against the minorities, and recommend measures for their removal. F. To conduct studies, research, and analysis on issues relating to socioeconomic and educational development of the minorities. G. To suggest appropriate measures in respect of any section of the minorities to be undertaken by the central government or state governments. H. To make periodical or special reports to the central government on any matter pertaining to the minorities and in particular difficulties confronted by them. I. Any other matter which may be referred to it by the central government. Powers of the NCM acting as a civil court are as summoning and enforcing the attendance of any person from any part of India and examining him on oath. B. Requiring production of any document. C. Receiving evidence on affidavit. D. Requisitioning any public record or copy thereof from any court or office. E. Issuing commissions for the examination of witnesses and documents. F. Any other matter which may be prescribed. Reports of NCM are to be placed in the Parliament and in state legislature, if necessary. The constitution of the NCM as a statutory body augurs well for the protection of the minorities in the country. But its functions do not allow it to be an effective champion of the minorities' rights insofar as it has to go along with the government of the day. A favorable government helps encourage the NCM while a hostile one makes the NCM dormant. X. National Commission for Backward Classes. The Supreme Court, in its judgment dated November 16, 1992, in a writ petition civil, number 930 of 1990, Indira Soni and Ors versus Union of India and Ors, directed the Government of India, state governments and UT administrations to constitute a permanent body in the nature of a commission or tribunal for entertaining, examining and recommending upon requests for inclusion and complaints of over-inclusion and under-inclusion in the list of OBCs. In pursuance of the direction of the Supreme Court, the Government of India enacted the National Commission for Backward Classes Act, 1993, Act No. 27 of 1993, and set up a National Commission for Backward Classes at the Center to investigate conditions of backward classes. Article 340 of the Constitution provides, 1. The President may by order appoint a commission consisting of such persons as he thinks fit to investigate conditions of the socially and educationally backward classes within the territory of India and difficulties under which they labor, to make recommendations as to steps to be taken by the Union or a state to remove such difficulties to improve their conditions, and as to grants that should be made for the purpose by the Union or state and the conditions subject to which such grants should be made, and the order appointing such commission shall define the procedure to be followed by the commission. 2. A commission so appointed shall investigate matters referred to it and present to the President a report setting out the facts as found by it and make such recommendations as it thinks proper. 3. The President shall cause a copy of the report presented together with a memorandum explaining the action taken thereon to be laid before each House of Parliament. At present, there is a chairman of the National Commission for Backward Classes, NCBC, 1 member secretary and 3 other members, 2009. Under Section 9(1) of the National Commission for Backward Classes Act, 1993, the Commission shall examine requests for inclusion of any class of citizens as a backward class in the central list of backward classes and hear complaints of over-inclusion or under-inclusion of any backward class in the list and tender such advice to the central government as it deems appropriate. Under Section 9(2) of the Act, the advice of the Commission shall ordinarily be binding upon the central government. Under Section 11(1) of the Act, the central government may at any time and shall, at the expiration of 10 years from the Act coming into force and every succeeding period of 10 years thereafter, undertake revision of the list with a view to excluding from such list those classes who have ceased to be backward classes or for including in such list new backward classes. Under Section 11(2) of the Act, the central government shall, while undertaking any revision referred to in subsection 1, consult the Commission. The primary function of NCBC is twofold. A. To consider request for the inclusion of any class of citizens as a backward class in the central list. This function makes the NCBC as a commission to work on a permanent basis. B. To act as a complaint authority. This function makes the Commission an important statutory body to go into the details of every incoming request, determine the claims of a class of people to be included or excluded in the list of backward classes. Though the recommendations of the NCBC are binding on the government, yet the latter remains the ultimate authority to accept or reject the recommendations of the Commission. XL. Other commissions. A. Niti Aayog. Niti Aayog, National Institution for Transforming India. Aayog Niti is a policy Aayog established as its predecessor, Planning Commission, by a cabinet resolution on January 1, 2015. It comprises I. Prime Minister of India as the chairperson, 2. Governing Council comprising the chief ministers of all the states and the union territories with legislatures and lieutenant governors of the other union territories, 3. Regional councils will be formed to address specific issues impacting more than one state or region. 4. Experts, specialists, and practitioners with relevant domain knowledge as special invitees nominated by the Prime Minister. V. Full-time organizational framework comprising A. Vice Chairperson Arvind Panagarya. B. 3 full-time members Bibek Debrode, V.K. Saraswat, Ramesh Chander, economist, former DRDO chief and agricultural expert respectively. C. Part-time members 1 university professor another relevant institution head. D. Ex officio members 4 members of the Union Cabinet. E. Chief Executive Officer to be nominated by the Prime Minister for a fixed tenure. And F. Secretariat. Aims and objectives of NITI Aayog. NITI Aayog seeks to provide a critical directional and strategic input into the development process. The center-to-state one-way flow of policy that was the hallmark of the Planning Commission era is now sought to be replaced by a genuine and continuing partnership of states. The NITI Aayog will emerge as a think tank that will provide governments at the central and state levels with relevant strategic and technical advice across the spectrum of key elements of policy. The NITI Aayog also seeks to put an end to slow and tardy implementation of policy by fostering better inter-ministry coordination and better center-state coordination. It helps evolve a shared vision of national development priorities and foster cooperative federalism, recognizing that strong states make a strong nation. The NITI Aayog develops mechanisms to formulate credible plans to the village level and aggregate these progressively at higher levels of government. It ensures special attention to the sections of society that may be at risk of not benefiting adequately from economic progress. The NITI Aayog creates a knowledge, innovation, and entrepreneurial support system through a collaborative community of national and international experts, practitioners, and partners. It offers a platform for resolution of intersectoral and interdepartmental issues in order to accelerate the implementation of the development agenda. The NITI Aayog monitors and evaluates the implementation of programs and focuses on technology upgradation and capacity building. Through the above, the NITI Aayog will aim to accomplish the following objectives and opportunities. An administrative paradigm in which the government is an enabler rather than a provider of first and last resort. Progress from food security to focus on a mix of agricultural production as well as actual returns that farmers get from their produce. Ensure that India is an active player in the debates and deliberations on the global commons. Ensure that the economically vibrant middle class remains engaged and its potential is fully realized. Leverage India's pool of entrepreneurial, scientific, and intellectual human capital. Incorporate the significant geoeconomic and geopolitical strength of the non-resident Indian community. Use urbanization as an opportunity to create a wholesome and secure habitat through the use of modern technology. Use technology to reduce opacity and potential for misadventures in governance. The NITI Aayog aims to enable India to better face complex challenges through the following. Leveraging of India's demographic dividend and realization of the potential of youth, men and women, through education, skill development, elimination of gender bias, and employment. Elimination of poverty. And the change for every Indian to live a life of dignity and self-respect. Redressal of inequalities based on gender bias, caste and economic disparities. Integrate villages institutionally into the development process. Policy support to more than 50 million small businesses, which are a major source of employment creation. Safeguarding of our environmental and ecological assets. NITI Aayog is an advisory body, a think tank, a sort of policy, and not a planning commission. To some extent, it is to replace the Nehruvian Soviet centralized planning body by Americanized neoliberal body to give India a developmental look. Obviously, it is different than the Planning Commission. Unlike the planning body, the NITI Aayog is an advisory body. It does not allocate funds. This job has been given to the Finance Ministry. The Planning Commission had the power to allocate funds to ministries and state government. The NITI Aayog has 2 full-time members, while the Planning Commission had 8 full-time members. NITI Aayog includes chief ministers of states and union territories, whereas the Planning Commission had chief ministers in the National Development Council, NDC, which is now extinct. The NITI Aayog has part-time members, whereas Planning Commission had no part-time members. The NITI Aayog's organization differs from the organization of Planning Commission. The states will be consulted in formulating policy matters, while the National Development Council, a body consisting of all the chief ministers now defunct, was to be consulted in Planning Commission. The Planning Commission was a Soviet-sponsored centralized body making plans and projects for the whole country, whereas NITI Aayog is neoliberalized, more open body, and a bottom-up institution which takes into account as open policy-making process as possible. NITI Aayog, hopefully, seeks to put an end to slow implementation of policy by fostering interministerial and center-state coordination. The Central Vigilance Commission, CVC. Central Vigilance Commission is an apex vigilance institution free of control from any executive authority, monitoring all vigilance activities under the Government of India, and advising various authorities in central government organizations in planning, executing, reviewing, and reforming their vigilance work. It was set up by the government in February 1964 on the recommendations of the Committee on Prevention of Corruption Santhanam Committee to advise and guide central government agencies in the field of vigilance. Consequent upon promulgation of an ordinance by the President, the Central Vigilance Commission has been made a multi-member commission with statutory status with effect from August 25, 1988. The commission consists of a Chief Vigilance Commissioner and 2 Vigilance Commissioners. Central Information Commission, CIC. Under provisions of the Right to Information Act, 2005, the central government has constituted a body known as the Central Information Commission. The commission includes a Chief Information Commissioner, CIC, and not more than 10 Information Commissioners, ICs, who are appointed by the President of India. The Central Information Commission has a duty to receive complaints from any person who does not receive a decision within the time specified by the Act. The Central Information Commission has a duty to receive complaints from any person who does not receive a decision within the time specified by the Act, or is aggrieved by a decision of the Central Public Information Officer or State Public Information Officer, and to conduct necessary inquiry and provide with remedy. For this purpose, the Commission has the powers of a civil court. D. Atomic Energy Commission, AEC. The Indian Atomic Energy Commission was first set up in August 1948 in the then Department of Scientific Research, which was created a few months before in June 1948. Later, a Department of Atomic Energy (DAE) was set up on August 3, 1954 under the direct charge of the Prime Minister through a presidential order. Subsequently, in accordance with a government resolution dated March 1, 1958, the Atomic Energy Commission (AEC) was established in the Department of Atomic Energy. The Secretary to the Government of India in the Department of Atomic Energy is ex officio chairman of the AEC. Other members of the AEC are appointed for each calendar year on the recommendation of the chairman after approval by the Prime Minister. E. National Commission for Religious and Linguistic Minorities, NCRLM. NCRLM was established on March 21, 2005 to address the Government of India's concern about the welfare needs of socially and economically backward sections among religious and linguistic minorities. The Commission has a threefold mandate: A. To suggest criteria for identification of the socially and economically backward sections among the religious and linguistic minorities. B. To recommend measures for the welfare of such identified backward sections, including reservation in education and government employment. And C. To suggest necessary constitutional, legal, and administrative modalities required to implement the recommendations. F. National Commission for Economically Backward Classes. The Center constituted a Commission for Economically Backward Classes in July 2006. The Commission elicits the views of state governments and union territories, suggests criteria for identification of the economically backward classes, and recommends welfare measures and quantum of reservation in education and government employment. Recommendations of the Commission are applicable to those not covered under the existing reservation policy. G. National Knowledge Commission. The National Knowledge Commission is a high-level advisory body to the Prime Minister with the objective of transforming India into a knowledge-based society. It covers sectors ranging from education to e-governance, focusing on knowledge paradigm. Terms of references of the National Knowledge Commission, NKC, are to build excellence in the educational system to meet the knowledge challenges for the 21st century and increase India's competitive advantage in the field of knowledge. Promote creation of knowledge in scientific and technology laboratories, improve the management of institutions engaged in intellectual property rights, promote knowledge applications in agriculture and industry, promote the use of knowledge capabilities in making government an effective, transparent, and accountable service provider to citizens, and promote widespread sharing of knowledge to maximize public benefit. Practice questions. 1. Examine the structure and functions of the National Commission for the Scheduled Castes. 700 to 800 words. 2. Explain the structure, functions, and rationale for the National Commission for the Scheduled Tribes. 700 to 800 words. 3. Why was the National Commission for Backward Classes been set up? Give reasons. 200 to 250 words. 4. Why has the National Commission for Women been established? What are its functions? State some of its achievements. 700 to 800 words. 5. Explain the functions of the Election Commission. 200 to 250 words. 6. State the composition and functions of the Union Public Service Commission. What is its role? 700 to 800 words. 8. The National Commission for Minorities is a commission with a major role. Elucidate. 200 to 250 words. 9. Write a detailed note on the Finance Commission of India. 700 to 800 words. 10. Examine the role of the Comptroller and Auditor General of India in promoting good governance. 2014, 200 to 250 words. 12. Examine the scope and limitations of women's movements in India. 2014, 200 to 250 words. 13. Write a detailed note on Niti Aayog. 700 to 800. 7. Discuss the organization and functioning of the National Human Rights Commission. 700 to 800 words. 11. Discuss the working of the National Commission for Scheduled Castes Curb Violence. 2014, 700 to 800 words. Federalism in India. Favor of a national government without sacrificing their autonomy. It is not the division of a larger national state into smaller units, giving each its constitutional existence. Integrative and disintegrative forces may lead to one form or another of federalism, as federalism today is essentially not conflictive in nature, i.e. the national government seeking to override the powers of constituent units or the federating units seeking more autonomy. Federal forms differ, such as the American form, which represents a model of strong federation like that of Switzerland, and the Canadian form, which represents a model of a weak federation like that of India. Yet there is a tendency among all forms of federations to strengthen the federal government as against the governments of federating units. A federation is an agreement among regional polities surrendering their sovereignty in. William S. Livingston, Federalism and Constitutional Change, defines federation as a form of political and constitutional organization that unites into a single polity a number of diversified groups as component polities so that personality and individuality of the component parts are largely preserved while creating a separate and distinct unit. Federation implies a dual polity, a division of powers between the two polities, each limited in its own sphere and independent of one another and yet coordinating with each other. Nature of the Indian federalism. In a country full of diversities as India has been, it is only the federal scheme which can suit its requirements. Our country, with numerous castes, uneven and underdeveloped regions, a variety of religions and the languages and dialectics, no other system would have been as suitable as is the federalization of India. The size of the country with its large population, again, could necessitate a federal machinery in our system. India's history has not witnessed a one-block entity until the British came to build it administratively as one polity, but even they also, again for purposes of administration, classified it into numerous provinces, though headed by a central government once controlled from Calcutta, now Kolkata, and later from Delhi. The division of powers under the Government of India Act 1919 first and later under the Government of India Act 1935 was a clear indication of an intentional federal idea for India. The Act of 1935 had also proposed an all-India federation, though this part of the act could not be made practical because of a lack of cooperation from princely states to join it. The Nehru Committee of 1928 had also suggested the federal idea for India. The Cabinet Mission Plan of 1946 did mention Union of India as the country's federal system. Of December 1946 sought to propose a federal system with autonomous units having residuary powers. But the fast-changing conditions of 1946 to 47 leading to the partition of the country followed by large-scale migration with violent catastrophic changes deliberately transformed the mood of the members of the Constituent Assembly. The idea of having autonomous units was changed into the idea of a strong union government. The word Union of India was preferred to the word Federalism of India. In the Constituent Assembly, the draft committee decided in favor of describing India as a union. Moving the draft constitution for the consideration of the Constituent Assembly on November 4, 1948, Ambedkar explained the significance of the use of the expression union instead of the expression federation. He said, "What is important is that the use of the word union is deliberate. Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole, its people a single people living under a single imperium derived from a single source." Explaining the use of the word union, Ambedkar indicated two things. That India is not a federation in the sense that it is not the result of some erstwhile sovereign states agreeing to have their sovereignties and coming together to form a new sovereign state. 2. That in India, the states do not have the right to secede from the federation. The word union suggests a relatively more powerful center. Our system differs from the American or Swiss federation insofar as it does not give the federating units equal representation in the second chamber of the national legislature, nor does it put them at par in the amendment process. In fact, our system is more akin to the Canadian model, where also the word union has been used for federation. Finally, the Constitution was adopted on November 26, 1949. It provided for India being a union of states and its states and territories being as specified in the first schedule. The schedule specified 4 types of units: Part A, B, and C states and Part D territories. Later, on the recommendations of the State Reorganization Commission, 1956, and with subsequent amendments, India now stands, according to Article 1 of the Constitution, as a union of states. 29 states and 7 union territories. In all these structural changes, the unity and integrity without sacrificing the diversities of the country was never compromised. The State Reorganization Commission, SRC, had pointed out way back in 1956. It is the Union of India which is the basis of our nationality. States are but limbs of the Union, and while we recognize that the limbs must be healthy and strong, it is the strength and stability of the Union and its capacity to develop and evolve that should be governing consideration of all changes in the country. The SRC, in fact, saw no dichotomy between a strong Union and strong states. The relationship the SRC felt between the Union and the states is a relationship between the whole body and its parts. For the body being healthy, it is necessary that its parts are strong. It is felt that the real source of many of our problems is the tendency of centralization of powers and misuse of authority. India's federal scheme is not as federal as is that of either the United States of America or of Switzerland or of even Australia. It is more close to that of Canada. That India is not a federation but a union of states means that our system is more centralizing, the national government is more powerful than the governments of the states in numerous respects, and that the framers of the Constitution themselves favored a system which would be integrative. Where modern constitutions describes the Indian system quasi-federal, a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary features. Santhanam Union States relations in India refers to two major factors which are, 1. That the union has more financial powers, 2. That the union controls the state's development projects. However, there are scholars who highlight the federal aspects of the Indian Constitution. Paul Appleby, Public Administration, characterizes Indian system as extremely federal, and Jennings, Some Characteristics of the Indian Constitution, observes. Indian Constitution is mainly federal with unique safeguards for enforcing national unity and growth. Alexandrowick's Constitutional Developments in India says that India's federal case is unique in character, while Granville Austin, The Indian Constitution Cornerstone of a Nation, describes India as a cooperative federation. Federal features of India's Union of States. That India is a federal state in form is a fact hard to deny. It is not a unitary state with federal features but is a federal state with unitary features. The idea is that India is structurally a federal system in which we find certain federal elements. In any federation, a written constitution is a necessity. There can be no federation without a written constitution. A written constitution specifies, in black and white, the domain of both the federal government and also of the states' governments. Some federal countries have separate constitutions for each federating unit. In India, we have only one constitution, the Constitution of India, which contains the features common for the states as well. The original Indian constitution had 395 articles. The constitution in every federal state has a rigid method of amendment. This is so because no amendment can be made without seeking the approval of the federating units. In India, the approval of the amendment of every article is not sought from the states, yet under Article 368, the approval of the states is sought for amending articles specified in Article 368. Half of the states which constitute the Union have to ratify such amendment after they have been passed by the Parliament. In all federations, it is the Constitution which is supreme. Both the federal government and the governments of states have to work within the framework of the Constitution. Any law contrary to the Constitution is declared as void, whether it is passed by the Union government or a state government. The power to declare a law as void rests with the judiciary. In India, the Supreme Court and High Courts with such a power of declaring law as void, i.e., the judicial review power, are rightly regarded as the custodian of the Constitution. In all federations, it is the Constitution which is supreme. Both the federal government and the governments of the states have to work within the framework of the Constitution. Any law contrary to the Constitution is declared void, whether it is passed by the Union government or the state government. The power to declare a law as void rests with the judiciary. In India, the Supreme Court and the High Courts with such a power of declaring law as void, i.e., the judicial review power, are rightly regarded as the custodian of the Constitution. In all federations, there is a division of power on the basis of which every government, federal as well as federating, makes laws in its own domain. The division of power limits the powers and allows the governments to work independent of each other. In India, the Union list with 97 items authorizes the Union government to make laws. The state list with 66 items authorizes the state governments to make laws. The concurrent list with 47 items authorizes both the federal and federating governments to make laws. The residuary powers in India lay with the Union government to make laws on. Though the division of powers favors the Union government, yet there is a clear-cut division of power in India. All federal systems give to the judiciary relatively a powerful status by making it the custodian of the Constitution, rights of the people, the federal system. In India, the Supreme Court does enjoy such a position. In all federations, the second chamber represents the states and gives each state, federating unit, equal representation in the upper chamber of the national legislature. In India, the Rajya Sabha represents the states, but the representation is not equal. Larger the state in population, more is its representation in the Rajya Sabha, the Council of States. Asymmetrical federal features in India. Federal features in India are asymmetrical in the sense that the federating units are not equal in respect to each other. That they are not equal in respect of the Union government is a different thing. That they, in relation to each other, do not enjoy equal status is what makes the Indian federal scheme asymmetrical. India's federation is asymmetric. By asymmetric federation, it is meant a federalism based on unequal powers and relationships in political, administrative, and fiscal arrangements between the units constituting a federation. The units are not seen to exist on the basis of equality. Some of the arguments expressing such asymmetric tendencies are as follows. The federating units forming federations are usually equal and at least made equal socially, politically, financially. In India's case, the federating units, when formed with federation, were not equal after India gained independence. They were, then, classified as states, B states, C states, or D states. After the State Reorganization Report 1956, the 14 states were equal only because each had a different language. Even the language formula was set aside when the process from 14 states to 29 came into operation from time to time. The inclusion of the princely states, around 500 at the time of independence, into India was done by integrating them into India, integration through bargain, and bargaining through the promises of privy purses. B and C states were the product of privy purses except the exceptions. The Constitution of India, as enacted in 1950, gave to the state of Jammu and Kashmir an advantage over the other states constituting the federation. Article 370 provided the state of Jammu and Kashmir a unique position in Indian Union. It gave the state its own constitution and residuary powers to the state legislature. No other state of India had such privileges. The northeastern states such as Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura are, with the exception of Assam, too small units to be considered as equal to any other Indian state. Many of them were raised to the status of states more on political reasons than on other usual reasons, with various clauses of Article 371 giving each such state some special powers. In matters relating to the amendment of the Constitution, especially those articles affecting the powers of the Union and the states as specified in Article 368, the requirement is the ratification of the states and that 2/2 of the states agreeing to the proposed amendment. As the states forming the federation are both too large, Uttar Pradesh, Madhya Pradesh, West Bengal, and too small, mostly concentrated in northeastern India, form the federation. It is always easy for the union government to manage 50% of the small states and get the constitution amended the way the union government likes. The federating units are not equal in their representation in the Council of States. Uttar Pradesh is, for example, not equal to Nagaland, nor is Arunachal Pradesh equal to West Bengal. Where's the equality? The wide differences in the economic characteristics between the states in Indian Federation can be highlighted. It is seen that in terms of area, the biggest state, Rajasthan, is 90 times bigger than the smallest state, Goa. Similarly, in terms of population, Uttar Pradesh, the state with the largest population, is 308 times bigger than the smallest state, Sikkim. The density of population varies from 13 in Arunachal Pradesh to 901 in West Bengal. The state with the highest net state domestic product, NSDP, Maharashtra, is 284 times that of the state with the lowest, Sikkim. There are significant variations in per capita incomes as well. In 2000 to 2001, Goa, a small state in the western coast, had the per capita NSDP of 44,613 rupees, which is almost 9 times that of Bihar with 4,813 rupees. The federating units are widely different in population, in size, in resources, in sources of income, in per capita income, in domestic product, in the level of development. High income. Table 25.1. Some characteristics of states in Indian federalism. Low income. How can they be equal partners in federations? How could they be treated equally by the former Planning Commission projects or by Niti Aayog today? How can they be regarded equally in the allocation of benefits, given the compulsions of electoral politics? 4. Unitary tendencies in India's federation. Federations are usually described as indestructible union of indestructible states. But in the case of India, the union is indestructible, the states are not. The Constitution, under Article 3, vests the Parliament with the power to constitute new states, alter their territories, and change their names. Clearly, it is the union government which is more powerful than the states. There are, thus, the unitary tendencies, i.e. federalizing features, visible in our Constitution. This is evident from the following. Note, NA not available. All states, NSDP figures do not include SDP from Uttarankal. NSDP figures of UTs excludes SDP from Dadra and Nagar Haveli, Daman and Diu and Lakshadweep. The federating units in India do not have the constitutions of their own. The Constitution of India contains the provisions relating to the administration of the states. Article 3 of the Constitution empowers the Parliament to create new states, alter their boundaries, even their names. This indicates the unitary tendencies. The states in India do not initiate the amendment proposals. It is the power of the Parliament, the national legislature. The states have the power to ratify the amendment proposals. The required ratification is not less than half of the number of states. If the Union government can manage to take along with it some minor half of the states, it can get away with any amendment. The states participate only in the amendments of a few provisions of the Constitution, only those contained in Article 368 and not in all the provisions of the Constitution. The single judicial structure provides the Union government more importance. The Supreme Court is not only the highest court but is also the court which controls all the subordinate courts, including the high courts. There is no uniformity of representation of the states in the Council of States. The states are represented in the Council of States on the basis of their population, see Schedule 4. The Union government has more subjects to make laws on. It can legislate on the Union list, 97 subjects in the original Constitution, while the states legislate on the subjects in the state list, 66 subjects in the original Constitution. On the concurrent list, which had 47 subjects in the original Constitution, both the Union and the states can legislate. In case both the governments make a law on any subject of the concurrent list, the Union law prevails over the state law to the extent it goes contrary to the Union law. The Parliament is empowered to make laws on the state list subjects in certain circumstances, during emergencies, when states themselves request the Parliament to make such laws, when any international treaty is to be implemented, and when the Council of States declares any state list subject as of national importance. The governors in the states are appointed by the President and can be recalled or removed by the President and remain in office during the pleasure of the President. The governor is empowered to reserve any bill for the consideration of the President, who can withhold his/her asset to such bills, Article 201. The directives from the Union government flow to the states, Article 256, and not vice versa. The states have to ensure the compliance of such directives if they have to avoid action under Article 365. The Union government has more financial powers than those with the states. The states have to depend on the Union government for financial assistance. The 2015 Niti Aayog is controlled by Prime Minister's men. Single citizenship, that is, the Indian citizenship, and numerous other measures such as uniformity in administration, all India services, all those go to favor the Union government. And yet it cannot be said that we do not have a federal system. Dr. B.R. Ambedkar had made certain observations in this respect. He was of the opinion that India is a federal state insofar as I. The Constitution provides a dual polity. 2. The states have not been created by the national government. 3. The states derive their authority and power from the Constitution. 4. The Constitution has given the states a list of subjects over which it is empowered to make laws. The Constitution demands that there has to be a governor in the state, Article 153, and also a council of ministers headed by the chief minister, Article 163. The office of the governor and the constitution of the council of ministers headed by the chief minister are constitutional requirements, and the Union government cannot, if it may want or wish, abolish them. Accordingly, the state governments constitute a basic structure of the Indian political system. In S.R. Bommai v. Union of India, 1994, the Supreme Court had observed the fact that under the scheme of our Constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages of the center. The states have an independent constitutional existence. They are not satellites or agents of the center. Within the sphere allotted to them, the states are supreme. The fact that during an emergency and in certain other eventualities their powers are overridden or invaded by the center is not destructive of the essential federal features of the Constitution. They are exceptions, and the exceptions are not a rule. Let it be said that the federalism in the Indian Constitution is not a matter of administrative convenience, but one of the outcome of our own process and a recognition of the ground realities. The emergence of regional political parties on the one hand and their rise to power in some states on the other made them an important factor in the political system of the country. They have become coalition partners and have made the Union government see reason in the state's agenda. The Union States Relations in India. Chapter of Part 11 from Articles 245 to 255 of the Constitution describes the legislative relations between the Union and the states, while Chapter 2 of the same part, from Articles 256 to 263 of the Constitution describes the administrative relations between the Union and the states and also relate to the disputes regarding waters, whereas Chapter of Part 12, from Article 268 to 276 of the Constitution explains the distribution of revenues between the Union and the states. Legislative relations between the center and the states. The 7th schedule of the Constitution provides for 3 lists: Union list, 97 items in the original Constitution; State list, 66 items in the original Constitution; and concurrent list with 47 subjects. There have been some changes in the items of these lists owing to amendments. Till 2007, Union list had 99 items, State list 61, and concurrent list 52. The Union list has subjects such as defense, development of armed forces, foreign affairs, citizenship, railways, highways, airway, navy, currency, interstate trade and commerce, banking, central universities, UBSE, Election to the Parliament and state legislatures, taxes on income, etc. Item 33 has been deleted and items 2A, 92A, and 92B have been added. This makes total items from the original 97 to 99 in the Union list. The Union legislature has the exclusive power to make laws on subjects enumerated in the Union list. The state list has subjects such as public order, police, prisons, local government, public health and sanitation, agriculture, gas and gaswork, trade and commerce within the state, markets and fairs, betting and gambling. Election to the state legislature, income, land revenue, toll taxes, etc. Items 11, 19, 20, 29, and 36 have been deleted, and this reduces the state list to 61 from 66. The state legislatures have the power to make laws over the subjects enumerated in the state list, but the Parliament can make laws over these subjects in certain circumstances. The concurrent list has subjects such as criminal law and procedure, matters relating to marriages and divorces, bankruptcy and insolvency, prevention of cruelty to animals, forests, trade unions, social security, social insurance, weight and measures, price control, electricity, etc. Items 11A, 17A, 17B, 20A, and 33A have been added through 42nd Amendment, 1976, to make it 52 instead of 47. Both the Parliament and the state legislatures have the power to make laws on the subjects enumerated in the concurrent list. Both the Parliament and the state legislatures have the power to make laws on the subjects enumerated in the concurrent list. In case of inconsistency between the laws made by the Parliament and the state legislatures, including laws made on the subjects enumerated in the concurrent list, the Union law prevails over the state law, and the state law would be void to the extent it is repugnant to the Union law. Article 254. The residuary powers following the scheme as in the Canadian Constitution, and unlike that in the USA and Australia, have been placed under the jurisdiction of the Parliament, e.g., power to levy residuary taxes. Article 248. Under the Government of India Act, 1935, the residuary powers were placed in the hands of the Governor-General. The jurisdiction of the laws of the Parliament extends to the whole country, whereas that of the laws of the state legislature extends to the respective states. However, in view of certain specified scheduled areas, the laws of the Parliament may be barred in those areas only by notification of the governors of those states, see Schedule 5th and 6th of the Constitution. In certain circumstances, the Parliament can make laws on the subject enumerated in the state list. Under Article 249, when the resolution passed by the Council of States, 2/3 majority of the members present and voting authorizes the Parliament to make a law on a particular item of the state list in the national interest. Such laws have 1-year validity and cease to operate on the expiry of 6 months after the period for which the resolution was passed. 2. Under Article 250, when the state of emergency is in operation, the Parliament can make laws on the state subjects, which laws become inoperative after 6 months of the expiry of the emergency. Under Article 252, when the legislatures of 2 or more states make a request that the Parliament may make laws on certain state subjects, examples, Wildlife Protection Act, 1972, Water Prevention and Control of Pollution Act, 1974, Urban Sealing and Regulation Act, 1976, Transplantation of Human Organs Act, 1994. Under Article 253, when the implementation of any international treaty, agreement, or convention may require so, then the Parliament can legislate on any state subject, example, United Nations Privileges and Immunities Act, 1947, Geneva Convention Act, 1960, Anti-Hijacking Act, 1982, and legislation with respect to environment. Under Article 356, when there is the President's rule in any state, the Parliament legislates for that state on state subjects. Besides, the Union government has a control over states' legislature in numerous ways. A. The governor can reserve any state bill for the consideration and reconsideration of the President, Articles 200 and 201. B. Bills on certain matters, i.e., restriction on the freedom of trade and commerce, can be introduced in the state legislature only after the prior permission of the President. C. The President may direct the states to reserve money bills for his/her consideration during the period of financial emergency, Article 360. 2. Administrative relations between the center and the states. There is a separate administrative jurisdiction of both the Union and the states' governments that extends to their respective legislative jurisdiction. Yet, there are provisions when the Union government may exercise control over the states. 6. 7. 8. Under Article 256, the executive power of the state has to be exercised to ensure compliance with the laws made by the Parliament, and the Union government is empowered to give necessary direction to the states. Under Article 257, the states are directed not to pursue their executive powers in such a way that the exercise of those powers is against the Union government noncompliance of 3 and 2 may lead to the application of Article 365, under which the President may take over the administration of the states. Under Article 258, the President may entrust the state's officials with functions relating to the Union government. Under Article 155, the appointment of a state governor is done by the President and the governor remains in office during the pleasure of the President, notwithstanding the 5-year term. During emergency under Article 356, the governor rules the state as the agent of the President, i.e., the Union government. Under Article 312, the Parliament can create an All India Service, Indian Forest Service in 1966, in addition to IS and IPS. Following the resolution by the Council of States passed by the 2/3 majority of the numbers present and voting, under Article 315, the Union Public Service Commission (UPSC) may serve the needs of a state on its request. The State Public Service Commission works in states, though their members are appointed by the governor, they are removed by the President. Under Article 317, under Articles 352, 356, and 360, the legislative, administrative, and financial powers of the Union government get increased to the disadvantages to the states. The institution of Planning Commission and the role of national political parties help the Union government rather than the states. Article 355 assigns 2 duties to the Union government: I, to protect the states from any external attack and internal disturbances, and 2, to see that the government of the state is carried on in accordance with the provisions of the Constitution. Article 262 provides for the adjudication of any dispute or complaint with respect to distribution and control of waters of any interstate river or river valley, for which the provision has to be made by the Parliament. Article 263 says that the President can establish an interstate council to investigate and discuss subjects of common interest between the center and the states. Example, such a council was set up in 1990. The Parliament has established zonal councils to promote interstate cooperation and coordination for 5 zones: Northern, Central, Western, Eastern, and Southern. 3. Financial relations between the center and the states. The Parliament has the power to levy taxes on subjects enumerated in the Union list on items such as 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92A, 92B, and 96. The state legislatures have the power to levy taxes on subjects enumerated in the state list on items such as 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, and 65. Both the Union and the states can levy taxes on subjects 33, 44, and 47 of the concurrent list. The residuary power of taxation, such as gift tax, wealth tax, and expenditure tax, is vested in the Parliament. The 80th Amendment Act, 2000, also known as Alternative Scheme of Devolution, made major changes in the scheme of distribution of tax revenue between the center and the state. Based on the recommendations of the 10th Finance Commission, which now deletes Article 272, the amendment provides that the states should receive 29% of the total income obtained from certain central taxes and duties. In this background, the constitutional provisions with regard to the distribution of tax revenue between the center and the states are as under. I. Taxes levied by the center but collected and appropriated by the states. This category includes the following taxes: I. Stamp duties on bills of exchanges, checks, promissory notes, and others. 2. Excise duties on medicinal and toilet preparations containing alcohol. The proceeds of these duties levied within any state do not form a part of the Consolidated Fund of India but are appropriated by the states. Article 268. 2. Taxes levied and collected by the center but assigned to the states. The following taxes fall under this category: I. Taxes on the sale or purchase of goods in the course of interstate trade or commerce other than newspapers. 2. Taxes on the consignment of goods in the course of interstate trade or commerce. The net proceeds of these taxes are assigned to states in accordance with the principles laid down by the Parliament. Article 269. Taxes levied and collected by the center but distributed between the center and the states. This category includes all taxes and duties referred to in the Union list except the following: I. Duties and taxes mentioned above in the first and second categories. 2. Surcharges on taxes and duties mentioned below. 3. Any cess levied for specific purposes. The manner of distribution of the net proceeds of these taxes and duties is prescribed by the President on the recommendations of the Finance Commission. Article 270. Taxes for the purpose of the center. The Parliament can at any time levy the surcharges on duties or taxes mentioned above in the second and third categories. The proceeds of such surcharges go to the center exclusively. In other words, the states have no share in these surcharges. Article 271. Grants and aids to the states. Between the center and the states, the Constitution provides for grants and aid to the states from the central resources. A. Statutory grants under Article 275 to states on the representations of the Finance Commission. B. Discretionary grants to the states in the name of development, usually as proposed by the Planning Commission. C. Grants of expert duty like on jute and jute products, Article 273. 6. Center-State Relations Commission. The center-states relations have been under consideration since the 1960s. Both the center and the states have undertaken attempts to address issues relating to their relations. Reforms Commission, 1966. Its important recommendations were the establishment of an interstate council under Article 263 of the Constitution, the appointment of persons having long experience in public life and administration and nonpartisan attitude as governors, the delegation of powers to the maximum extent to the states, the transferring of more financial resources to the states to reduce their dependency upon the center, the deployment of central armed forces in the states either on their request or otherwise. No action was taken by the Union government. 2. Rajamana Committee, 1969. The Tamil Nadu government appointed a committee headed by Dr. P.V. Rajamana. Its major recommendations, though ignored by the Union government, were an interstate council should be set up immediately. 2. Finance Commission should be made a permanent body. Planning Commission should be disbanded and its place should be taken by a statutory body. 4. Articles 356, 357, and 365 dealing with President's rule should be totally omitted. The provision that the state ministry holds office during the pleasure of the governor should be omitted. 6. Certain subjects of the Union list and the concurrent list should be transferred to the state list. 7. The residuary powers should be allocated to the states, and 8. All India services IS, IPS, and IFS should be abolished. 3. Anandpur Sahib Resolution, 1973. The Akali Dal's resolution in Punjab demanded that the center's jurisdiction should be restricted only to defense, foreign affairs, communications and currency, and the entire residuary powers should be vested in the states. It stated that the Constitution should be made federal in the real sense and should ensure equal authority and representation to all the states. 4. West Bengal's Memorandum, 1977. Its suggestions were the word union in the Constitution should be replaced by the word federal. 2. The jurisdiction of the center should be confined to defense, foreign affairs, currency, communications, and economic coordination. 3. All other subjects, including the residuary powers, should be vested in the states. Options. Services should be created. 4. The residuary powers of taxation should continue to remain with the other residuary powers should be placed in the concurrent list. When the president withholds his assent to the state bills, the reasons communicated to the state government. 6. The National Development Council, NDC, should be renamed and National Economic and Development Council, NEDC. 7. The zonal councils should be constituted afresh and reactivated to federalism. 8. The center should have powers to deploy its armed forces, even states. However, it is desirable that the states should be consulted. 9. The center should consult the states making a law on a subject of the The procedure of consulting the chief minister in the appointment should be prescribed in the Constitution itself. 11. Steps should be taken to uniformly implement the three language. A commission on center-states relations is headed by Justice Mudun. Recommendations are 1. Articles 355 and 356 be so amended that specific troubled or controlled under the President's rule for a limited period. 2. The Commission supports the right of the Union to give sanction. D. The post-electoral alliance with some parties joining the government and remaining including independents supporting from outside. 5. The panel also feels that governors should have the right to sanction prosecution of a minister against the advice of the Council of Ministers. However, it wants the convention of making them chancellors of universities done away with. 6. As for qualifications for a governor, the Punchy Commission suggests that the nominee not have participated in active politics at even local level for at least a couple of years before his appointment. It also agrees with the Sarkaria recommendation that a governor be an eminent person and does not belong to the state where he is to be posted. 7. The Commission also criticizes arbitrary dismissal of governors, saying the practice of treating governors as political football must stop. There should be critical changes in the role of the governor, including fixed 5-year tenure as well as their removal only through impeachment by the State Assembly. It has also recommended that the state chief minister have a say in the appointment of governor. 8. Underlining that removal of a governor be for a reason related to his discharge of functions, it has proposed provisions for impeachment by the state legislature along the same lines as that of president by parliament. This significantly goes against the doctrine of pleasure upheld by the recent Supreme Court judgment. 9. The Commission says appointment of governor should be entrusted to a committee comprising the Prime Minister, Home Minister, Speaker of the Lok Sabha, and Chief Minister of the concerned state. The Vice President can also be involved in the process. 10. Unlike the Sarkaria report, the Punchy report is categorical that a governor be given fixed 5-year tenure. The Punchy Commission report also recommends that a constitutional amendment be brought about to limit the scope of discretionary powers of the governor under Article 163(2). Governors should not sit on decisions and must decide matter within a 4-month period. 11. The creation of an overriding structure to maintain internal security along the lines of the U.S. Homeland Security Department, giving more teeth to the National Integration Council. 12. For the National Integration Council, NIC, the Commission has proposed that it should meet at least once a year. In case of any communal incident, it has said that a delegation of 5 members of the council who would be eminent persons should visit the affected area and submit a fact-finding report. 13. The Commission, however, rejects a suggestion from some stakeholders as well as the Liberin Commission that the NIC be accorded constitutional status. 14. The Commission has also studied new setups like the National Investigation Agency and recommended procedures to ensure smooth cooperation of the states in terror investigations entrusted to NI. One can say that the extreme politicization of the post of governor must be decried and certain specific norms for the appointment and removal have to be evolved. 15. The recent ruling of the Supreme Court has indicated that the sanctity of this constitutional post should be preserved. In democracy, nobody can have absolute power in the name of smooth administration and good governance. The administrative apparatus has to be in line of the Constitution, which was prepared by the people of the country and amended by the elected representative of the people. The doctrine of pleasure has to be understood in this light. Tendencies. Integrative, regional, interstate disputes. The practice of federal idea is always a difficult exercise. The two opposing forces are always at work, one trying to bring about integration and the other, in its efforts to fulfill regional aspirations, work in the opposite direction, at times in conflict. The problem of state autonomy did not arise until 1967 when the Indian National Congress ruled at the center as well as in the states. The legislature was itself the Congress Party and the Congress Party was itself the government. The Congress system, as Rajni Kothari, cast in Indian politics, had rightly summed up. The problem became acute when there arose non-Congress parties to power in the states and sought more powers for the states, mostly from late 1960s down to late 1970s. The coalitional era beginning in the 1980s witnessed the rise of the regional political parties which rose to significance and came to play a definite and decisive role in the national politics, relegating the issue of state autonomy in the background. Whatever be the merits and demerits of coalitional system, it has made the regional political parties in India see the nationalistic perspective rather clearly and in the process has strengthened the integrative forces on the one hand and helped, on the other, fulfill the regional aspirations. The national regional parties have, now, become relatively more considerable and the regional political parties, rather relatively more assertive. The perception of the framers of the Constitution of India was not to make the centre so powerful that the federating units appear to be mere glorified municipalities, though they did avoid the tight mold of federation. The framers did not want and had not really wanted to compromise the integrity of the nation, but they did, at the same time, wish diversities not only to be protected but also promoted as well. The post-1950 period began until late 1960s, moving towards making the center more powerful to the point of assuming autocratic regime, leaving behind the concept of cooperative federating as Austin had visualized. The 1960s, 1970s, and 1980s saw the Indian federalism in crisis, the center trying during the times of Indira Gandhi to intimidate the states on the other, challenging both the center and the Indian model of federalism. As Kothari wrote, the political constitutional sphere has itself become prone to the same tendencies of centralization, domination, and inequity leading to institutional disorder. As Kothari wrote, the political constitutional sphere has itself become prone to the same tendencies of centralization, domination, and inequity, leading to institutional disorder. The post-1980 political situation is much different from what it was earlier. States are becoming more assertive if not dominating. The center is becoming more accommodative if not weakening itself. Integration is not at risk and the regional identity has earned acceptance. The interstate disputes refer to the original jurisdiction of the Supreme Court under Article 131. This article states clearly that the Supreme Court has the power to decide on disputes arising between I, the Government of India, and any one or more states. 2. The Government of India and one or more states on the one hand and one or more states on the other. 3. Disputes between the states. Not many such disputes have come up before the Supreme Court. The 1961 dispute between the state of West Bengal and Union of India, in which the Supreme Court declared the unconstitutionality of Coal-Bearing Areas Act, 1957. In the case of State of Bihar versus Union of India, 1970. The Apex Court urged the parties to bring for the consideration of the court issues of constitutional or legal nature. /N State of Karnataka and Union of India, 1978. The Supreme Court interpreted Article 131 rather liberally. Other cases such as State of Karnataka versus State of Andhra Pradesh, 2001, and State of Haryana versus State of Punjab, 2002, were cases more of administrative nature rather than constitutional or legal of any dispute. Practice questions. 1. Discuss the nature of Indian federalism. 200 to 250 words. 2. How do you make a case that India is structurally a federal state? 700 to 800 words. 3. What is asymmetrical federalism? On what grounds do you say that there are, in India, asymmetrical federal features? 700 to 800 words. 4. India is a federal state with unitary features. Describe the unitary features of India's federalism. 700 to 800 words. 5. Describe the legislative relations between the Union and the states. 700 to 800 words. 6. Explain the administrative relations between the Union and the states. 700 to 800 words. 7. Discuss the financial relations between the Union and the states. 700 to 800 words. 8. Write a brief note on the Sarkaria Commission report. 200 to 250 words. 9. What are the terms of reference of Punchy Commission? 200 to 250 words. 10. State the nature of India's federalism in the post-1980 era. 200 to 250 words. 11. Examine the efficacy of available mechanism for resolving interstate disputes in India. 2012. 700 to 800 words. 12. Examine the uniqueness of Indian federalism. 2013. 700 to 800 words. Planning and economic development. Development is a universal phenomenon. It is universal in the sense that it is a worldwide concept with different connotations and differently understood. The Brandt Commission rightly observed, development never will be and never can be defined to universal satisfaction. Some describe it as increase in national economy, while with others it is social development, whereas still others give it another name of modernization. Development. Meaning and implications. The concept of development has numerous definitions and, therefore, has somewhat different, though interrelated meaning. Estman says, development is the rational process of organizing and carrying out prudently conceived and staffed programs or projects, as one would organize and carry out military or engineering operations. To Colm and Gregor, development means change coupled with growth. Widener holds the view that when a process is directed towards nation-building and socio-economic progress, that process of growth is development. For Hanbin Lee, development is both a process and a purpose. He, therefore, says that development is a process of acquiring a sustained growth of a system's capability to cope with new, continuous changes towards the achievement of progressive politics, economic, and social objectives. T.N. Chaturvedi observes development as a process which stands for the transformation of society. Riggs gives, rather, a detailed definition. Development involves the ability to choose whether or not to increase outputs, whether or not to raise levels of per capita income, or to direct energies to other goals, to the more equitable distribution of what is available, to aesthetic or spiritual values, or the qualitatively different kinds of outputs. Middleman refers to development as the increasing capacity to make rational use of natural and human resources for social ends. Barron says that development means far-reaching transformation of society's economic, social, and political structure of the dominant organization of production, distribution, and consumption. It may, however, be pointed out that development is a multidimensional process involving changes in structures, attitudes, and institutions, as well as acceleration of economic growth, reduction of inequality, and eradication of poverty. It is a transformation from a traditional society to a modern society. The political dimension of development includes, among other things, rationalism, secularization, participation. The social dimension of development includes, for example, elimination of social evils, all distinction and all types of discrimination, equality of status, increase in social mobility. Its economic dimension means, for instance, provision for social security, absence of exploitation, sustained economic growth, attainment of plenty and prosperity. All these dimensions of development are so closely related to one another that it is difficult to separate them. The development of one dimension or one of its aspects is bound to influence and get influenced by the other dimension or its any other aspect. Development, in the context of underdeveloped or developing countries, means the transformation of society from its traditionality to modernity, from its crude ways of doing things to sophisticated ways. Its features and implications are: 1. Development is not a static concept. It is a dynamic and hence an ever-changing and ever-evolving concept. One cannot imagine anything in a developed form, for every developed form still needs some improvement. Development is, thus, a continuing process. 2. Development is not unidimensional, but is a multidimensional process. This means that development is not only economic development, it is also social development as also political or any other. Its goals are not confined to economy merely. They touch every aspect of human and societal life. They may, to mention a few, include economic growth, social progress and political development, nation building, and the like. 3. Development implies growth. What it means is that all societies keep growing, expanding, advancing, and, therefore, are in the process of change ever-changing. The present society of a country is different from such a society of another country. Today's society is not what it was yesterday in the past. Likewise, the future society would be substantially different from the society we find around us. For development is closely related to technology. In essence, a technologically advanced society is a developed society. Technology has changed and in fact is changing our life, each aspect of our life. Technology has made the world very small. 5. Rationality constitutes yet another component of development. What it means is that a developed society is not tradition-bound or religion-laden, but is one that stands up to reasoning and rationalism. 6. Development has yet other features or requisites as well. Order, stability, security, and the like prepare a ground for sustained growth. Countries have grown in years of peace rather than in years of wars. As development means change with growth, it implies substantial changes in infrastructure as well. You cannot run an import-export business without a developed banking system. How can you have a democracy with the institution of a dictator as the executive head? Development, Gandhian and Nehruvian perspectives. The Gandhian view of development was not, in any case, a model of material development. He was a great critic of Western capitalist system for its being exploitative and oppressive. By development, he did not mean accessibility to all material comforts but the one which leads to the development of individual and his personality, his virtues, his values, his self. All material development which the world had attained through private property did not attract Gandhi. He regarded possession as a crime. Gandhi was a simple man, a simple villager, a simple Indian. His view of development measured materialistically would be a self-sufficient village. He said, an ideal Indian village will be so constructed as to lend itself to perfect sanitation. It will have cottages with sufficient lights and ventilation built of a material obtainable within a radius of 5 miles of it. The village lanes and streets will be free of dust. It will have wells according to its needs and accessible to all. It will have houses and workshop for all. Also primary and secondary schools in which industrial education will be the central fact. It will produce its own grains, vegetables, and fruits and its own khadi. This is roughly my idea of a model village. These are Gandhi's priorities and preferences of an ideal village, self-sufficient, self-evolving, and self-developed, interdependence when it is necessary. The Gandhian approach to development would help create the following model. A predominant network of village and cottage industries along with a few key industries in the nearby towns, preferably under state or / and cooperative ownership. 2. The Gandhian model of development is not Western-based or urban-based. The Western type of industrialization can prove useful for some countries, especially in the West, but what is true about one nation cannot be true about another. In the Indian context, development has to be rural-based and has to follow the path of industrialization from the bottom to the top, i.e., from villages to the towns. 3. The Gandhian view of development never favors mass production and mass consumption. Gandhi advocates mass production in the homes, in the villages, and of those things which a common man requires. In other words, he advocates the means of production and distribution to be decentralized. 4. The Gandhian model of development was an integrated model, one that includes, among other things, agriculture, sanitation, education, social service, industries, all these locally based and locally regulated. That is why Gandhi never approved of large-scale industries, transportation, metropolises, and so on, and that is why he found pre-Western Indian way of life including traditional handicrafts, village exchange system, simplicity, religious cultural traditions acceptable under the given conditions of a backward economy as of India. Gandhi did find planning useful. He favored planning as a means for transforming the Indian backward economy into a developed one, but his planning process would begin from the bottom. The central planning institution would only lay guidelines and take upon itself the functioning of industries related to import and export items which include, for example, maintenance of large-scale infrastructure, combining the efforts of the development of village communities and those of the centralized modern sectors, planning of the development of urban areas in a limited way, re-establishing of the nationwide systems of cooperative trade. The Nehruvian model, as against the Gandhian one, laid emphasis on features like large-scale industrialization, central planning, the application of advanced technology and huge capital investments, drawing largely from the experience of the West and the Soviet Union. Nehru believed that large-scale industrialization and material progress would automatically eradicate the evils that plagued the Indian society. He thought that the modernization of the Indian economy was possible by building a strong industrial base. Thus, he supported the creation of a new institutional framework that could embody the spirit of progress or its synonym, development. The basic tenets of modernization were promoted through a rational, scientific planning under the banner of 5-year plans. The central planning designed the roadmap for the socio-economic development of the country. Nehruvian model was, unlike the Gandhian, Western and Soviet-based, a mixture of private-public framework, mixed economy, a part in the private sector, agriculture in particular, but with land reforms, conducive agrarian relations wherever possible, and another part in the public sector, major industries to be socialized so as to generate public employment, those which could serve the people, ensuring their interests, public utilities and services. Obviously, the Nehruvian model favored protectionism, import substitution, industrialization and state intervention in labor, large public sector, import-export regulation and central planning. If in the process of such a model, there was to be a system of elaborate licenses, rules and regulations, and the like, Nehru was not the man to show any hesitation. In fact, he did not. The Gandhian and the Nehruvian perspectives varied, the former largely localized whereas the latter largely westernized, one almost rural while the other urban, one based on village, small and cottage industries while the other based on large-scale industries, one by and large need-based whereas the other market-based, one taking the country a century backward in the past as Gandhi admitted himself while the other a century forward in the future. As Nehru presided over the proceedings of modernizing India after the independence, he sought modernization through planning and development, but he did accommodate the Gandhian features wherever possible. LLL. Indian planning, nature and role. Planning was taken up as an instrument of socio-economic change immediately after India attained independence. With Nehru as the prime minister together with his Western and Soviet leanings, he resolved to convert political democracy into socio-economic democracy. His Fabian base tended towards faster rate of growth through industrialization on one hand and planning on the other. Nehru was a Democrat, but he was not a communist. He was, indeed, impressed by the Soviet rate of growth, but he did not argue on the strength of Soviet style of control and command. He did urge for socialization, but only of major industries. His socialism was not Marxian but was what he described as the socialistic pattern of society. His type of economy was not completely capitalistic, privatized, nor was it socialized, social ownership of the means of production neither completely private nor completely public. Nehru went for mixed economy. India's mixed economy pattern was based on the coexistence of public sector units and private sector enterprises. Both sectors work within the framework of the invisible hand of the market and the visible hand of planning. Planning was rightly regarded as the solution to all problems of India after she gained independence. Solution to our backwardness, to our agricultural stagnation, to our poverty, to our rampant unemployment, to our illiteracy, to our ill health. The main objectives of planning, as stated in different plan documents, if one takes the total view, may be summed as I. To build the industrial infrastructure. 2. To expand and improve agricultural production. 2. To lay down the foundation of a self-reliant and self-generating national economy. 4. To increase and distribute national wealth. V. To promote social justice. 6. To remove unemployment and poverty. 7. To remove illiteracy and disease. 8. To promote trade and commerce. 9. To give incentives to entrepreneurs for export-oriented and import-substituting production. And X. To make the Indian economy modern, efficient and competitive. The Planning Commission and the National Development Council had been the highest planning bodies. The Planning Commission of India was set up in March 1950 as a result of a cabinet resolution. That is why the Planning Commission was rightly described as an extra-constitutional body, which, in theory, may be said to be an advisory committee of the cabinet. It was assigned 7 duties. I. To make an assessment of the material, capital, and human resources of the country. 2. To formulate a plan for the most effective and balanced utilization of the country's resources. 3. To determine national priorities of development and define the stages of growth and suggest allocation of resources. 4. To indicate factors tending to retard economic development and determine conditions necessary for the successful execution of the plan. V. To determine the nature of machinery required for the implementation of each stage of the plan. 6. To appraise periodically the progress achieved in the plan implementation and to recommend necessary adjustments of policy and measures. And 7. to make recommendations for its own effective working and regarding necessary changes in the prevailing economic conditions, current policies, measures, and development programs, or on problems referred to it for advice by the central or state governments. The Planning Commission was required to make recommendations to the Cabinet. It is expected to work in close understanding and consultation with ministries of the central government and state governments. Decisions for implementation are taken by the central and state governments. The federal system of India's polity presents certain problems of coordination between the center and states. The Constitution includes economic and social planning as entry 20 in the concurrent list of jurisdiction in the 7th schedule of the Constitution. Hence, after the Planning Commission prepares its draft for the 5-year plan, the states also formulate their 5-year plans and annual plans and coordinate them with the general plan. The highest deciding body structured on Planning Commission for planning has been the National Development Council, NDC, which used to meet under the chairmanship of the Prime Minister, and which included all the chief ministers of states and union territories, union cabinet ministers, especially those in charge of economic ministries, and members of the Planning Commission. The Secretary of the Planning Commission has been its secretary. The National Development Council discussed and, if necessary, modified the draft plan and approved it, after which it is sent to the Parliament for its final approval. The major thrust of India's planning has been to increase the country's national income and comprehensive development. Planning helped in establishing certain developmental priorities, emphasizing on heavy industry, light industry, agriculture, irrigation, and infrastructural services. Through planning, participation of people at all levels, down to the villages, came to be enlisted, resources mobilized, rules and regulations streamlined, trade, industrial and licensing policies had been formulated in such a way as helped industrialization to grow at a faster rate. Under the circumstances, mixed economy pattern was followed in the initial years of independence. Mixed economy meant the coexistence of public sector units and private sector enterprises. The industrial resolutions of 1948 and 1956 stated clearly that for planned development, all industries of basic and strategic importance and those in the nature of public utility sector and infrastructural industries were placed in the public sector while all other industries were entrusted to the private sector. In the mixed economy framework, private ownership of the means of production has been allowed. The private sector in India accounts for about 80% of the total national output. Industries such as cotton, textiles, jute, sugar, cement, vegetable oil, leather, cosmetics, automobiles, scooters, cycles, electronic goods, and appliances, etc. are in the private sector. Agriculture, the principal economic activity of 70% of the people, is also in the private sector. The ownership of agricultural land is entirely personal. Large business houses and monopolies have grown rapidly. There are about 75 big business houses, of which 20 are top houses. They control about 75% of the national wealth, GNP, as against 7% by the small sector of entrepreneurs. 20 top business houses had assets ranging from 436 rupees crores to 4,111.55 rupees crores in 1985. The top 3 in 1985, Birlas, Tatas, and J.K. Singhanias, jointly accounted for assets of approximately 9,000 rupees crores, 1/4 of the central plan budget. Most of those 20 big houses have increased their assets 6 to 8 times in about 20 years. 4. Role of public sector. Public sector units in a mixed economy have the exclusive responsibility for the development of public enterprises, which are used for developing heavy industries and infrastructural services. These include means of transport, trailways, shipping, airways, certain type of road transport services, communications post, telegraph and telecommunication, irrigation facilities, energy sources, coal, petroleum, natural gas, electric power, atomic energy, etc., iron and steel, minerals and metals, chemicals, fertilizers and pharmaceuticals, heavy engineering, machine building, etc. Investment in public sector grew from a modest 29 rupees crores covering just 5 enterprises in 1951 to 35,411 rupees crores covering 214 enterprises in 1984, at the end of the 6th plan, i.e. 1985. The growth of the public sector is one of the major contributions of the planning process. The Mahalanobis Plan Frame of March 1955, the second plan period, stated that the development of heavy industries was essential to strengthen the foundations of economic independence. Now, the public sector having reached what was intended, namely the commanding heights of the economy, and has become an engine of economic growth. Approximately 55% of the total investment in the last 3 decades of planning has been made in the public sector. Together with this, state-owned financial institutions, the nationalized banks and insurance companies, etc., have played a major role in mobilizing resources for investment in the development of many sectors. Despite the drawbacks of public sector enterprises, their role in the economy until late 1990s was significant. The public sector has helped India emerge as the most stable democratic polity in the third world with a massive industrial and increasing agricultural base. A great measure of self-sufficiency has been achieved in many sectors of the economy. For a country which produced practically nothing significant in the manufacturing sector at the time of independence and imported numerous commodities, the transformation to a self-reliant industrial economy in just 4 decades is really impressive. We now manufacture machinery for all major industries: locomotives, shipbuilding, automobiles, heavy and light vehicles, construction equipment, power generation and transmission units, chemicals, drugs, machine tools, precision instruments, whole range of domestic gadgets, and a wide variety of electronic goods and instruments. India has a self-reliant defense production as well. The most dramatic and far-reaching achievement is the build-up of the country's own industrial infrastructure. In the generation of power, India is the 5th largest in the world with 49,288 megawatts capacity in 1987. Coal production has increased from 35 million tons in 1951 to 154 million tons in 1986. Exploration of petroleum and natural gas and offshore drilling have produced remarkable results. 2/3 of our requirement of crude oil and its byproducts have been met by domestic production. Natural gas production is increasing fast. Indian railways are one of the most extensive transport networks in the world, covering 61,850 route km and carrying 90 million passengers a day. They serve the movement of goods and services and have become the arteries of industrialization. India is one of the biggest manufacturers of locomotives and rolling stock in the world. The network of roadways covering 1,770,000 kilometers has linked every nook and corner of the country. India manufactures its own trucks, vans, passenger buses, jeeps, cars, and a wide range of two-wheelers and world-famous scooters. Our shipyards manufacture almost all that is required, including merchant vessels, barges, dredgers, tugs, etc. India's aviation industry is one of the biggest in the third world. Indian Airlines carries passengers to 80 destinations and is expanding its network to 140 airports in different parts of the country. Integrated steel plants in the public sector provide the basic inputs for the plan development. An impressive range of engineering and machine tool goods are being made and exported. Electronics is growing at a rate of 40%. Urbanization is growing steadily. In 1901, India's urban population was 10.8% of the total. In 1951, it increased to 17.3%, and by 1981 it rose to 23.3%. There has been a phenomenal growth of towns and cities. Around the middle of the century, there were 19 major cities, 12 with a population of 4 to 10 million, 3 with 2 to 4 million, 5 with 1 to 2 million, in addition to 3,300 towns. Literacy rate has increased. In 1901, the percentage of literate people in India was as low as 5.35%. In 1951, it grew to 16.67%, and in 1981 it rose to 36.17%. States with high rates of literacy include Kerala with 69.17%, Maharashtra with 47.37%, Tamil Nadu with 45.78%, and Delhi with 61.06%. The labor force had increased to approximately 300 million in 1981, and the scientific and technical personnel to about 3 million. A phenomenal expansion of the middle classes has taken place, probably one of the largest and fastest growths in the world. We may sum up the defects of our public sector policy, which include: A. Centralized planning. B. Lopsided employment strategy. C. Excessive use of public sector undertakings. D. Agriculture overshadowed by industries. E. Faulty industrial policy. F. Politicization of the planning process. A planned development within the framework of a mixed economy has its own points of contradiction. The public sector, in the context of a capitalist mode of production, has not succeeded in promoting the prospect of distributive justice. It has provided, at public and state cost, the infrastructure of power, energy, coal, iron and steel, transportation and communications, etc. that facilitated the growth and expansion of a sprawling capitalized system in India. The public sector represents elements of state capitalism more as a cooperative rather than as a competitive segment of the private sector. There have been gaps between aspiration and achievement in Indian planning. Planned targets have been unrealistically high. The implementation machinery has been weak and inadequate. The bureaucracy and politicians have remained often uncommitted to the goal and purposes of planning. Corruption and inefficiency in the administration resulted in a neglect of projects and waste of resources. There has been inadequate use of irrigational facilities by farmers. The business community, concerned more with profit, could not develop the public spirit to help the plan implementation. Tremendous growth has taken place, but appalling poverty persists. This is evident from the fact that according to World Development Reports of the World Bank, India ranks 8th in overall industrial production, 7th in iron ore, 6th in coal and manganese, 4th in grains, 3rd in railways, and also 3rd in the number of scientific and technical personnel globally. But the other side of the picture is that the process of industrialization is still far behind the requisite level of development that could stabilize the base of a self-reliant and self-generating economy. While we are 15th in the world in terms of our GNP, we are 106th in terms of per capita income. That is, among the poorest countries in the world. In 1983, India's per capita income was as low as $260, which was less than 1/50th of the USA's per capita income. It is less than 1/30th of the average per capita income of developed countries. Of the 246 commercial enterprises established by the central government, see Bimal Jalan/India's economic policy, excluding public financial institutions, insurance companies and railways. There are 6 in the construction sector, 74 in services and 166 in manufacturing, involving a capital investment of 160,000 rupees crores, an astronomical figure, mostly contributed by the government but also borrowed by it at interest rates of 12 to 14% per annum. Jalan writes, the central government's total internal public debt in 1994 to 1995 was close to 500,000 rupees crores, of which nearly 1/3 was owed by assets held in the public interest. Interest payment on the public debt accounted for nearly 50,000 rupees crores a year. The situation, alarming as it is, indicates, as Jalan says, the colossal investment in the central public sector yields a net profit of only 4,000 rupees crores or 2.8% of the capital employed. A paltry 800 to 900 rupees crores of this comes back to the government by way of dividend. About half the enterprises make losses which have to be covered by fresh loans from the government or government banks. What this means is that the government has been accumulating additional public debt, a debt trap leading to more borrowing and higher interest obligations. The situation in states is worse. State governments have invested heavily in the public sector, with long-term debts reaching about 200,000 rupees crores and interest obligations, about 20,000 rupees crores. Such a situation was bound to trigger the need for a change in the economic policy. Slow economic development, growing technological backwardness, heavy government expenditure, and the like were other additional reasons seeking a change in the policy. Government's expenditure was more than its revenue. Loan was more than the capacity to pay the interest. At the beginning of 1990, we were not able to pay for our imports. There was a financial crisis, forcing us to borrow from international institutions such as the World Bank and the International Monetary Fund, IMF. The new economic policy, NEP, could alone help bring our economy back on track. The Green Revolution. The Green Revolution revolutionized the traditional method of food production by boosting productivity level to the tune of 250% or more. The Green Revolution, GR, was centered around the use of the high-yielding variety, HYV, of seeds developed by the German agroscientist Norman Borlaug, a British Rockefeller Foundation scholar in Mexico, in the early 1960s. The new wheat seeds which he developed in vivo, it was claimed, increased the productivity by more than 200%. By 1965, the seeds were successfully tested and were being used by farmers in food-deficient countries such as Mexico, Taiwan. Components of the Green Revolution. The Green Revolution was based on an adequate supply of many inputs/components. The components of the Green Revolution are as follows. The HYV seeds. They were popularly called the dwarf variety of seeds. With the help of repeated mutations, Mr. Borlaug was able to develop a seed which was biased in its nature of nutrients supplied to different parts of the wheat plant against the leaves and stems and in favor of the grain. This made the plant dwarf and the grain heavier, resulting into high yield. These seeds were non-photosynthetic, hence, non-dependent on sun rays for yields. 2. The chemical fertilizers. The seeds were to increase productivity provided they got sufficient nutrients from the land. The level of nutrients they required could not be supplied with the traditional composts because they have low concentration of nutrients and required bigger area. While sowing, it meant it will be shared by more than one seed. That is why a high concentration fertilizer was required which could be given to the targeted seed. The only option was the chemical fertilizers, the urea, N, the phosphate, P, and the potash, KK. 3. The irrigation. For controlled growth of crops and adequate dilution of fertilizers, a controlled means of water supply was required. It made 2 important compulsions. Firstly, the area of such crops should be at least free of flooding, and secondly, artificial water supply should be developed. 4. Chemical herbicides. Herbicides were used in sowing HYV seeds so that herbs and weeds in the fields did not consume costlier inputs and fertilizers. Green Revolution in India. As fields suitable for the new kind of farming were region-specific, Its application was confined in India to regions such as Haryana, Punjab, and western Uttar Pradesh. The Green Revolution program resulted in a substantial increase in the production of food grains, mainly wheat and rice. The Green Revolution in India had positive as well as negative results. These may be summed up as follows. A. As crop areas under high-yield varieties required more water, more fertilizers, more pesticides, fungicides, and certain other chemicals, there was a need for certain local manufacturing industries. That resulted in the creation of new jobs, and in the process, growth in the country's GDP. B. The increase in irrigation created a need for new dams to harness the monsoon water. That led to the generation of hydroelectric power, which, in the process, boosted industrial growth, generated jobs, and improved the quality of life in villages. C. With food sufficiency, India paid back loans taken from financial institutions. That resulted in the creditworthiness of the country in the eyes of lending agencies. D. Sociological results of the Green Revolution led to the creation of jobs in the agricultural and industrial sectors which, in due course, transformed India from a starving country to an exporter of food grains. The limitations of the Green Revolution were, however, no less alarming. Some of these were: 1. Even today, India's agricultural output sometimes falls short of demand. The Green Revolution, howsoever impressive, has not succeeded in making India totally and permanently self-sufficient in food. In 1979 and 1987, India faced severe drought conditions due to a poor monsoon. This raised questions about the long-term achievement of the Green Revolution. In 1998, India had to import onions and sugar. 2. India has failed to extend the concept of high-yield values. India has failed to